Hi, you guys. We have the seal of the state of Georgia, so I think we're about to go live in a minute here. Day 2 of motions. I thought it was day 102 of the YSL trial, so I'm going to go change my title because it's day 103. But how is everybody? And if you watched yesterday, what did you think of yesterday? So while I change my title here... Mia Moore says, throw this case out. Good morning. Hey, Factual Lie. Hey, JC. You were cutting it up on X. I saw you. Matthew, I think it's going to be wild today, too. With the transcript, you guys, yesterday, Judge Whitaker had asked, are there any other ex parte meetings that we're not sure that the other side knows about? And everyone, gave a few things, and, we just want to make sure that you know about this one. Well, one of them was June 7th, Friday, before the Monday ex parte meeting. And at the end of the day, Judge Whitaker says she has copies of a rough transcript for each of the defense counsels. So they hand those out, and we also find out that the defense counsel never got a copy of the motion for Kenneth Copeland's immunity order. So they've never seen the argument made for the obtaining of that immunity. So some interesting stuff. I didn't see any motions filed in relation to that, but I wonder if we'll hear some issues about that today. Now that they've become aware, they've been disclosed, hey, there's another ex parte meeting that took place on June 7th. Who knows? We got some wiggle over here. Good to see you. Hey, Jason Hodges. All right, we're wiggling right back to the seal, so maybe we're not starting. Yesterday, she started exactly on time. All right, and my title is now correct. It no longer says day 102. Good to see you, Drea. Hey, Daniel. Sherry, Diane, or maybe it's Dion. You know me and my pronunciations. If you phonetically put it in the chat, I'll get it right. Yeah. You said the ex parte question yesterday was like a Monty Python skit. No. Well, wait. And I'm interested, of course I want to see the transcript, but I really want to see what's in that motion for the immunity order. What was the reason they were giving? Because they're writing this to Fani, right? They got to write this to the district attorney. It's in the public interest. We need this to get this testimony for the greater good, safety of the public. He's afraid to testify. Was that one of the reasons they wrote in this motion? Can anything in that motion be contradicted? Did Fani Willis do anything to verify the grounds presented in that motion? Or did she just sign off on it as soon as she got it? Those are kind of big questions. Sapphire Ridge News, good to see you. I did see a comment yesterday that I know you started your channel, but you are getting some growth. So that's very exciting. I'm very happy to hear that for you. Lynn, good to see you. Too bad we can't hold out for a mistrial. I think she just wants this too bad, but she's making herself look so corrupt. Today will be the day. What I think is if she denies and the defense asks for certificate for immediate review, and then she denies that, that's really where my eyebrows will go off my head. They'll go all the way up. Mark, good to see you all the way from England. Thanks for becoming a member, Lynn, too, and Mahadi. But yeah, I don't know what we're going to start with today. I don't know. We had a lot of homework yesterday for all parties. The judge had a lot of homework. State had a lot of homework. Defense had some homework. But of course, I just want to see if the state is going to come prepared with everything they need. Here we go.
I trust you had a productive evening last night, and I understand that the parties have a proposal with regard to at least a portion of
Mr. Copeland's testimony? Sorry, I didn't have this turned on. So what I said was, I trust everybody had a productive evening, and I understand that there is a proposal with regard to at least a portion of Mr. Copeland's testimony, so I'll hear what that might be.
Good morning, Your Honor.
Morning.
Simone Hilton for the state of Georgia. Last evening, myself and Mr. Schardt had a brief conversation regarding the testimony of Mr. Copeland.
Yes.
I believe the defense counsel have to speak among themselves in order to determine what portions of Mr. Copeland's testimony they are asking to be kept. And so we believe that we need a copy of the transcript.
Okay.
So that they can have that conversation. Once defense counsel has that conversation, then they'll speak with the state about their proposals and we can move forward from there, Your Honor.
All right, so I don't believe that I think we have the 7th available. I don't know that we have the 11th and 12th yet, but I think we've reached out this morning to Ms. Weaver, the court reporter, and I know she has some other people working with her as well, so we'll endeavor to get that to y'all as soon as possible. And she's been pretty fast with the turnaround, so we may even have parts of it by the end of the day. So that seems like a reasonable approach. And then I would think that the next thing we can do, to the extent y'all feel like you want to revisit evidentiary issues with regard to any of the videos, or I don't think you had gotten to the jail calls yet anyway, but with regard to the videos, we can probably do that now. Do y'all think? Otherwise, give me something else we can do this morning.
Yes, we can do that. If you can, we just need the
This
we
microphone.
just need to get that material very quickly to the office. I mean, to the courtroom. Your Honor. But we can do that.
All right, send somebody to go do that, please. And has anybody thought through yet, and maybe we'll have ready soon, any kind of potential instructions for what we're going to be telling the jury about either Mr. Copeland's testimony, well, I guess generally Mr. Copeland's testimony. And then I'll entertain what we're going to, I am going to say about the fact that here I am instead of Judge Glanville. But I mean, for that, I'm thinking essentially just, I don't know, some matter has required a substitution of judges, and that's about it. I don't plan to tell them really much more than that. They don't need to know why.
Your Honor, given the conversation Ms. Hilton had with the defense last night, in that some of them may be seeking to have some portions of it kept, depending on the court's decisions regarding our respective positions, I don't think we can craft at this point. For instance, if we decided, everybody said, let's just keep it, then we would just keep it, understanding that's likely not going to be the case until we know the respective positions and the court's ruling on that. I don't think we could endeavor to craft it.
Yeah, that may be true. Okay. Yes, sir.
Good morning, Your Honor.
Good morning.
Good morning to everyone. Your Honor, I wouldn't, and Mr. Adams can opt out of this if he believes it, but I'm objecting to anything except the unvarnished truth about Judge Glanville. I would like the court to tell the jurors the truth, that he has been found to be disqualified and removed from this case for his conduct. And that's my instruction that I worked on. That's what I'd like you to do.
All right, well, I'll consider everything once I've got everybody's proposed instruction, to the extent anybody wants to provide one for me to think about.
I want to read it.
Thank you.
And Your Honor, I believe that the statute, if I'm not mistaken, regarding recusal specifically speaks to the fact that that is not to be made a portion of the case in chief, of the main case. I'll get the exact language that I'm speaking of.
All right, great, thank you, I appreciate that.
Case in chief, you guys.
Okay, anything else?
Yes, Your Honor. We also briefly discussed yesterday the exhibit list, talking about how we can resolve working through the exhibit list. And my understanding from Mr. Schardt, I'm not sure if Mr. Kokomo was finished yet, but Mr. Kokomo, who's his legal assistant, and another legal assistant, we're actually working through the same thing that our legal assistant is working through. And our hope is, hopefully the court will be okay with this. By next Wednesday, our legal assistant would have gone through every video to assure we have all of the correct exhibits. But it's taking time because she's literally watching every single time we're in court.
I'm not okay with waiting until next
They didn't
Wednesday.
do this already?
I mean, I'm hoping, and it may be a false hope, but I'm hoping that we'll have a jury back with us by next Wednesday. So that needs to accelerate.
Okay, we will work on accelerating that list to get it to the court. But I believe that they're working on it as well.
Well, they need to accelerate as well if their thought was next Wednesday. I mean, like, I'm thinking
That's
this Friday.
insane.
Okay, which is the day after tomorrow. All right, with regard to, and you're talking about the videos of his testimony, right? Or are you talking about?
No, I'm
The
sorry, I should have been
discrepancies?
clear. To confirm what exhibits have been admitted and not admitted. That's what we've been working on. No, that's
The giant list of?
the giant list of
Okay,
exhibits.
yeah, that's fine. That can be next Wednesday. That's not that urgent. As long as we've got that correct by the end of the trial, that's all that really matters
Yes, Your
for
Honor.
that. I
And
thought you meant Mr. Copeland's testimony.
No,
Me
no,
too.
no,
Okay,
Your
all
Honor,
right,
no.
my misunderstanding then. Okay.
Thank you so much, Mahadi. Catnip.
All right, so with regard to the video interviews of Mr. Copeland, I suspect there are parts of those that the state knows they intend to be using or suspects very strongly they probably need to be using. So can we either come to some form of an agreement about evidentiary rulings that were already made, and or let's figure out what I need to do again?
Yes, Your Honor. I believe after we had the initial arguments regarding some of the redactions, some of the redactions we did concede on. So once I get that list, I can let the.
Well, I've already seen those with regard to a couple of things, but I haven't gone through. I mean, I was looking at, for the transcripts I had, the arguments that y'all had already presented, and I saw that there were maybe like a couple, I don't know which, I can't remember right offhand which dates I've already looked at, but there didn't seem to be that many that y'all just conceded. Seemed like y'all argued and needed a ruling for most things. But what I'm saying is, having argued it once and having gotten a ruling from a judge who knows what he's doing, whether y'all like him right now or not, do I need to re-listen to each argument and make my own determination? Or can y'all agree that, hey, you know, the law, regardless of us arguing our various sides, the law probably is this, and we're okay with that ruling?
We believe
That's
out of them, we believe, and I'm sorry, Your Honor.
Go ahead.
Out of them, we believe that there might only be two that we think may need to be re-argued.
Okay.
I just want to, we don't think there's many, at least from the state's perspective.
All right, that's good.
Your Honor, I'm speaking for myself. Yesterday, we received a transcript that was
Here we
a
go.
transcript of an
Here we
ex
go.
parte meeting that occurred on Friday.
Right, this is the
Before
one.
the Monday.
Sorry, just so that we're clear for the record purposes. This is the transcript I gave y'all at the end of yesterday that reflects Ms. Love had said, oh, yeah, we had, and in court on the record, but ex parte discussion that led to the Monday, June 10th ex parte. So that's what you're talking about?
Let me be more artful, yes.
Okay.
We were made aware, leading to the recusal of Judge Glanville, that there was an ex parte meeting that occurred on June 10th, Monday, June 10th. We We're not told by the state, we're not told by the judge that that had occurred. We found out about it, luckily, and by happenstance. We then demanded a transcript. We complained about said ex parte, inappropriate ex parte meeting. At no point, when the court finally acknowledged that there was an ex parte meeting that occurred on Monday, June 10th, at no point did the court or the state at that point acknowledge, oh, by the way, there was another ex parte meeting that occurred on June 7th.
We find that out yesterday.
We sat there after finding out about one ex parte meeting and having to drag the truth out. We sat there and the state and their co-conspirator, the trial court, were silent about the first ex parte meeting that happened on June 7th. What happened in that meeting on June 7th? The state went in and disparaged defense counsel. The state, with no one else there, trashed a fellow member of the bar, Mr. Melnick, trashed another fellow member of the bar, Kayla Bumpus, presumed the guilt of all these individuals, including my client, Shannon Stillwell, and all but accused myself and Mr. Steele of being co-conspirators in this YSL enterprise. And the judge agreed. And the judge said in this ex parte meeting, yes, I've observed these things. The judge presumed the guilt of all the defendants. The judge presumed the guilt of myself and co-counsel, Mr. Steele. And all this, people have been saying to me throughout this whole trial, why does Judge Glanville have it out for you? And it never made sense. And I don't assume bad motives of anyone. Why did Judge Glanville, when you did nothing wrong, try to throw you in jail? Accuse you of cussing him out in open court when you didn't do anything? Why does he always tell you, yell at you, tell you to sit down and be quiet? Why does he cut you off at every opportunity? Why did he try to throw Brian Steele in jail for 20 days for doing what was right?
Look at love.
And I didn't have an answer. And then yesterday I received, and I appreciate that, Judge. I appreciate someone finally being open about what's going on here. And I received a transcript. And in that transcript, the trial judge, who's not only assuming the guilt of my client, but is assuming the guilt of me and my friend, Mr. Steele. This is gross. This is disgusting. But it's all starting to make sense. It clicked when I read that transcript last night. This is not okay. Nothing about this is okay. These gentlemen have a right to a fair and impartial judge. And I appreciate the fact that you are going to be a fair and impartial judge. But the reality, Judge, is that they don't have a right to a fair and impartial judge starting on witness 76 of a trial after 9 months or whatever it is. They have the right to a fair and impartial judge from the beginning. And this is absolutely gross and disgusting. And the bottom line is there's a lot more discussions that need to be had about this. But the bottom line is, if you ask me, do we need to revisit the rulings of the judge who sits in chambers secretly and talks to the other side and says, yes, I've been observing this. I've been observing this about what's going on in trial. The judge that says, not only I'm going to meet with you on Friday and on Monday, but if we need to talk during the weekend, yeah, we can do that. The judge that suggests handing Mr. Copeland a list of questions. Do we need to revisit those rulings? Absolutely, we need to revisit those rulings. We need to revisit everything. This is broken, and it's not okay. It's not okay. It's offensive, and it's not your fault, Judge. You didn't do this. I'm not trying to raise my voice at you. I'm heated right now.
I can tell.
My steam's been coming off my bald head all night. Nothing about this is okay. Yes, we need to revisit everything. That's my stance.
Okay, thank you. And I think that I understand you being upset, and I understand why you and probably some of your fellow defense counsel on this side of the room are upset. I do not think that everything you said is a fair characterization of what that
You don't
June
know the
7th
context.
transcript reflects. But once we have the official copy, that'll be made a part of the record, and that will show what actually happened, what actually was said. As to any kind of legal error that may have been made with regard to rulings prior to Mr. Copeland's testimony, assuming this case goes forward and assuming there is any kind of conviction, I then assumed that there will be a motion for new trial phase, which at that point I can appropriately revisit things, and then potentially an appeal, at which point those things can be raised. I am
In 2 years.
considering and reading what y'all gave me yesterday to make a ruling on the substantive matters of that ex parte, and I can consider the June 7th ex parte as well, because I suspect y'all asked me to do that. And if I determine that that is such, that there was coercion that is unconstitutional or structural error, then I will grant a mistrial. If not, then the case will move forward and we can consider again all of the evidentiary rulings with regard to the videos and audios that might be used with Mr. Copeland, because that's the witness that we are on the stand with right now. I would, and I know this is hard to do, but I would like for everybody to try to take some deep breaths and move forward professionally. A lot of what y'all are talking about doesn't make it any easier, but it happened a month ago. I know tempers flared all around, but we need to move forward with this in whatever way it's going to move forward in a calm and professional manner, okay? So then with regard to what we need to do evidentially, I guess I will need to hear from the state as to what y'all think it's very likely for you to be using while you're examining Mr. Copeland, and then I will entertain evidentiary objections, responses, and we'll consider what's coming in.
Thank you, Your Honor. And we're getting that ready as we speak to present to the court. And I'd also like to thank Your Honor for the reminder regarding professionalism. I was going to ask that the court require that we all adhere to that.
You didn't like
being
that
called
yesterday.
co-conspirators is not something that I would expect to have heard, no more than I would expect to level a assertion that Mr. Schardt is a defendant. So I'd ask that that all sides be required to adhere to the court's admonition.
Okay, well, again, the transcript will reflect what was actually said in there, and there are some allegations that if I were an attorney and it were leveled against me, I mean, I am an attorney, but you know what I mean, practicing in a case, I would be a little hot under the collar as well. Y'all had potentially legitimate concerns. I don't honestly at this point right now need to rehash all of that. But the reminder is to everybody, okay? And I mean, I've said it, so let's act accordingly.
That was
Yes,
pretty
sir.
good.
If I can address the court briefly.
Yeah,
I filed
Doug.
a supplement to the Mr. Kendrick's
Oh.
motion for a mistrial this morning. I
I'll
just want to
look.
make sure the court's aware of it.
I am aware of it. I have not yet had a chance to look at it, but that's, got it.
Thank you, Your Honor. Mostly I want to make sure I bring it to the court's attention because again, and I've followed the request of the court to not argue what's already in the papers, but I just want to make sure that the court understands that based on this additional information that we learned about the July 7th meeting, that my client has been consistently denied his right to a fair tribunal. It's been a due process violation. I, like Mr. Schardt, am extremely upset having read that transcript. Myself and my fellow outside agitators over here, I assume that they are upset as well. And
I don't think, honestly, I don't think that reference was to anybody who is a member of the bar. I think that there have been times in this case where members of the public are in the courtroom, which they are, of course, entitled to be, but communicating in ways that are not appropriate.
well, you know, the problem, Your Honor, is that since this was an ex parte meeting that should probably have never taken place, you were not there, I was not there, my fellow outside agitators weren't there, we don't have a video of it, so I have no idea specifically if that was not referred to us. We don't know, do we? We don't know. And what I do know is that I have been arguing with people for 18 months that Chief Judge Glanville was doing his best, that he was trying to rule to the best of his ability based on the evidence and the law before him, and now I have been made to look like an idiot. So
well,
I do not believe that this trial should continue, Your Honor.
I understand. Thank you. I'll take your supplement under consideration. Like I say, I haven't, obviously you just filed it and I haven't had a chance to look at it yet, but I will consider that in the overall context of the motion I was already considering. And, you know, I don't know that everybody's not going to want to come up here and do their 5 minutes of how outraged they are. Yeah, if y'all feel like you need to get it off your chest, come on. Now's the time.
Okay, I got one more thing to say to you. And then I'll sit down.
Okay.
And I don't believe that this is performative outrage, Your Honor.
I mean, I don't either.
Okay.
I don't either. I already said I understand.
In July of 2023, after months of me complaining about late discovery from the state, which should have been produced in December of 2022, when another terabyte or so tranche of discovery was produced to us, I begged Chief Judge Glanville to put a hard deadline on the discovery being produced from the state. He refused to do so. And you know what Judge Glanville's response to me was when I will tell you. I will tell you what his response was. If this was a civil trial, I would keep this out. But since this is a criminal trial, it's coming in. If this was a civil trial, if it was about money, I would keep it out. But since it's only about Mr. Kendrick's life, that last part obviously wasn't in there. But if this is a civil trial, I would keep it out. I've been a civil litigator for 25 years. I agree that if it was a civil trial, it would be kept out. What I'm shocked by, and I'm new to criminal, what I'm shocked by is that the standard would not be higher in a criminal trial. But what did I say to people? Chief Judge Glanville is doing his best. He is doing his best. And now, again, I don't even know what to say to my client, Your Honor.
All right. Well, you know.
Transcript looks a bit crazy, you guys. We're going to look at it on break.
I don't know. Obviously, I don't know what to say right now either. But I think that, while again, I understand frustration, you know, let's be careful about disparaging a respected judge. I do think that he has, and I haven't looked at every transcript yet because they haven't all been produced yet, but I don't think you're wrong that he has been trying his best and doing his best. And, you know, we all as lawyers know that everybody talks about lawyers trying to herd cats, and that's not inaccurate. This is a big case. There are a lot of good litigators on this case, but with a lot of good litigators probably comes a lot of egos as well. And I think sometimes it is possible to sort of get so enamored of your position and of winning a point that you are focused more on that than on backing down and taking a breath and being amenable to hear what the other side is saying. And hell, that's true in our whole society right now. Should have said hell, but y'all, I mean,
You're
all right.
those were not my words. Those were Chief Judge Lando's words. If this was a civil trial.
Well, I don't know why it was. I don't know what evidence you were talking about. I'm sure there have been evidentiary rulings that have been frustrating to both sides. I will look at the two transcripts and I will make a ruling. And again, I don't think that the characterizations are exactly accurate, but I'll consider it all in context and I'll make a ruling.
Thank you.
All right. Anybody else, or can we move on to evidence? Mr. Steele.
Of course. Here we go.
So there are 16, and good morning again.
Good morning.
Good morning, Madam Court Reporter. Ms. Winfrey, there are 16 hours approximately of the video audio you're talking about.
Okay.
And yes, we were going through to dissect objections, but I, and among others, really had an overall objection because the witness testimony, which is before the afternoon of June 12th of 2024, he agreed that he said these prior statements. So over objection, and the way I understand the law, the state shouldn't have been able to put it in at all. So I understand what you're doing. You know,
Okay.
we're going with you, but I just want you to know that we're not conceding that the way it came out, and obviously it's going to be redone after, I believe, I heard what you said yesterday, I agree, but that's the law. I don't believe that it should come in at all. So before you tell us later, hey, why'd you make me do that?
No, I understand. And I think that Mr. Schardt had actually put that particular objection in writing in one of your filings anyway, essentially that to the extent that Mr. Copeland said, yes, I said every one of those things to police officers, but every one of them was a lie. That is an admission that he made the statements. And the defense position, as I understand it, is as long as he acknowledges the statement, then nothing else is a prior inconsistent statement. And I'll hear from the state with regard to that, but.
I had one thing. Just another layer of that. Oh, I'm sorry.
Go ahead.
Just another layer of that is that the issue, the subject matter of these statements is largely the alleged co-conspirator statements, that our stance is that those were not in furtherance of conspiracy either. So
Okay.
there's like two layers
Sure.
of analysis.
Okay, thank you.
I'm sorry for interrupting.
You asked, I let you. But anyway, with regard to, does that make something said that is inconsistent in a prior inconsistent statement? And the state can provide me the law on that. But I think there are times when either an I don't remember or an I don't know or a, well, that was a lie, can still form the basis of making something a prior inconsistent statement. So, but
And Your Honor, I'm going to let Ms. Hilton speak specifically as to the law on factually what Mr. Copeland did say. What he said was, I don't remember anything that I told the police. I keep telling you, I don't remember anything. But if they say I said it, then I said it.
yeah, I think what they're talking about is he also at certain points said, yeah, I absolutely said that and it was a flat out lie, and I'm paraphrasing, but
Okay.
that is what they're talking about, correct?
If that's what they're talking about.
Is that what y'all are talking about, Mr. Schardt, Mr. Steele?
Yes, Your Honor.
Yeah, so that's what I would like for y'all to address.
Your Honor, we believe based on two positions, OCGA 24-6-621, which be impeachment by contradiction, as well as a prior
Not this
inconsistent
again.
statement in both that statement, I said all that I said, but it was a lie, or I was trying to finesse my way out of being locked up, would lay the grounds of still allowing the prior inconsistent statement to come in.
Okay, and 24-6-621 is the
Impeachment
by
by-
contradiction, and 24-6-613 is essentially prior statements, right?
Yes, Your Honor.
So what I'd like is some case law that represents the proposition that you are asserting, okay?
And remember,
Yes,
they've
Your Honor.
argued this for hours
And
before.
I don't want it just simply quoted out of a horn book. I would like the actual case law.
Your Honor, if you can give us a moment, just because
Okay.
we need to.
I mean, y'all, when I told you a week and a
Be
half
prepared.
ago that I wanted to be going through Mr. Copeland's evidence, y'all had 10 days or more to get ready for this. So I don't know what y'all thought we were going to be doing, but yes, I'd like to hear it. So if you need a minute to get me the law, go ahead.
Put a 1 if you remember Glanville trying to give them the case law when they argued this last time. Put a 1.
Is there, we can also do this portion after lunch and do something else right now, because I don't know that we all need to sit in court and do our research.
Oh, we can read the transcript. Take a break.
What
we can
else
read the
can we do
transcript.
that's productive?
Take a break.
Your Honor,
Yes.
I would like to make records. The Honorable Attorney John Melnick is under subpoena. He's in your courthouse, to my knowledge, or to my belief.
Okay.
Oh,
If your court thinks that's good use of time.
They're calling
he
Melnick.
is going to, I believe, take to task the statements of Lawyer Love.
All right. Well, tell me why that matters, because what may have been the actual truth and what Miss Love
that's why you need
and or
him
Miss
for the
Hilton
truth.
perceived and therefore caused them to want to speak to the court ex parte or not, don't really have to be the same thing. And I don't know that it matters whether what they thought was true was actually true.
So objectively, he will go through the emails for the court that were misrepresented by Lawyer Love. He will then, I'm making a record, God forbid there's an appeal as well as for your consideration in this case going forward about calling Judge Glanville as a witness, that he spoke with Lawyer Love. She knew that he represented Mr. Copeland. Lawyer Love said that she did not know that he had denied representing him, Mr. Copeland.
That Mr. Copeland had denied that Mr. Melnick represented him.
No, Lawyer Love stated that John Melnick had previously denied representing Mr. Copeland to Judge Glanville.
Yep, that's right.
And that goes to the heart of why is there a ex parte meeting in the first place? Because I don't know why there was, but Judge Krause I've objected to it. And I know you said maybe not, it's dicta, and I agree that it did not go to the holding or the ruling. And she didn't make long statements of fact or findings of fact. So I appreciate you saying, I don't know if these are findings of fact, but maybe just surplusage. But
Yeah,
if
Cash
that
is talking
meeting
about
is
the
the way Judge
transcript.
Krause found, and there is a honorable Superior Court judge who made that ruling that's cemented in our case, that, I forget the line, but something like it was, maybe it should have been done in open court, but the substance may have been proper, something to that effect. If it was done in open court, I would have been able to be there to question Mr. Copeland. I would have been able to be, because the Judge Glanville said, do you want to be, you have questions for your lawyer, the state, or me? If I was there, I assume he would have said, or Mr. Steele. And then people were asking him questions.
They were discussing his testimony. Those are things that we had a material right to be present for. So the point I'm trying to make.
Okay, well, I'm going to make a substantive ruling with regard to that, and I don't know how Mr. Melnick is going to add to that. I mean, it is clear to me from reading that June 7th transcript that the questions they had about whether Mr. Melnick represented Mr. Copeland were not, is he literally counsel for Mr. Copeland right now? I mean, they knew he was that because Ms. Hilton said when Mr. Copeland asked to talk to Ms. Hilton outside of the courtroom, and they were about to talk, Mr. Melnick either was there or appeared, and Ms. Hilton said, oh, you seem to want to talk to him, so I will let y'all talk privately, which if she didn't think Mr. Melnick were representing Mr. Copeland, wouldn't have done. I mean, there would have been no reason for her to do that. I think that it is clear in context that what they meant by we've got questions about whether he's representing Mr. Copeland is, and they said it, we have questions about whether he is representing Mr. Copeland's best interests, which as a lawyer, you are always supposed to do for your client. So I don't think they meant literally has he entered an appearance for Mr. Copeland, or has he represented to us and to the outside world that he is counsel for Mr. Copeland? It was, is he really acting in the best interest of Mr. Copeland? That's what they said they wanted to research and then meet with, or potentially meet with Judge Glanville about.
Yeah, do you think the state
lawyer
cares?
said John Melnick, the Honorable John Melnick, stated that he was not representing Mr. Copeland. And Mr. Melnick said that is just a flat out misrepresentation of conversation.
Okay, well.
So I just want to get the record straight because Georgia law, and I gave you these cases in a footnote. Georgia law right now, and I know I'm very familiar with this Honorable Court's very in-depth knowledge of the law. So right now, it's if the court finds, this court finds, or an appellate court, that Mr. Williams et al. Had a right to be present, that's at a critical stage of proceeding. It's over. The case, no one looks at prejudice. But the two cases that came out in April, one of them had been in January, but I cited them in the footnote of my motion to just educate
Okay,
the court.
well, if it's there,
I could give it to him, but yes, it's
that's
there.
fine, I'll jot it down.
But the Georgia courts are saying that is the law now, but we are interested in whether that is wrong,
Okay,
and we need to show prejudice,
okay. With regard to,
like federal.
give me the cases in what?
Step back.
Okay,
But so I want to make a record of showing it was prejudicial because there were knowing misrepresentations to even have a auspices of a meeting with the judge.
okay, well,
And I'm not agreeing.
I'm not sure if I follow you though, with regard to, I need to establish that Mr. Melnick was in fact counsel for Mr. Copeland, because even in the June 10th ex parte meeting, Ms. Bumpus was there as stand-in counsel for Mr. Melnick, because apparently Mr. Melnick had said he had a pre-scheduled vacation or something like that, which everybody knew about on Friday or before Friday. And they were saying, you know, how can he actually be representing him, i.e. the best interest, if he's off on vacation when this critically important thing for Mr. Copeland
What about
is going
Hilton
on.
leaving?
But here's his standing counsel, Ms. Bumpus. So they understood that technically, at least, Mr. Melnick was representing Mr. Copeland. So, I mean, that's, I can take judicial notice of that to the extent I need to.
I'm inarticulate then because Mr. Melnick, I believe, is going to have testimony before your court for you to judge credibility.
Okay.
That what was said out of the mouth of the two prosecutors, Hilton and Love, are not true. There's no emails to back up what Love says. Ms. Hilton, there is not this Mr. Copeland, I need to speak with the DA. Those things have been unrebutted. They're just being said. And my point is, without that, then why are you questioning another lawyer's
ethical duties. What gives you the right to say that to the judge? And then the courts need to know that's not true.
All right, just like I said to the state essentially yesterday with regard to their motion that suggested that defense attorneys were violating bar rules in the way that they talk to the press, I am going to suggest to the defense that if the state is violating bar rule, or attorneys for the state are violating bar rules in the way that they talk about defense attorneys or in representations that they make to the court, that too is something that they may have to deal with the state bar.
I understand, but I'm dealing with, my concern is Mr. Williams. So I'd like you to make findings, because I think that they go to the heart of.
We want findings,
You're
not indicta.
entitled to ethical prosecutors. We demand that. Ethical lawyers, ethical prosecutors, and a fair tribunal. That's constitutional, as a fair tribunal. That did not happen here in my advocacy, in my viewpoint, the way I understand what happened. I wasn't there. So I can't talk about, I wasn't in the outside the courtroom when this supposed Mr. Copeland wants to talk with Ms. Hilton. I don't know. All I know is what, we do. We come in after the fact and we investigate. But I'd like to spread that on the minutes. So I raised that. I don't know, Mr. Melnick's day-to-day or.
I don't know that.
But I'd like to call him.
I understand, and I don't know that that is ultimately relevant to the determinations I have to make, because again, whether what the prosecutors represented to Judge Glanville was true or not, maybe an issue for another type of tribunal. But
Wink,
in
wink.
terms of whether it was then appropriate for Judge Glanville to okay the June 10th meeting to further flesh that out is what I need to figure out, right? So it doesn't really matter whether what they said was true for that purpose. It is, they told Judge Glanville what they told Judge Glanville. Was it reasonable at that point for Judge Glanville to entertain the ex parte on Monday, the 10th?
Okay.
Okay. So let me make that determination.
I'd like to call him if you change your ruling. Both of them. Judge Glanville.
You can proffer what he would testify to.
Then I need to, because he
You're
didn't
gonna
see this
proffer.
new transcript, so I need to, he being Mr. Melnick.
Well, what's
didn't
in the
even see it?
transcript shouldn't influence what's true. So
I would think, no, it doesn't. I would think that he can then say, or tell me and I'll tell you, and then you can hear from him if you want, that did not happen or this. I want to get it right.
all right, so you haven't talked to him yet about what? All right, well, obviously
This is
I'll give you a
crazy.
chance to talk to him before you make a proffer because you need the proffer to be accurate.
Okay,
All right, so that's not something we can do right now either.
okay. Thank you.
All right. So what can we do? And if there's nothing, then I'll just go back in chambers and I'll read all my cases that y'all gave me yesterday and I'll make some rulings so I can still be productive and y'all can be productive out here. You want to break for an hour and a half?
Yes, Your Honor.
Okay.
Thank you, Your Honor.
All right, let's come back at 11.
We have a small break, so
I
wanted to say- is
Doesn't
she
matter to
interrupting?
me.
Okay, we're off. Okay, I'm gonna keep the screen.
Ladies, so if that's fine, that's fine, but I'm not going to ask them to stay here. They've got a lot of other work to do too. Okay.
Okay. Until 11 a.m. Okay, so we got like a couple super chats. We're gonna read this transcript, you guys. Yeah, so we have about an hour and a half. So we will get through. We'll start with the transcript because that's probably what everyone wants to see, and then we'll read the supplement. So we've got that. I do want to say thank you again to Sapphire Ridge News for sending in the super sticker. That was so nice. I'd put it up on the screen, but I didn't want to talk over the stream. Garrett S. had said June 7th and the 10th. The state likes the ex parte like it's 1999. Add that to our vocabulary of language from this trial, along with comfort and convenience break. Carson for $4.99, thank you so much, says, state has been given so many softballs during the entire trial. They are falling apart now that they have to do some actual work. I can't believe that they still can't make this argument about getting this evidence in through impeachment by contradiction. We heard them get demolished in court the first time they tried to argue this in front of Glanville, who's nice to them and tries to help them. That it wasn't impeachment through like inconsistent prior statements. And they kept confusing the two. And Judge Glanville ended up looking at case law to try to nudge them and help them. And you guys dropped the ones in the chat saying you remember that. But Carson, you've got it absolutely right. Like, they're not used to it. And they should have been prepared to make this argument because it involves a critical part of their case. The Copeland testimony, the videos, the police interviews. And then EDW Raptor, I got to thank you in the chat, but thank you so much for giving gifted memberships. Super, super nice of you. And I saw some people saying thank you. If you got a gifted membership, you guys, make sure you say thanks. You've got a nice green name, and now you can use Mario Kart emojis, member emojis. So have fun with that. We are going to look at this transcript, though, you guys. I think it was 12 pages. And to be clear, we'll find out when we read the whole motion. Because I'm sure, depending on how Doug references it, he might say it's an unofficial copy, because I didn't see an official copy filed. So this might be the rough version that they handed out yesterday. I don't know. So I don't want to say something wrong. But this took place at 2:45 p.m., it looks like, on June 7th. So they got right out of court, got right into this meeting. And by the way, the leak was not Kayla. It was not Melnick. According to Kayla yesterday, it was Deputy Brown, who was listed as being present on the June 10th ex parte meeting. So that is the reason Steele found out about the June 10th ex parte. If you missed that update, that's something I caught yesterday on Kayla's live. But what happened on June 7th? Miss Love. So this is Miss Love talking. Judge, the reason that I specifically wanted to talk to you is that I have a concern about the representation being made of the representation of Mr. Copeland. I am concerned, and I am sort of not. I wanted to just bring it to the court's attention. Mr. Melnick has not conveyed to either Ms. Hilton, myself, or any member of the state any legitimate concern that he has regarding Kenneth Copeland testifying. So what does this mean? Holy crap. I gotta be careful about my words. They don't think he's in fear. This is them saying we don't think that Kenneth Copeland is in fear. That he's scared of anything. This isn't good for the state. What we have seen is physical interactions with persons besides Mr. Copeland, that would indicate that Mr. Copeland is not Mr. Melnick's primary priority. What we do know is that the fact that he's willing and wanting to leave, number one. He left twice after the court ordered him to speak with his client. And it would seem his actions convey that it is not Mr. Copeland's best interest that is his priority. Ms. Hilton was out speaking with Mr. Copeland at Mr. Copeland's request at the time that I announced that Ms. Hilton was calling Mr. Copeland. What I did not know is that she was trying to tell you to give us a minute because Mr. Copeland was feverishly, and I will let her speak as to how that went down, feverishly trying to get her in there to convey to her something that Mr. Melnick had just said to him that did not come from any of us. Yeah, so we just heard Steele saying, I want to at least, or Whitaker says you can at least proffer what you want Melnick to be able to come and testify about. Steele says Melnick hasn't seen this part of the transcript yet, day June 7th. And look at how much this would involve Mr. Melnick's knowledge. It seems necessary to me. So, and what was that, Miss Hilton? So the judge is asking Hilton, what was that Mr. Melnick had just said to him, as in Mr. Copeland, that didn't come from any of us? Miss Hilton says, so let me just put the order of operation. I got up because Deputy Chief Long said, he wants to talk to you. Come out right now. So when I went into the room, Melnick either came in or said, and I think that he wanted to get some autonomy. I want to talk to you. He's like, I've already talked to you, but I want to talk to her. And Mr. Melnick kept blocking him being able to talk to me. So eventually I was like, well, clearly you want to talk to him, so I'll step out and you can come in. Mr. Melnick spoke to him, and I think he was trying to eat up time because he knew that you were coming out. So by the time I got in there and started to talk, that is when everyone said, come on, the judge is waiting. and that's why he stormed in angry. Miss Love, he being Mr. Copeland. Miss Hilton, because I think he was trying to convey to me some concerns he had. And so I was trying to have that conversation because Mr. Copeland and I have been having really good conversations since Friday. Remember when she couldn't... Wasn't she wishy-washy saying it was only like Monday and Wednesday? And didn't Woody correct and say it's since last Friday? But here she's saying she's aware on Friday that she's been having conversations since last Friday. Like very, very good conversations. Just not even about the facts of the case, but just life experiences. You getting played. So I think I was building a rapport with him that he thought I lied to him, so I was trying to explain to him. Miss Love, and by that she means today. Miss Hilton, today, about what was going to happen. Miss Love, because of what someone conveyed to him. Miss Hilton, we believe that something was being conveyed. What happened is, as Mr. Copeland was walking back into the courtroom, Mr. Melnick, and Julie would have to, Miss Lancequote would have to confirm this, but he said, they are going to hammer you. And that made me ask Miss Love, did you say something about hammering him? And I don't know who, Miss Love, nobody did. The court, it doesn't make sense you would say that to him. Miss Love, we never said that. The court, but anyways, okay. Miss Hilton, so whatever that communication was, that's when he stormed in and got angry, and the result I got was what he gave when we started. So at this point, I'm very concerned. Miss Love, he meaning Mr. Copeland stormed in and got angry. Miss Hilton, the timing of everything is very ironic. We laid it out on the record earlier about what happened, and I don't believe that Mr. Copeland's best interest is being served at this moment, given that, Mr. Melnick was willing to take a vacation and let him languish in jail, and that is not, we have communicated that we never wanted Mr. Copeland to go to jail. But you wanted him to go until all the defendants are tried. This is insane. We don't want him in custody. You didn't have to hold... You could have just waited to testify until Monday, like all the other delays Judge Glanville called for trials that got us through to day 100 with like maybe 60 actual days of court days. We don't want any of that to occur, and so Miss Love, and Mr. Melnick has not spoken, he has not relayed. What we did get during the break was an email from Mr. Melnick. I don't know if he had to have been blind copying someone else. The only two people I could see on the email were Miss Hilton and myself, but he referred to me in the third person and said, these are the communications between myself and Miss Love. So I asked Mr. Melnick, whose interests are you concerned about, your clients or Mr. Steele's and Mr. Schardt's? And we saw these emails attached in, was it Brian Steele's motion? One of them. Because prior to, and this is not the first time Mr. Copeland, and the reason it was important that we saw this was because this isn't true. You can see who it was sent to and who was CC'd. So she either just doesn't know how to use email or look at them, or she's being disingenuous, or she's flat out lying. So because prior to, and this is not the first time Mr. Copeland has said, he doesn't represent me. This is not the first time Mr. Melnick has, and let me be clear. When he spoke of what was happening before, him representing Mr. Copeland and da-da-da-da-da, he told me that, and that's da-da-da-da-da if you're listening, that's in the transcript. And da-da-da-da-da. He told me that he didn't represent Mr. Copeland. He told me, Mr. Melnick told you? Yes. Mr. Melnick told me previously that he wasn't representing him. The court. You would not speak to an unrepresented party. I mean, I know you know enough of the rules to know that if you thought or intimated that somebody was represented by counsel, you would go ahead and let them contact that lawyer, Mr. Hilton. Or Mr. Copeland would have said, because I don't know as a witness, because he's not charged, if he would have had to, Miss Love, write, Miss Hilton, because he's not charged. The court. I don't think you have to because there's no pending charges, but if he told you, I got a lawyer, I don't want to talk to you, Miss Love, we would have left. The court. Because people counsel that they have under retainer or something else, or they say, hey, I got a lawyer that I use for everything and I want to talk to him. I'm not comfortable talking to you unless my lawyer's present. Miss Hilton, we have done that with a number of our witnesses here. So this would have been no different. Miss Love, exactly. And we would have, I'm sorry, I don't mean to cut you off. Miss Hilton, no, go ahead, that was it. Miss Love, we actually communicate, especially when either they are incarcerated or subject to having their sentence revoked as a result of their testimony because they pled guilty here. We only reach out to them through their attorney because we want the attorney to speak to them, and for that to be because that's the best way, in our opinion, to get a rapport that elicits truthful testimony. So in this particular instance, there was not that, number one, there was not that communication made by Mr. Copeland, that there was ever a need for that. And two, there was not a need for us to be concerned about it because he doesn't have charges. Ms. Hilton explained to him at length that whatever happened that he did in 2015, which is all we're going to be talking to him about, the statute of limitations has run. He didn't do the murder, we know that. So great. We know that because we decided to trust him and we want to believe it. I mean, so I don't want to get into the facts of anything. What I'm trying to get at is the fact that Mr. Copeland, I believe Mr. Melnick has inserted himself in a way that jeopardizes the best interest of our witness. Now, before I go on, if this is the point of contention, this is what Ms. Hilton is explaining to him in length. Why would it be necessary for Ms. Hilton to try to keep explaining something in length to somebody? If that person knows they didn't do something or wouldn't be at risk of being prosecuted for something because the thing itself, so anything except murder, would have fallen outside of the statute of limitations by this point in time. If all those pieces lined up, would there need to be extensive explanations? Would we need to explain this to you in length? Or was Woody asking questions while Hilton kept saying, we know you didn't do this, we know you didn't do the thing that we could prosecute you for, so you should be good. You should be good. Yeah, you should be good. You should be good. Usually when someone has to keep saying something over and over, it's because there's a reason the other person isn't buying it. So just marinate on that. I believe that in conveying to the court that Miss Bumpus is going to stand in his stead, Miss Bumpus has been, she had to be, she was, what is the word I'm looking for? The sheriff had to speak to her because she was in the courtroom trying to hug Jeffrey Williams. Miss Hilton, no, she hugged Diamante Kendrick. Miss Love, I'm sorry. Miss Hilton, in fact, she hugged Diamante Kendrick and hugged Mr. Williams, and that's how Captain Kendall saw her, and Captain Kendall had her taken out. Miss Love, she expressed dismay and concern in challenging her right to go interact in that manner with the defendants. So our concern is that it's not in Mr. Copeland's best interests that are being represented. And that not only is that the case with respect to Mr. Copeland, we have no interest in prosecuting, but there is a tampering of sorts going on in this person inserting himself, where Mr. Copeland has been reaching out to speak to Miss Hilton, and that communication is being blocked by someone Mr. Copeland didn't reach out to. You notice no one said, Mr. Copeland called me. He never said, when we put on the record, when Miss Hilton said, the way I understand it, Mr. Melnick reached out to Mr. Copeland, because the first time we heard an assertion like, oh, he's going to plead the fifth, is when Mr. Melnick sent an email to Miss Hilton and myself, and he had copied on it Mr. Steele and Mr. Schardt last night. So we know that how CC works now. I think we got this wrong on the June 10th meeting too. I think when they were talking about this, they jumbled all of this. They switched this around. The court. Why would he have done that given Miss Hilton? And that's the state's concern. Miss Love, that's the point. The court. But here's the challenge. The challenge is you have privileged communications, and unless you've got him being the client, disclosing to a third party that wouldn't be subject to the privilege, that is the only way you're going to, Miss Love. I don't disagree with that at all. But if Mr. Melnick, and the thing that got me the most is Mr. Melnick is not looking at Mr. Copeland saying, you know, Mr. Copeland, I want you to stay out of jail and I will be here with you. And if they ask you anything that touches upon something that you and I have talked about, I will stand up and assert your right. He didn't do that. So this is Friday. The immunity order was signed on the 6th, right? The evening of the 6th. But we find out that Melnick hadn't received a copy of the immunity order. That may have been the email that got sent on Friday. So it's possible that during this time in court during the day on Friday before this ex parte meeting at 2:45 p.m., Melnick still might not have seen a copy of the agreement. And we learned today that yesterday, Schardt got up at the end of the day after the camera tried to pan away for the night, Schardt ends up saying we've never even seen the motion that was made to request this immunity order. So it's possible Mr. Melnick here didn't know the full scope of what he could be protecting Mr. Copeland against. But anyway, what he did was he looked over at two people and said, like, I did what I could, shrugged his shoulders. Like, so they're giving a quote. They're completely characterizing this, like creative licensing. What he did was he looked over at two people and said, like, I did what I could, shrugged his shoulders, held up the palms of his hands like this as to say, I tried. So these aren't actual quotes. These things weren't said. They don't ever actually make a proffer that somebody overheard him say this or his lips are moving and it looks like he said these things. It sounded like he said something. All they have is he did a body motion and then they're attributing statements as if they heard him say these things. This is like the third place they've done this. There is no reason he would be looking at the right to counsel for the defense like I tried after Mr. Copeland said he wasn't going to testify. That doesn't make sense. The court, well, there's a lot of innuendo that they have asserted themselves. They, being some of the defense counsel, have inserted themselves in this particular process. And that's what, Miss Love, my concern is Mr. Melnick's insertion of himself. The court, what are you asking me to do? What are you asking me to do, and what do you think that I can do? Miss Love, why are you asking two dolts to coach you on what you have? Miss Love, that is the exercise. That is the homework for tonight. So we don't know. So this is why we're coming back to you on Monday morning. Miss Love says that's the exercise. That's the homework for tonight. I wanted to let the court know that that is what we're looking into right now because there is a remedy, because I have faith in our law. I love this thing, and I know there's a remedy because this can never have been the first time this happened. It has been addressed. I just have to find it. So you're holding someone in contempt while you figure out how to get what you want. But I didn't want to be looking for something and not let the court know what I'm looking for. So that you are caught off guard when Monday morning or Saturday night or Saturday afternoon, we find it and send it to you. Okay. So thank you for allowing us to audience with the court. I just wanted to make certain that we did it properly and we had everything on the record. It is our witness. We have conveyed to him that he is shielded from prosecution for anything that he talks about on the stand and any use of that. Great, so you've been incorrectly advising him for more than just that Monday meeting. And the thing, no wonder you had to keep explaining to him in length. Because Woody's like, that can't be right. So Hilton just kept explaining it and explaining it. I can picture it going down. And the thing is that we won't ask him that, but this is what he said. Y'all might not, but they might ask me about some things that I have to assert my right on. So, but this is what, y'all might not, but they might ask me about things that I'd have to assert my right on. And that would be a question by question basis. Yeah. I think, great question, Lil Woody, Kenneth Copeland, someone that probably has less responsibility to know this and is instead being incorrectly counseled by somebody that wants a certain testimony from him. This is exactly why Melnick was sending you guys these emails and you acted like Melnick's crazy. And why you hate the idea that Melnick said they're going to hammer you. Because this is the problem. Woody thinking that he's going to be hammered, which the defense can hammer him on certain things. You can object and say, don't badger my witness, or you're asking the same question too many times. But you can't stop the defense from asking questions they have a right to confront a witness with. And you don't want that to happen. You don't want Woody to be up there and be able to say he pleads the fifth. Because that'll look like he's the one that did something. He's the one that did the thing that the defense counsel's asking him if he did. That's the whole problem. It's obvious to you guys. I'm just going on my monologue here. You guys already know. What he is being influenced to do, we believe, by Mr. Melnick. So the state is saying that Melnick is the one influencing Kenneth Copeland, not Hilton, who's speaking to him and explaining to him in length all these things that are still not convincing him that he won't be asked these things that he might need to invoke his right on. But here, it's Melnick that's influencing Copeland. And it's through Mr. Melnick because, as you saw, Kenneth Copeland said, "I will testify." I think they're referring to, he said that on the stand in court. When he gets up on the witness stand, he's wearing the plaid shirt, and Glanville's like, and he's like, "Yeah, I'll testify." So it sounds like he got influenced right before this, but Mr. Melnick even said that he's asserting his fifth. I'm going to go talk to him. Logically, one would think that as long as Mr. Melnick's concerns about Kenneth Copeland's freedom, legal freedom, and his exposure, as long as those were addressed, Mr. Melnick should be saying, "I'm here with you. If there is something that I know will put you in jeopardy, I will stand up and stop you. But right now, I would rather you stay out of jail." Instead, you get Mr. Copeland, and you can see through his body language, he gets there in court and he's smiling as if making a show of being taken into custody after this. And the man don't want to be in jail. He said it. So, how would this have anything to do with Mr. Melnick? And remember, they told reporter George Teedy, the deputy said, "Don't film this. Don't film him being arrested. Don't film him in the hallway in cuffs." So, this is kind of telling. Everything they're trying to say here in this transcript to Judge Glanville, everything they're trying to portray, this unravels it. This man doesn't want to be in jail. He said it. Didn't he say he didn't want to be in jail? Miss Hilton, that's his biggest fear. Miss Love, that's his biggest fear. And now he's in jail after Mr. Melnick asserted himself in this process. So we have to figure it out. I'm not just laying it on your lap saying, "Go fix this." I'm just bringing this to the court's attention. This is a grave concern. Miss Hilton, she's about to lose her mind because her biggest concern is that Mr. Melnick is actively harming a human being. And that's what she's maddest about. How many times are they going to say they're mad because, and it's not the reason they're really mad? "I'm mad because it is stopping our trial." Yeah, okay, there we go. We get a little truth. And it's wrong. And that is not how the law is supposed to work. So we have two big old grave concerns that we are working to remedy right now. Okay, well, like I said, I think that you brought your concerns to me. Without more, I don't know what else I can do in terms of that. My comments today are predicated on there's a lot of stuff that's going on in the background, and it shouldn't have anything to do with you all's case. It really shouldn't. But I think it does in some way. Outside agitators. Miss Love, that too, the court, and everybody else who I think are trying to influence, Miss Love, that is absolutely happening. Miss Hilton, there's a lot going on. Miss Love, there is a presence. Yes, that's all I'll say. The court, but I see it from the beginning in the courtroom and tracking. But okay, if you find anything, we'll see where Monday leads us. I know that's like a figure of speech, but if you find anything, we'll see where Monday leads us. And like I said, since we now know he's going to potentially invoke. So we know, and we're going to try to put him on the stand again anyway after another ex parte hearing. We'll see what his pleasure is, and Miss Love, just the idea of someone sitting in jail throughout this trial, but if that's what he's being counseled to do and that's what he does, that's just wrong. It's wrong because the member of the bar is, in my mind, creating that circumstance. He's going to do what the person he trusts to have his best interest at heart tells him to do. And that person, he doesn't have to tell us what he's concerned about and can just sit there. And when he sees the train coming, stand up and say stop. But he's got a vacation to go on, so he can't be here. So Miss Bumpus is going to be here. Miss Bumpus, hugging Mr. Kendrick and Mr. Williams, is going to be here representing the interests of Kenneth Copeland, who is supposed to testify against Mr. Kendrick and Mr. Williams. That is where we are. That doesn't pass the smell test. And then the court. All right. Okay. Miss Love, thank you. So that is the transcript, you guys. And it was only Doug that wrote this one. This motion that this is this amendment, this supplement that's attached this transcript. So what do you guys think? What do you guys think? We can look at this motion. We've got an hour. It looks like I'll double check. Yeah, it's still saying over here that they're on break until 11. So we've got some time. That wasn't that long to read that. Yeah, like what else do we say? Yeah. Yeah. I think so. I don't even want to say, I get that on one hand, he's had to deal with like possible deals with federal prosecutors. So he also has like kind of experience in like that specific circumstance. But additionally, if he just knows when someone's BSing him to his face, it's fine, don't worry about it. I mean, that's the kind of, you can have someone that's fine, don't worry about it in any scenario. And you can kind of register when it seems off. Yeah, definitely was on Melnick too. Just totally, and I really think these paragraphs here on the second to last page, where Glanville jumps in, is like, yeah, everyone's influencing, yeah, there's a presence, there's a lot going on. I've seen it from the beginning in the courtroom and tracking, as if he's tracking it, right? Is he talking about who's coming into court every day? We get this motion from the state to restrict extrajudicial statements because Doug Weinstein is going onto channels and speaking to people. Doug Weinstein speaking with infamous Sylvia. Like, there seems to be some unstated animosity here, possibly towards people with the Rule 22 in there. They don't want George Cheedy recording the arrest in the hallway. And I believe infamous Sylvia said the same thing. We weren't supposed to take pictures or record in the hallway when they were holding Woody in contempt, walking him out to, take him into custody. So, but they had no problem having him in handcuffs on Monday morning when they wanted to talk to him to make sure he was going to get on the stand and testify. Like, all these layers are just fishy. And then when Glanville makes his judicial record, the day he announces he's going to, I forget what day that was. It was like a week and a half after the 10th. But he's like, look, this is when the meeting started. He gets the times wrong. And then he says, I didn't try to see it, but my deputies brought it to my attention that there's a video of Mr. Schardt, Max Steele, Kayla Bumpus, and I forget the fourth person. Maybe it was Melnick. I don't think it was, though. I think it was 4 people. I didn't try to look for it. It just came to my attention because of one of my deputies. And maybe that is true. But he could have had his deputies tracking and keeping an eye and reporting on things to him. What does this mean here? I've seen it from the beginning in the courtroom, and I'm tracking to me seems like an incomplete sentence where he's saying, and I'm tracking it, but okay, if you find anything, he goes on. Like, how are they not acting in concert? They're noticing things together. They're noticing things are funny. Yeah, and I really think, Nancelot, I think Woody knew when to play dumb about certain things. She loves fantasy, says this back and forth gossip girl banter is nauseating. They don't give a F about Woody. No. And how many times in this did they say they don't want to see him in jail? Did they use jail every time they said it? So 8 times, jail is used 8 times in this document. To be fair, it's all in the transcript. None of it's in the motion. Custody. 2 times in the transcript, custody is used. Hold. They don't mention contempt by word. So, but several times in here, they're like, we don't want to do that. We don't want to do that. We don't want to do that. Like, it reminds me when someone's like, I'm not in it for the money. I'm not in it for the money. I'm not in it for the money. I didn't marry him for the money. Like, all right, the more you say it, the more I'm thinking about it, that kind of being one of the factors. Yeah, outside agitators. And that's why he came back up. Great point, Brittany. So, guys, when we watched earlier this morning, Doug made sure he corrected. He said, look, those weren't my words. Those were Judge Glanville's words. Because he had quoted them in his argument to Judge Whitaker. And Judge Whitaker kind of took issue with the professionalism and some of the terms being used. And he was like, no, I was quoting the transcript. Which makes me think maybe Whitaker didn't really read this thoroughly if she didn't remember that phrase. Because as we're reading this, I don't know about you guys, but do certain phrases stand out to you? They're memorable. Like, for me, it's really memorable when Krauss called Brian Steele's motion hyperbolic. I'm going to remember that she used that word. But here, things like influence, outside agitators. If you'd read this transcript last night and someone said the same phrase in the morning, if you read this with attention, you paid attention to it, would you remember that phrase coming from this document, or would you think that Weinstein was saying it himself? I don't know if what I'm getting at makes sense. You just like pick up on certain things like that. So yeah, I'm sure, I have no doubt. I'm sure Kayla will be live today. You guys, her channel, her handle for her channels. Let me pull it up. That way I can just drop the link, because I don't even know if I could guess it's like a random word right now. And I'm also wondering if she had seen the transcript yesterday, and maybe that's why she was like, it was Deputy Brown that told Steele. Okay, so she has a weird handle. This is her YouTube channel. I think she can't change her handle for like 14 days. When you change it once, it like locks you out from changing it again for 14 days. So that's probably why it's still like that weird Busco J1P. But that is her real YouTube. She has it back. And I'm sure she'll be live to talk about, yeah, okay, so she has something scheduled for tomorrow. Nothing that looks like it's going to be about YSL, but I'm sure she'll go live tonight. Let me get this. Lindsay, please get up and make me avocado toast. Love you. Wait, is this like a movie quote? I don't know that I've ever had avocado toast, but I know everybody likes it, so. But thank you for the super chat. I am so bad with movie quotes, so if that's a quote, it's over my head. Garrett says, if judge bans Melnick to testify, he should go public. And then also, okay, thank you again, Garrett. So Garrett says, ex parte meeting in Fulton is the de facto strategy session. Yeah, and it's, you kind of see it. What do you guys think about this part? Let me find where it said other. Oh, okay, it's right on the same page that we're on. So the preceding paragraph, you know, I don't think you would have to, because there's no pending charges, but I know if he told you, I got a lawyer, don't want to talk to you, we would have left. And Hilton goes on here to say, we've done that with a number of our witnesses here. So that would have been no different. Cool. It's not unusual for, all right, state's trying to speak with different witnesses. It wouldn't be unusual if a couple of them say, look, I would like to have an attorney here. I want to speak to an attorney I already have. But when it's coming from these two specifically with what we know, when we have things like, where was that one thing? Miss Hilton explained to him at length that whatever happened that he did in 2015, which is all we're going to be talking to him about, that the statute of limitations was run. He didn't do the murder, we know that. So when we say we do that with all of our witnesses, we've done that with other witnesses, do we mean found out they had an attorney and decided to just wait? Or do we mean we talk to them to the point of exhaustion? We explain to them at length whatever we want them to believe we are going to do or not going to do or not going to question them about, until they finally understand, even if it's incorrect, what we want them to understand. Because for me, reading their description of what they do with other witnesses, I don't really have a reason to give it the benefit of the doubt that it's just business as usual. They're just, all right, we're trying to get statements from you. That's our job. And if you want representation, cool, we'll get you representation. No big deal. I don't think that's what they're doing. Don't think that's what they're doing. So thank you so much, Garrett. Yeah, and like, what do you guys think about, you know, the outstanding motion for mistrial? Some of the language, and it's weird because one moment Whitaker will seem like, I don't want to deal with this anymore, we're not going to talk about it, or we'll talk about it later, as if she's brushing it off entirely, kicking it down the road. But today, when Schardt was arguing, and Schardt came with different energy today, that was awesome. He was making his argument, she was nodding along. We saw some kind of agreeing on things being done wrong. And then after they got done having their conversation, Love tried to stand up and say, oh, can we have more professionalism in the court? We don't want to use these terms like co-conspirator. And even though Whitaker was quickly like, all right, yeah, I get the thing about the terms, she shut Love down as soon as she acknowledged, yes, about the terms, but she didn't want to hear Love try to switch the argument to make herself the victim. And now I'm wondering, with this new stuff with this ex parte, with John Melnick wanting to testify, could that change the needle on this outstanding mistrial motion? And yeah, guys, just so you know, we are still out of court here. Still nothing going on. We've got an hour. We can read this, what Doug Weinstein's arguing, and his tone, his energy has been very different too. And I don't blame them. I understand. So comes now Diamante Kendrick. Oh, this is for mistrial, not bond. Okay. Comes now Diamante. That makes more sense. By and through his undersigned counsels, and brings a supplement to motion for mistrial showing as follows. Quote, outside agitator. Okay, so yeah, so I doubt Whitaker saw this if this was filed this morning, 7:15. So outside agitator is a term that delegitimizes internal dissent against the status quo. So anyone who speaks up against the status quo, whatever that is by definition an outsider. And that's cited to Professor Dylan Penningroth from Berkeley. Judge Glanville making outrageous allegations against members of the defense team in the present case, and this is really tiny. Outrageous allegations against members of the defense team in the present case. But I think it does in some way outside agitators and everybody else who I think are trying to influence. The third ground argued in Kendrick's motion for mistrial is that Kendrick's due process rights were violated relating to a 14th Amendment due process violation, relating in part to Chief Judge Glanville wrongly coercing Copeland to testify. Further evidence of the state and Judge Glanville's violation of Kendrick's due process rights has just come to light. Yesterday after court, Kendrick received a rough transcript. Okay, so that is a rough transcript of an additional secret ex parte meeting with Judge Glanville held on Friday, June 7th, 2024. The rough transcript was helpfully provided by this court to defense counsel. A reading of the rough transcript highlights that which has been obvious to all observers, except for Kendrick's counsel, for the past 19 months. Judge Glanville has been willfully biased and acting as a member of the prosecution team since the inception of this case. He said he's been tracking. Please call it out. Kendrick's counsel takes no pleasure in alerting this honorable court to the situation, but client obligation requires it. I'd be ineffective assistance of counsel if I don't do this. Due process requires a fair trial. It is not a fair trial when, in an ex parte meeting, Glanville, Love, and Hilton gossip like yentas. Oh my god, Erica, are you still in the chat? I don't know your new screen name, Erica. I forgot it. So, Fantasy, are you here? Where are you? You called it. They were gossiping. And Doug Weinstein's calling them yentas. Gossip like yentas over 13 pages of transcript about attorneys Schardt, Melnick, and Steele. It is not a fair trial when in an ex parte meeting, Glanville, Love, and Hilton assassinate the character of attorney Melnick and attack his integrity, alleging that he is not acting in the best interest of his client, Copeland. It is not a fair trial when in an ex parte meeting, Glanville, Love, and Hilton attack attorney Bumpus for allegedly hugging Kendrick and stating that she is incapable of representing Copeland. It is not a fair trial when, in an ex parte meeting, Love lies to Glanville about an email, call it out, an email she received from Melnick. It is not a fair trial when, in an ex parte meeting, Glanville starts talking about, quote, outside agitators, stating, my comments today were predicated on there's a lot of stuff that's going on in the background. But, and it shouldn't have anything to do with you all's cases. It really shouldn't. But I think it does in some way. Outside agitators. Yeah, I really don't think Whitaker read that transcript. She didn't remember that Glanville's the one that said it. It is not a fair trial when in an ex parte meeting, Glanville and Love have the following outrageous conversation. Court. But I think it does in some way. Outside agitators. Love. That too. The court. And everybody else who I think are trying to influence. Miss Love. That is absolutely happening. And then citing to page 11, 11 and 12. It is not a fair trial when Glanville, Love, and Hilton have this further discussion. Miss Hilton. There's a lot going on. Miss Love. There is a presence. Yes, yes. That is all I'll say. The court. I mean, but I see it from just being in the courtroom and tracking. How many violations of the Georgia Code of Judicial Conduct does it take to get a mistrial with prejudice? Oh my God, someone put this on the Tootsie Pop thing. Make a Tootsie Pop meme with the owl. Make Doug Weinstein the owl. And ask how many violations of the Georgia Code of Judicial Conduct does it take to get a mistrial with prejudice? This case is like an old house that the present honorable judge is tasked with renovating. Every time a piece of pasted-up wallpaper is removed, more rot is found hidden underneath. No Herculean effort by the present court can fix the due process violations of the last judge. This house must be torn down. A mistrial should be declared and retrial barred due to prosecutorial and judicial misconduct that has goaded Kendrick into the present motion. Wherefore, Kendrick respectfully continues his request that this honorable court declare a mistrial based on at least due process violations of Kendrick's constitutional rights under the federal constitution and the constitution of the state of Georgia. Man, shout out to Doug. Guys, this is the link to the document there. And I saw Flesh of the Gods is on it. We're going to get a Tootsie Pop. How many judicial code of conduct violations does it take? Oh, it's going to be so good. I know Doug's going to love it. Oh my gosh. So there is the link. Yeah, the words, the quotes. This was great. Shout out to Doug. Shout out to Doug Weinstein. And you know, all that love to Katie Hingerty. Doug is so gracious to his teammates, his partners, his staff. He gives them all their flowers. But he didn't have Katie helping him write this, and I think he did a great job too on his own. I think he certainly did a great job. So shout out to Doug. Gonna make the owl. It's gonna be so good. Oh, if you guys want to join and become a member, I don't know, maybe I didn't put it in the description. I usually have it in the description of the videos, but I probably created this one and didn't put the join member link in the description. It should be next to where you chat. There's like a little money symbol next to where you type something to chat if you want to become a member. And if you go to a different video, I always have it in the description because YouTube, when I upload a video, it automatically says become a member of this channel and it like puts it in the description automatically for me. So I just don't know if it's in this because this is populated by StreamYard right now. So sorry. I don't know. That's cute. I appreciate that you want to become a member though. And look at all the love for Doug. Look at all the love. Yeah, there you are. She loves fantasy. I knew it was fantasy something. I was like, she called it. Calling them yentas is so funny to me. You know what? I'm going to screenshot that. We're going to memorialize that. There we go. Shout out to Doug Weinstein. So thank you so much, Aaliyah. Good to see you. Cat in Wonderland says, I think the judge is flooded with docs right now. That is very true. That is very, very true. I guess I have to remember that not everybody's me. Because personally, I was like, I want to see that transcript. It was really because of you guys in the chat yesterday. We find out that this is from, it's not just the courtroom transcript from June 7th. You know, you guys in the chat were like, hold on, wait. And sure enough, it was a separate, after court ended, they held another ex parte. And I think we guessed. We were like, that looks like it could be 10 to 12 pages if they're making 6 copies of it. And we're sitting here really doing the math to try to make predictions about this ex parte transcript, and we got it. Like, that's really cool. And I wanted to read it, but that doesn't mean that this was the first thing on the priority list for the judge. It's fair enough that she may not have had the attention span to dedicate to thoroughly reading this. So good point, Cat in Wonderlands. Thank you so much. And then I Am Shout just became a member. Shout out to I Am Shout. Oh. Long meat, little sack with the hot dog pictures. The acting like Doug wouldn't come up out the cut. CJ says, true or false, if a judge has a personal opinion of another judge and knowledge of them, wouldn't it be unfair for that judge to rule on another judge? Personal relationship with anyone shouldn't allow it. Yeah, and I think there is an issue with practicality. So at some point, you could run out of judges if you play 6 degrees of Kevin Bacon. About 5 degrees of Kevin Bacon, the Kevin Bacon thing. Like, technically at some point you'd run out practically of judges. But, Oh, yeah. Actually, this is great. So, yenta is kind of like a word that, like, I'm not Jewish, but growing up, like, Queens, Brooklyn, yenta was used and understood by people that aren't even, that don't even know Yiddish. So, sorry that I took it for granted. Yenta is a Yiddish word that refers to a woman who is a gossip, busybody, or meddler. Definitely great context out there. If you're wondering why, I love that Doug Weinstein used the word yenta. And then who finally admitted to the 6-7 ex parte? So that was yesterday. Let's go look at that clip. Paralegal Institute of Washington, I'm going to drop his channel too, does a lot of great YSL content, went and pulled the timestamp. So let's revisit that while we wait for court to come back in session today. We'll start with how it was introduced in the morning. Let's see. So first I want to give you Paralegal Institute's channel. And then let's go to the timestamp he pulled from yesterday. So we're going to switch over to this.
The next thing is the defense asking whether there have been any other ex partes that we don't know about. And so I'm going to ask everybody, and y'all know what ex partes you had with Judge Glanville, and you know what filings got made. And so is there any ex parte that occurred that is not connected to one of those sealed filings? And I'll ask the state first.
Your Honor, not being certain whether the seal filings include the transcript of the request from the state to have the hearing with Mr. Copeland, and not certain whether or not those sealed filings contain that.
Okay.
I can't say, but the state requested that we address the matter of Mr. Copeland's representation.
All right, and was that done in writing or was that oral?
No, the request was done orally with the court reporter there.
Okay.
We requested that the court allow us to address the matter and that it be taken down for the record.
Okay. All right. Anything beyond that?
Yes, there was also the state's request for a material witness warrant for one of the.
I think those are all reflected, and you may want to go back and look, but I know that there were material witness warrant requests from several different parties in the case.
Okay. Okay.
All right.
So those are the ex parte matters that we address with the court.
Okay. Thank you. Mr. Weinstein, anything? Okay. Mr. Carlton, Mr. Matthews. Okay. Mr. Steele.
think at this point they do mention there may have been something else. We'll play it for a little bit because we have the time to make sure.
Which I believe is accurate, there were 2 meetings with recused Judge Glanville. One was during voir dire. It is going to be the day, I could get you the date, but it's going to be the day that law enforcement execute a search warrant for the computer of the Honorable.
Yeah, so these are talking about other separate things that they just want to make sure it's on the record. And then there was a bit at the end of the day yesterday. So let me pull up the full day stream. And you'll see exactly how cut off it was because the camera will pan to the seal as if, and the sound cuts off. They stop, the sound cuts off and then it has to come back in. So let's see.
My absence will be 1 week. Your Honor,
Okay, so the other thing that I had
Your Honor.
is, I
Your Honor.
asked,
Judge,
yes,
I'm sorry.
yes.
I'm sorry. Didn't speak
Oh, I'm
with.
sorry.
Oh, it's a little after this.
There had been, I'll think about that one.
Here we
Okay,
go.
so there had been, Miss Love put on the record this morning that she had made the request for the Monday morning meeting. There was the June 10th meeting with Judge Glanville and Miss Bumpus and others at some point in the afternoon of the Friday the 7th. And I said I would get that ex parte because it did get taken down. And so I reached out to the court reporter who handled that, and she has given me a rough. Now this, and I'm going to share it with each of you. It's a rough, so this is not the official transcript, but I mean, she's an experienced court reporter, and this is probably pretty close to what it's going to be officially. But anyway, I'll just share that with each of y'all so that everybody's on the same page about everything, okay? So if y'all all want to come up here and get a copy from Ms. Burstfield, after that, we will be in recess for the day. Thank you.
This is where it looks like it's over, but then Schardt has one more thing to say. I think they come back pretty quick.
Relates to the ex parte.
Yeah.
I could be wrong about this, but I'm asking my colleagues, and no one has the written motion for immunity for Mr. Copeland.
Okay, I think that probably got filed ex parte, but is there any objection at this point in time in the defense having that as well?
No, Your Honor, not
Okay.
the defense, no. I
Okay.
just didn't want to, no objection to the defense having it.
Okay, so I'll email y'all if that's okay, because I don't have hard copies of that available. A copy of that. Do y'all have the order?
We have to-
Okay, yeah, I'll make sure y'all have a copy of the motion. Okay. Third time's a charm, we're in recess? Okay.
Yeah, so that was it. But you see how that was like really stuck in there at the end of the day. I only knew about it because the chat was like, wait, hold on, there's more. Like, was it Billy Mays? Hold on, wait, there's more. But what Schardt was just asking about was not about a copy of the immunity order, but the motion used to get Fonnie Willis to sign off on granting the immunity use order. So they've never seen it. They don't know by what grounds, what reasoning. Was he in fear of his life? Like, if he can't testify because he's afraid, he's shaking in his boots. Like, what is this argument? Is this argument to grant the immunity order going to be based on Melnick? We think Melnick is up to no good. Like, I want to see that motion, that filing. And I'm sure as soon as they get a copy, let me check while we're here. Let me check and see if anything new is uploaded. Because think about that. What do you think they argued as the grounds for needing this immunity order? Based on what they're arguing in the court in the ex parte meetings. What was sealed was the motion for the immunity order. So the request for the immunity order. Nothing new. I always check 2 portals for updates. Yeah, I really think Melnick needs to testify because who else can counter? How can you get to the truth if you only look at what Love is saying in that transcript? And unfortunately, like, hopefully Judge Whitaker knows better when she said that the transcript is the best evidence we have of what was said during that time. Hopefully she just means as far as what was actually said. And she doesn't mean that what was being said, the truth behind what's being said. Because you can't just take what's in that transcript at face value. Especially since they're lying about the emails. Some of the things that Doug called out are really, really, really huge in his supplement today. Well, they're lying in their motion. But you just told us that the transcript is the best you've got to say that this ex parte on the 10th was proper. But we have more indication that they were lying in that meeting. So what good is a transcript? The stuff that they're saying in the transcript isn't true. Even if the transcript's true and accurate, it's just transcribing some BS. Like, and actually, let me check. So I checked, obviously, Doug Weinstein. But let's see if like, let me check, like, Shannon Stillwell. It's a true and accurate lie. Let's see if Steele's filed anything. Can you imagine? Steele probably needs more time to write his motion about this new transcript. Okay, this is old. This is the response to the proposed witness list, which, by the way, this is just a 1-page thing. The Brian Steele took issue with the state's proposed witness list, but we did find out from this that they filed it late. They filed it on Friday, and they were supposed to hand that in by the deadline on the 23rd. Nobody's surprised. Let's go back to looking. Let's see if Schardt filed anything about this transcript. Okay, and this is just the state's motion, the addendum from the other day, from the 29th. So nothing new filed by the other defense counsel at this point in time. And looks like we're still on track for 11 a.m. Guys, that means we're going to talk about, I'm going to go through the chat. We're going to talk about what we all think is going on. But this would be a good time. You've got 30 minutes. You've got about 30 minutes if you need your comfort break, if you need to get a snack, if you need to fill up on your water, caffeine, whatever it is you're drinking right now. What do you guys think? Good to see you, Lady Red. And by now, Whitaker shows Love. Candor is not up and honest. Yeah, that's the thing. Love is really burning herself. we opened yesterday. The first thing that was addressed yesterday was, I'm not restricting extrajudicial statements. The defense counsel can appropriately speak to the public. They didn't cross any lines, and I'm not going to restrict their ability to speak. Then the next thing that was addressed was, I don't want to revisit all of these prior rulings. I don't see anything wrong with them. Moving forward, anything new that we're going to do, I'm going to be the one that rules on them. And the rulings might seem a little different, but I'm not going to revisit things from the past. Then she goes through the day and has to ask rhetorically if Adrian Love even knows what case in chief means. There was something else that she asked about too, where it seemed like, I think we had a little bit of, no, what was it? There was another term that it seems like she had to define what it was, and she was like looking over at Love when she said it. And then there was also the oral arguments back and forth in relation to one of Steele's motions or maybe it was Max Schardt, the statement of interest relating to Garlington's statements. And I think she was asking Love like 3 or 4 times for case law that backed her argument. And every time Love got up and started rambling about something that wasn't providing case law, or one of the times she tried to cite something from the 70s, even though a new statute's in place that does all of that, Judge Whitaker just looked like, what are you doing? So when you think about how Whitaker started yesterday thinking like, all the prior rulings might be fine. By the end of the day, you see that she probably realized that all the things Love is trying to argue, that Whitaker is disagreeing with and pushing back on her on, Judge Glanville actually agreed with those arguments and made a ruling in her favor. So now maybe she's questioning those rulings after she didn't really question them, because she's learning how they came about. Inartful. Oh yeah, the reciprocal discovery and the impeachment, the impeachment by inconsistent statements, prior inconsistent statements, and the impeachment by contradiction. It's just something that drives me nuts. And to be fair, for the most part, it's been Hilton making those arguments. But I think Love stepped in for her. I think Love and her both made arguments back in June when they were arguing about this. But that today, I'm sure we're going to see more about that. The gang is, that's what it was. Gang is gang, gang is Rico, Rico is gang, Rico is Rico. Like, just let us all say there's a hearsay exception to anything that anyone that may have ever waved to YSL. Now they're going to argue, we can, anything Kayla said anywhere. If we want to bring that into court, there shouldn't be a hearsay. Hearsay shouldn't be a reason to not let it in. It should come in. There should be an exception because she hugged someone that may be part of YSL. like that's the logic. That's the logic that Love was arguing to Whitaker yesterday. And Whitaker's like, what's your basis? Are you saying it's because they're in a gang? Are you saying it's because of the Rico statute? And she's gang is gang, Rico's gang. Oh my gosh. You guys. Yeah, and the reciprocal discovery. You still don't know how discovery works. I think Thugger Daily clipped those parts too if you want to watch them. Let me go find that. Let's look at some Thugger Daily clips. Shout out to Thugger Daily. You guys are on X and don't follow Thugger Daily. Not only great updates on the case, but pulls funny clips. He's already got clips from today. Oh, this is a clip from Max Schardt where he says this from today.
But it's all starting to make sense. It clicked when I read that transcript last night. This is not okay. Nothing about this is okay. These gentlemen have a right to a fair and impartial judge. And I appreciate the fact that you are going to be a fair and impartial judge. But the reality, Judge, is that they don't have a right to a fair and impartial judge starting on witness 76 of a trial after 9 months or whatever it is. They have the right to a fair and impartial judge from the beginning. And this is absolutely gross and disgusting. And the bottom line is there's a lot more discussions that need to be had about this. But the bottom line is, if you ask me, do we need to revisit the rulings of the judge who sits in chambers secretly and talks to the other side and says, yes, I've been observing this. I've been observing this about what's going on in the trial. The judge that says, not only I'm going to meet with you on Friday and on Monday, but if we need to talk during the weekend, yeah, we can do that. The judge that suggests handing Mr. Copeland a list of questions. Do we need to revisit those rulings? Absolutely, we need to revisit those rulings. We need to revisit everything. This is broken, and it's not okay. It's not okay. It's offensive, and it's not your fault, Judge. You didn't do this. I'm not trying to raise my voice at you. I'm heated right now.
I can tell.
My steam's been coming off my bald head all night.
That's so great.
Nothing about this is okay. Yes, we need.
I love that quote. The link I'm posting in the chat right now, you guys, is Doug Weinstein. I'm typing quick because I don't want to type in the microphone or just sit here quiet while I'm typing on screen. But the link, I saw someone just ask, is the transcript available? We did just read it, so if you want to rewind about 35 minutes, maybe 45 minutes, you can go through a reading of it. But the document that I just linked, it's attached as an exhibit at the bottom. It's a rough copy of the transcript, the same that was handed out by Judge Whitaker at the end of the court day yesterday. So we've got about 20 minutes till we come back. And I'm counting on that being on time. Hey, Miss Mandy Reacts, good to see you over here. And then you came over from Dear Woke Christian's channel. Dear Woke Christian, I don't know if I'll be able to make it, but he's going to do a YSL discussion panel. Let me double check the date. I want to make sure, I don't know if it's today or tomorrow. If he has it scheduled, I'll just drop a link to it so you guys can bookmark it. I'm going to try to hop on, but I've been working after I get off these streams because I usually would be working during these hours. If I can get some time free, I will join in. But I'm not optimistic about it. So this is going to be the panel. It says 7 p.m. Eastern tonight. So there you go. And thank you so much, Mandy. Good to see you. And then shout out to Steven for becoming a member. I pulled it up on screen, but I didn't want to talk. And then Black Butterfly says, remember those hand signals? All trial with the judge and the prosecutors. They were conspiring the entire time with that. And guys, I tried to be fair. I tried to look at a possible explanation where, maybe, sometimes you see someone yawn and you start yawning too. You see someone touch their mouth and you think, oh, do they mean I have something on my mouth? And you think maybe I got to check. Whatever. But when it happened consistently and I was watching most of the video, like there were a few times I looked off screen to get links or something. But yesterday I didn't really notice Love sitting there, Hilton doing anything with their ear. Were you guys observing that yesterday? Did you notice a difference? Because if there's a stark difference between those motions, whether they used to be accidental or not, it'd be really unusual for those same motions to suddenly be absent now. And all the while they're accusing the defense team of using body language to do something suspicious, outside agitators, influencing. Like, think about that, because it kind of sounds like projection. Thank you so much, Black Butterfly. Carson says, why hasn't the judge asked how many ex parte meetings were held before Copeland? Why have all these motions with that overhang? And I think we might see more of that. I mean, I don't think that I don't think we've seen the end of these conversations in court, these oral arguments in court about this June 7th thing, let alone the general principle of how does this keep happening? They had the opportunity to disclose the June 7th meeting when they finally caved in and had to disclose June 10th, and they still kept that a secret. What the heck? So what else? Because the inquiry yesterday, as we got to just watch that replay, I didn't catch it yesterday, but Whitaker does say the defense has asked. So I'm asking because the defense has asked us to find out were there any other ex partes. And the only one they offer up is this June 7th one. Why do you think they were willing to mention the June 7th one? My guess, you guys, is they feel like Melnick or somebody else knew. Or they think the deputy that told Steele also may have told Steele about that meeting. May have seen them go in and out of the room. I think they would rather just admit to it rather than deny it, not speak up, and get caught not bringing it forward. They probably thought there was a great likelihood that the defense already knew about this meeting, this June 7th meeting, in addition to the June 10th. So yesterday they said, all right, F it. We've got to sacrifice this one. We've got to just let them know about this one. Just to make sure they can't tell us we withheld another thing from them. But, you know, maybe they just thought it was the right time to finally promptly disclose something. I think we should have Whitaker teach Love what prompt disclosure means. And then so Ron says, where is the transcript of the ex parte meeting that the state would have had to get the order of use immunity the morning of June 7th? I don't know. I don't know. I have no idea. I'm sure this poor court reporter, Kristen Weaver. No wonder we're getting rough copies, though, because Christina Weaver has to produce all these transcription copies. So that's actually no surprise at all. We got a rough copy first. I doubt it's much different. They're probably just going to fix up the formatting and double check stuff, but yep, that's a great point. So J Capo T says, because it's the only one that was actually held with a court reporter. So if it was held with a court reporter, maybe they're worried that, you know, Whitaker's requesting the records from all these days. She's going to figure out that there was something transcribed. So we might as well just say so now. That is a great point, Jay. That is a great point. Oh, Janelle, yeah. This morning, you know, it's not really recapable. I think it's something you have to hear, watch the voice, the energy in the room. You really got to see Schardt goes bananas. Doug Weinstein goes bananas. Love tries to make it in all of us, not just a we did something bad thing. Judge Whitaker doesn't really buy that. Kind of has her sit back down. Really, really a good amount of fireworks today because of this newly disclosed June 7th ex parte meeting about Woody needing help being compelled to testify because Melnick is up to no good. That's my new summary of the June 7th in-chambers meeting, hearing, whatever they want to call it. Oh, and Cheesy, thank you so much for the love. Just the $1.99 super chat. Appreciate you. And right, that was such a great point by Jay. Can't wait for Replay Gang. I love being Replay Gang. And guys, by the way, if you ever watch one of these replays and you like to do the chat, I like to see the chat even if I'm watching on replay. Someone pointed out they didn't think the live chat replay was there yesterday on yesterday's video. It took some time to load. But if you ever notice the live chat's not there, drop a comment. I'll go and enable it and make sure it's still there for you can feel like you were hanging out in real time. I do try to read the comments out loud as I'm referencing them. That way, if you're listening and the chat's not available, you guys know on replay what I'm talking about. But yeah. Yeah, and let's go back to that. Let's go back to that. We still have 11 a.m. on the time to come back. But what was that? Glanville was like, yeah, just come to me on Saturday or Saturday night or Saturday afternoon if we can do something before a Monday morning. Like, come on. Exactly that. And a lot of you guys are thinking Whitaker's in on this. I do think, unfortunately, that a lot of judges would rather just kick things to an appeals court. And that might not mean that somebody's in a way that they're participating in something, like literally participating in, doing this to help you out, bro. But kind of like implicitly, it's allowing it to continue. It's not, being a forward thinking. The best example I can think of is actually a prosecutor right now, or Linda Johnson in the Alec Baldwin case. She had to step forward with 2 feet and say, I don't like what's going on here. I want to withdraw because, I tried to tell the lead prosecutor, this isn't right, we shouldn't be doing this, and they wouldn't listen. So because they wouldn't listen to me, that this wasn't right, I went to the judge midday and withdrew. And then by the end of that day, the judge ends up calling a mistrial of prejudice because Erlinda Johnson was right. So shout out to prosecutor Erlinda Johnson for having the balls, or the female equivalent of that, to do the right thing. But I think a lot of times there's just kick the can down the road, let the appeals court handle it. And guys, I'm telling you, if we get denials of the certain remaining motions, look and see if the defense asks for the certificate of immediate review to take it to the appeals court. Miss B, good to see you. How much longer before she calls a mistrial? I don't know. She got hits. I know you came in and out yesterday. You came back. Were you here in this stream when we got to look at the transcript? It's still on the screen here, but we read through the transcript from June 7th. Let me know if you got to hear that, because I really think there's some stuff in here that warrants calling Mr. Melnick. At the very least, it sounds like the judge is going to allow a proffer where Steele will get to say in court, it'll be on the record, what he intends to have Mr. Melnick get on the stand to talk about, which we could get a lot of details from that. And if Melnick gets on the stand, you guys, Love would have the opportunity to cross-examine Melnick, which could be even funnier. I can picture a situation where we hear a lot more because Love, or maybe Hilton, could be out-wrangled by Melnick on the stand. They're going to try to cross-examine him, and the way they approach it could backfire on them. He could just unleash. You never know what you're going to get when there's an attorney on the stand in the witness booth. So we've got a lot coming in. So how much longer before she calls a mistrial? I don't know, but I think this puts new reason, a new grounds to do so, right back on the table. I really don't think Whitaker started yesterday understanding the context of the ex parte meeting, and then we got brand new context. Everybody got brand new context last night. Like, just crazy stuff. Thank you so much for the super chat. V. Davis says, Love put Hilton in first chair to get the smoke. I do think she's just handling some of the arguments, but I can't believe one of the first arguments we hear her make is about the thing that was fumbled a month and a half ago in court. And now you're making this argument in front of a judge that's not going to be as nice to you as Judge Glanville was. Like, where's your case law? She said, where's your case law? You should have case law. Can we take some time? Well, no, we have other stuff to do. I'd rather move on to something else. Like, come on. So I don't know why. That's poor strategy on Love's part to have Hilton go and argue something she failed to argue previously. But yeah, my rolling joke is I think the chair closest to the podium is getting too much work in. It's not sliding as good as it used to. Maybe the chair on the left is easier. It's sliding back. It's smoother. You guys know when you get something brand new and it works a little bit better, it hasn't been used as much. Maybe Love just likes that she can push back easier in that third chair and get up to say something. Yeah, blue skies, I think a lot of people are thinking that. And there's people that take the Bruce Harvey approach where just the logistics of it don't make sense. We don't even need to consider, was something actually improper? The way the case has been managed and how it's fallen apart as far as the calendar is enough to just, how can you keep going with it? How can you get jurors back on track? If we don't get a mistrial, I really want to hear the proposed jury instructions, the curative instructions. How are we going to tell the jury to come in and, forget the stuff that you heard Kenneth Copeland talk about? And then he has to get back up on the stand. And now if Kenneth Copeland is only facing up to 30 weeks that he could be held in contempt, because Whitaker says she wants to be out of here in 30 weeks. If he's only facing 30 weeks, And it seemed like he was willing to be held in contempt through the duration of this trial, just not longer than that if he had to sit for the other co-defendants that are not part of this enjoined case. Maybe he would be willing to be held in contempt for 30 weeks. So what if he gets back on the stand and he doesn't want to testify, and he'll just take the 30 weeks in custody? Like, just think about how this could keep going. Like, it's just nuts. And yesterday, I really don't think, if you could, let me know if you guys were here yesterday and what you think about the questions Whitaker was asking of the defense and the state on their arguments about the admissibility of these hearsay statements introduced to the police through Kenneth Copeland, but were originally made to Kenneth Copeland by Garlington. The judge was giving a lot of pushback on the context, the characterization of, January 15th, when Donovan Thomas was murdered. She was trying to learn the context. She didn't seem to buy Prosecutor Love's characterization of how those events all unfolded. She also didn't seem to agree with the arguments the state was making about what laws or statutes or case law apply. So if we still have an issue with Copeland testifying and how we're going to instruct the jury on how to deal with that, and then we also have outstanding admissibility issues that the judge is taking under advisement. She said she's going to need some time to think about it and might make a decision today on it. What if those interviews can't come in? Some of them came in already and the jury's going to have to forget. That's a problem. But what if the state loses the stuff that they need to bring in for their other witnesses to make their whole theory of the case stick? Like, what do you do? What do you do? And then Mahadi, thank you so much. Love has low poker chips at the table. Steele shamed her yesterday. And guys, keep in mind that that left chair, the jury box, is like a couple feet away from where Love is sitting today. So if Love sits there on a day when the jury's there and she's doing all of this, like, the jury can see every wrinkle on her face, every pore on her face. They're that close. And yeah, guys, hit that like button. It's free 99 to hit the like button. Thank you so much. And then, let's see. That could be it, Sexy Smart Sweet. The judge is buying more time to make up more excuses why she's going to deny the motion for mistrial. I wonder if she's trying to consider having Melnick come testify. Either that or maybe checking out the transcript and Doug's motion. Because I don't think she had a chance to read Doug's motion. So she could address Doug's motion today if she knows what the argument is. So there are some paperwork things that she could be doing. And Jenny, something like that. Like a godmom or an aunt or something like that. I don't really know because I didn't pay attention, but something in that space. Yeah, free 99. I mean, technically free. Free 99 sounds like it's 99 cents. But I'm going to double check because, sometimes we get back to a seal. We'll put this back on the screen. That way I don't go off into a rant about how much Love annoys me. And we miss the start of this new part of the day. And I absolutely predict, if there's no mistrial today, we will have more motions filed by the defense team today or tomorrow morning. You said go ahead and rant. I mean, so much in the transcript pissed me off, but, in the back of my head, the judge is going to just say, like, we don't know for sure that that's what it means. I don't know how else you can read into a judge saying he's been tracking and he's agreeing with the state that there's outside influences. And like this. Everything that's wrong with Copeland's testimony is because Melnick asserted himself. Like, All right, bring Copeland in right now. Have Copeland talk to the judge. Ask him, why did you fire Kayla? Well, because she was going to be stuck in Atlanta otherwise. I thought she was done, making sure she could go home. Like, it hasn't gotten to a point where they bring up YouTube interviews. And if you notice, Love and Hilton didn't want to bring up Kayla's interviews on YouTube or Kayla's own streams on YouTube. Why? Because Woody's clearly on good terms with her. You can't just say Woody doesn't think that Kayla had his best interest in mind if he's still cool with Kayla. But that stuff's public information. It's on YouTube. And Love has kind of started tightrope walking on this thin line of taking issue with other defense counsel who are part of this case, to be fair, but she's treating Melnick and Bumpus like they're part of this case in this transcript. You can't have it both ways. You want them to talk about YouTube interviews, you want to have a problem with it. Let's ask Woody about how he feels about Kayla. You think she didn't have your interest at heart? Oh, and then what if the motion for the immunity order was based on this claim that these attorneys don't pass the smell test? Where did they say that? This stuff doesn't pass the smell test. What if that was one of the grounds, or the ground, that Love made in her request for this immunity order? And none of it's true. Woody doesn't feel that way. They made it up. What does that sound like? Sounds like prosecutorial misconduct. And that's true too. They're doing all of this. This second ex parte meeting. What a show on live TV. Supreme Court should be embarrassed. They need to be charged to. Or the Supreme Court, you want to change the panel out. I mean, probably. I don't know. I don't know the panel or much that the Supreme Court is doing over there in Georgia. I do know that with Christina Peterson, they did not play about an ex parte communication that a court clerk had with a party in a case. It wasn't a hearing. It wasn't something long and drawn out. It was a communication about a scheduling change, which could adversely affect the other party because they didn't get the same notice of the date change, something to that effect. And they listed it as one of 4 points to remove Judge Christina Peterson from the bench. They took issue with that type of ex parte communication. Here we are.
The fact that Mr.
I'll go back, sorry. We'll put it on 2 times to catch up. Come on, YouTube.
That case law about your direct question regarding the prior inconsistent statement and whether or not the fact that Mr. Copeland said, I said it, but I lied, if that would be grounds to, would that still be considered a prior inconsistent statement? Your Honor, I have three cases for the court.
Okay.
I have Green v. State, I have a copy for the court, as well as a defense counsel. You're welcome. Green v. State, which is 317 Georgia 250, which is a 2023 case. Schardt v. State 318 Georgia 855, which is a 2024 case, Your Honor. Sure, Sconyers, SCONYERS v. State. You're welcome. And United States v. Odom, which is a federal Sixth Circuit, United States Court of Appeals case for the Sixth Circuit. It is an older case. It is a 1994 opinion, and it's 13 Fed 3rd 949.
Okay.
May I approach with those three cases?
Yes, thank you.
Oh, fine, I'll give it to you. One second.
Thank you.
I gave you green already. I gave you green already. Which one did I give you?
Okay, it must have just caught up because it's doing this little lag thing, so Every time it switches to Normal for me, it does that. All right, so we're in real time on normal speed again.
All right, so Green seems to say that if you say you don't remember, that's a sufficient foundation. Is there, and that's the only one I've looked at so far, is there one that says, if you say, yeah, that was a total lie?
Yeah, so that's also in green, Your Honor.
Okay.
So if you look at page 5 of the opinion, Your Honor, about the 4th paragraph down in the facts of that case, Your Honor, it says during the course of their investigation, officers interviewed Corey Milton, who said that he knew Green had a green Camry, that Green told him that a cracker bucked, I shot him, and that it was not Baba, Hill's nickname, who shot someone. The state played this recorded statement interview for the jury at trial. However, before the interview was played, Milton testified that he did not remember an interview or Green telling him about a murder, stating, I be getting high, I don't know. After a break, Milton testified that he did remember telling law enforcement lies to try to get out of trouble and that he would say anything.
Okay.
Milton further testified that the investigators brought up his criminal record, including a federal conviction and state charges that were dismissed, and that during the conversation about Green, Milton was looking for help with his case.
Okay.
And those facts are analogous to what Mr. Copeland has said so far on the stand, that he was just trying to finesse his way to get out of trouble, that he said those things, but they were all a lie. And here, our Supreme Court in Green said, a witness's failure to remember making a
All right, so hang on. You're talking too fast for the court reporter to take it down because you're reading.
Sorry.
And then where are you reading from?
Now I'm on page 7, Your Honor,
Okay.
Division 3.
Okay.
And when the court, the analysis is a witness's failure to remember making a statement may provide the foundation for offering extrinsic evidence to prove the statement was made. They cite London v. State, which is 308 Georgia, 63 at 66, pages 66 through 67. They further cite Bridgewater, which is 309 Georgia, at Penn site 887.
They
Which
coached
cited
him to
defendants
say, I don't
denied
remember.
recollection, making a statement provided sufficient foundation for the state to present extrinsic evidence of the statement. Here, the state laid the foundation for the admission of the recorded interview when it asked Milton twice if he recalled making the statement, and Milton responded first that he could not recall making the statement, and then that he did recall but had lied.
Okay.
And so that is Green. And we also have Scaniers that discusses primarily that the state does not now have to go through every single inconsistency.
Okay.
But that we can now, the flat out denial of that statement, Your Honor, allows us to move forward in playing the entirety of the statement, Your Honor, without going into further details. That's kind of our summation of Scaniers.
All right.
And then Oldham, Your Honor, is a federal case on the same point as the Green case, Your
All
Honor.
right. Thank you. Appreciate it. Counter position from any of the defense attorneys?
Your Honor, I'm gonna let someone that's better than me respond, like Max Schardt or someone. But I just want to state that the foundational element for this argument doesn't even exist because we don't know what Mr. Copeland has testified to. I mean, everything he testified to after the 12th is void.
You mean we don't know what he is going to testify to?
Well, we certainly don't because we.
Right. No, I mean, I don't think anybody disagrees with that.
Okay.
But what I said was, let's go ahead and things that we think are very likely to still be an issue, given what he may testify to, let's go ahead and try to, hash out the admissibility of. So true. Yes, he may get up there. Who knows what he's going to say? But yeah, I mean, he would have to say something that would give a foundation in order for it. But assuming that he testifies generally in the same way that he did before, which was, according to y'all, and I've seen some of it, that was a complete lie, then we will face this, and so let's figure out what the.
So we're guessing at what he may say based on what he said.
Right, because I am trying to get prepared ahead of time instead of having to do all of this while we have the jury. So yes, absolutely.
Thank you.
Okay.
And if for anything, I do remember that there were at least 2 full days of testimony from the 10th to the 12th. And it's the state's remembrance that the I lied started early in his testimony. So, but we can.
Thank you.
with that as well.
And with regard to that, the court reporter has said that she probably, what did she say, Ms. Firstfield? You talked to her, I didn't.
She is working on the transcripts of Mr. Copeland's testimony, and she said that either late today or tomorrow morning, she should have, I believe it's June.
So Whitaker is not aware how many times he said, I don't recall.
And then would be working on June 12th, shortly thereafter.
And do we already have June 10th, or did he testify at all on June 10th?
He testified on June 10th, 11th, and all of the 12th.
And did he take the stand? He took the stand at least on June 7th, right?
Took the stand. I asked 3 questions in that.
All right. So do we already have the 10th? Somewhere? We'll figure that out. But anyway, it should all be forthcoming soon. Okay, Mr. Steele.
Your Honor,
Dun, dun, dun.
I don't think that the state's cases, from what I heard, I did not read them, I just heard the discussion, are what we're looking for, because those cases are, I don't remember, or I was on drugs, or I don't recall, but I found a case, it is pre the new evidence code.
Okay, so hang on just a second. So I didn't know, did y'all didn't, it's fine if y'all don't have copies of it, but you have the site to it. But looking at it, it does actually look like, in addition to saying, I don't remember, reading right from the case, he says, Milne testified that he did not remember an interview or Green telling him about a murder, stating, quote, I'd be getting high, I don't know. After a break, Milton testified that he did remember telling law enforcement, quote, lies to try to get out of trouble, unquote, and that he would, quote, say anything, unquote. So it sounds like that is pretty close to what we've got.
Well, okay, maybe I have to study it, but I found a case. Now, my understanding of 24-6-613 is it did not change much of our former evidence code. So I'm about to give you a case from 2011, but it is obviously, if you disagree with that, then it should have no application if it doesn't carry forward.
All right, so you just said 623?
24-6-613, if I said 23, I meant prior inconsistent statement.
Okay.
That's what the state is traveling under that.
Yeah.
And then prior or impeached testimony or
Right.
testimony by contradiction. So I found this case, if you don't mind pulling up, or I can email it. Johnson, Johnsson versus State. Your Honor, it's 289 Georgia at 106. It's Division 3. And that is 709 Southeast 2D 768 2011. And I think that it's on point bad for Mr. Williams, but it says over objection, the trial, but we just follow the law. So over objection, the trial court allowed the prosecutor to play the entire tape of an out-of-court police interview of a witness for the state. Johnson urges that particular statements made during that interview, which were inculpatory of Johnson, were inadmissible as prior inconsistent statements because the witness had admitted making them, but testified that he lied to the police. Then it says, however, the fact that the witness admits that he or she made the prior inconsistent pretrial statement does not render it inadmissible. We have rejected that assertion that a prior inconsistent statement is admissible only if the witness denies making the prior statement, but not if he simply disputes the truth of the earlier statement. There is no such denial requirement under, and again, it's I don't want to mislead the court, it's under the former 24-9-83. Then I looked at Cummings, which is cited, which is Cummings versus State, which is 280 Georgia, 831. It's in Division 3. It's a 2000. Now we're way back in 2006. That is actually helpful. It does not support the situation that we have here. In that case, let's see, Division 3.
Yeah, so it looks like in that case, he just like refuses to answer whatsoever.
Exactly, which
Okay.
is really obviously, saying I don't remember, I don't recall, I don't, I may have said something. Those things trigger a prior inconsistent statement. I thought that's what the Green case is that I have to study that the state just cited. But I wanted to bring to your attention that language that I just gave you out of Johnson, I thought right on point and bad for my position, but we just tell the truth. So I want to arm you with it. But then we always look back. We're always taught to look back on the cases cited, and that former case doesn't promote that position.
So it appears to me, and I'm just looking at Cummings right now too, but so it looks like the defendants, appellants now at, the appellate stage are saying, hey, a prior inconsistent statement is admissible only if I deny making the statement, not if I simply say it wasn't true. And the appellate court is saying, no, that's not correct. You don't have to deny it. Even without a denial, it can still come in. That does not mean the flip is true, that the other part, not simply if he disputes the truth, is not a way to get it in.
I agree.
So I mean, you can take a look at Green, but Green seems pretty on all fours. So I'm thinking unless I hear something that either overrules Green or causes me to severely question Green controls. And whether he says, I don't remember, whether he says, I never made the statement, or whether he says, yes, I made the statement, but what is a total lie, all three of those, it appears under our current state of the law, would permit then the introduction of prior inconsistent statements under 613.
Well, I'm going to read with your permission.
Sure, yeah, absolutely.
Yes.
Thank you.
All right. Thank you, Ms. Hilton. That was a helpful use of our break. All right, so with that understanding, are there other specific evidentiary issues we want to consider? Or do we want to just jump right into hashing out some of the evidence?
Your Honor, during the course, the state also looked at the redactions that we had previously discussed with Judge Glanville for the state as it relates to the January 11th, January 28th, February 20th, and February 21st interviews.
Okay.
We do not have any issues with the redactions as is.
Okay, and those redactions being something that the defense and you all have agreed to?
Or it was what was hashed out during
the state of it. Okay, so were those hashings out done prior to or after the recusal motion being filed?
It was done. 3 of them were definitely done after the recusal motion was filed.
Okay. Well, the one done before the recusal motion was filed, we can go with, however, that ultimately ended up being redacted.
Yeah, I'm trying to recall if the other, I know we were in the middle of playing 2 of them during that time period. I just need to confirm when we actually discussed those 2. So January 11th and February 20th, we actually played those interviews before the jury. I believe we played those interviews on Monday, June 17th.
And which would be part of what either needs to get redone or y'all need to make a,
Yes,
come to agreement on.
and we may have started it on Friday, the 14th, whatever that Friday was before. But for the ones that we did discuss during that pendency, the state does not have any issues with those four. As it relates to June 11th, the June 10th interview, there are some we would like to revisit, so.
All right, I'm not sure I follow you.
Okay.
So. What, you say you want to revisit. So I think first it would be helpful to know which ones were hashed out before the recusal motion. And then we can just say that's what we're going with because that was prior to any issue. And therefore we can stay with that. As for anything that was post recusal motion, unless the defense can come to an agreement with y'all about admissibility, we're going to have to redo all of those. So have y'all had discussions yet about, or I mean, I thought y'all wanted to figure out what was actually done and what wasn't.
And I guess maybe I misinterpreted what the court, I thought the court wanted us to figure out whether or not there were some that we wanted to even object to. And so we're saying there wasn't any that were done that we wanted to object to for 4 of them. I don't know if the defense has any, for 4 of the interviews, we have no objection to the current state of the redactions based upon what occurred.
All right.
And so that's what I thought I understood.
Okay, and that was January 11th, January 28th.
February 20th and February 21st.
And so you will let me know which one or ones of those were hashed out before. And that is, status quo on that. For the other 2 or 3, whether they were before or after, y'all are good with what was decided, but I'll have to find out from the defense whether y'all are good with what was decided. And if not, what particularly you want to revisit.
Yes, Your Honor.
Okay. And then there was a 5th one.
For June 10th, there are areas we would want to.
And that has not been gone into with anybody yet. Is that true?
No, we did hash out that one as well.
Oh, you want to revisit that one?
Yes, Your Honor.
Okay. Okay. All right, can anybody from the defense give me anything close to definitive about whether y'all are good or want to revisit the evidentiary determinations made as to any of those?
Keith Adams?
And
sure.
respectfully, and I'm not trying to belabor the point, but I just need to make a record. Our stance is that our trial judge was not an impartial.
I understand.
And so we don't believe that the issues are just limited to post-serving the recusal motion at this time.
Okay.
So
well,
that's, and we understand.
I am not going to be going back and revisiting evidentiary rulings made before then.
I understand. And I just need to say that.
But yes, for the record, I understand.
This is a very difficult task. I was I think we all were very involved in the negotiations and reviewing of these things. But, as we were doing it, I wasn't taking notes of what I was doing. So I'm trying to put together what exactly was discussed. And part of the problem is we don't have a transcript.
Well, I've got some of the transcripts, but not all of them. So if it would be helpful to y'all to have the transcripts of when the jury's out and y'all are going through, we don't have all of them yet, but I've got certain days. So y'all did that like on the 18th, the 20th, and the 21st, and the 24th. And the 25th and the 26th.
Yes.
Okay. Which is why I want to use this week to the extent possible to not take 1, 2, 3, 4, 5, 6 different days to do that. Okay, so I'll see what we already have and get that out to y'all. And again, y'all, this is all rough. This isn't official, but it looks pretty clean to me.
And there were extensive emails that went back and forth from myself and other defense attorneys
Melnick.
with Ms. Hilton mostly
Okay.
regarding these kind of negotiations
Okay.
where we agreed and didn't agree at the time.
Okay.
So I'm trying to check my emails to
Yeah.
make sure I have.
So
all
y'all
of them.
have those or should have those, so.
And that would be a good starting point. I'm just making sure that what I have is accurate to what she has.
Okay.
I'm sorry I don't have a better answer for you.
Okay.
Keith Adams on behalf of Mr. Williams. Let me kind of echo what Mr. Schardt just said. It wasn't very involved, and I'll be candid with the court. I have several boxes, and one of those boxes contains my notes. It got to the point where Ms. Hilton and I were kind of back and forth in court on the day of and sending emails. I don't have those with me. I think what Mr. Schardt is saying, and if he's not saying it, I'll say it, that we really need some time to kind of get all that together.
All right, y'all.
Yeah.
When I met with y'all, when was that? Friday, a week and a half ago? And said, okay,
Defense is
here's
in
how we're
trouble.
gonna move forward. And then gave y'all 10 days or so to, before we had our Tuesday, hey, we're doing motions now, and then we're gonna move to evidence. Y'all should have used that 10 days to be doing this because we literally
Sorry.
talked at that time about
Sorry, we had to look
we're
at
gonna
new
need to go back
transcripts we got
through some
yesterday.
of Mr. Copeland's evidence, and we're certainly going to have to reach what hadn't been reached before. So I know I can't reverse this all back to 10 or 11 or 12 days ago and have y'all then make better use of your time up until now, but y'all, that's what I meant when I said we're going to be doing the evidence this week. So y'all may have a really long night tonight. I do not want tomorrow to be as unproductive as today. And yes, it will help when you have transcripts. And so to the extent I can, will get transcripts out to you as I get them. But with regard to discussions y'all were already having amongst each other, it wasn't that long ago. So.
Seems like it was.
Okay. All right, so how about another witness? If we can't work on Mr. Copeland right now, is there some other witness that we know is going to also have a lot of evidence that is going to be contentious?
Mr. Zachary. Sorry, Mr. Zachary.
Your Honor, Mr. Zachary, there are other witnesses.
Okay.
We've not gone over, well, we have turned over the statements that Mr. Zachary has made.
All right.
The police that we intend, if necessary, to use for impeachment purposes.
Okay.
There have been no motions in limine regarding any portions of those statements, as we don't know what, Mr. Zachary has not yet testified. And, we would hope that he be truthful and consistent, but we don't know what he's gonna do.
Okay, so for a whole lot of this, I mean, y'all can't really, let's assume that he testifies, let's assume for everybody who there might be impeachment or other evidentially challenging evidence out there, that they are going to testify in a way that is going to force y'all or permit y'all to use whatever it is. And then the other party assume, Well, let me look at, all of this is going to come in if I don't object. What do I think I have a legitimate objection to? And then bring that to me. And I know it'll all be hypothetical right now, but that's what motions in limine are. As to evidentiary issues we think are likely to come up at trial. And then we will go ahead and hash those out. So yes, obviously it's a contingent ruling, but if y'all as the defense have Mr. Zachary's statements and have taken a look at them and know what you think is going to be potentially objectionable, if y'all want to give me those statements, make those objections, I'll hear a response and then we can try to get through that. That would be great.
And would the court, is the court asking for a copy of each of his statements? Because we can't provide that.
Yeah, because I mean, I'm going to need those if I'm going to make rulings. So yes. And I know in this day and age, almost everything is a video statement. I also know that for Mr. Copeland, when y'all were litigating the evidentiary issues, you had transcripts available, and that would be immensely helpful. It is a whole lot faster because a lot of the statements aren't going to be anything anybody has an issue with, or you're going to have agreed that's not relevant, it's going out. If you can say that's on page 7 lines, whatever, I can go right to that instead of listening through 5 minutes of that before I get to page 7. So I would love transcripts to the extent we have them. And then of course, if in court, I need to, for a particular reason, watch and listen to the video that is the relevant, cogent part, I of course will. But as to, you know, a 5-hour video when there are 20 minutes that are really at issue, if we can hone in on the 20 minutes via a transcript, that would be ideal. Okay, so is anybody ready to go on Mr. Zachary? Anybody?
Did you guys like the motion in limine definition?
Does everybody have Mr. Zachary's statements?
Yes.
Okay.
This is fine. All right, I'll take the hit here.
They do keep sending you up here to be the one.
That's okay. I'll take the hit. So there are thousands and thousands of pages, and probably thousands of pages of transcripts. So we have a digital copy. I'm sure someone has the full discovery here, but we all have printed out copies of his statements. I know my copy
But y'all
has.
are all old like me and you like paper.
And because we have our notes on the paper too, and so
Yeah.
I didn't know that Zachary's statements were going to be on the agenda for today, so
Yeah.
I didn't bring the transcripts with all my
Yeah,
notes.
I mean, they shouldn't have been on the agenda because Kenneth Copeland was the agenda today, but.
Understand.
Okay, yeah, I hear you. You're not ready, but you can be ready soon. So when you say thousands of pages, do you mean period or thousands of pages for Mr. Zachary?
Mr. Zachary, to my recollection, has at least 2, I believe maybe 3 statements.
Okay.
And I'm estimating here, I would say a total of about 9 hours of
Okay.
talking.
All right. Has the state determined whether, so I know, like, for example, for Kenneth Copeland's jail calls, I think you had 11, but you said we're only interested in 6 of them. Have y'all done that type of winnowing for Mr. Zachary and the other witnesses that you're going to be getting to soon?
We have been, not entirely, as the court said, down. We have identified jail calls of particular, not witnesses, but defendants that we intended to use. And when the court says particular witnesses.
I mean, Mr. Zachary is a witness, right?
But I don't believe that we have any jail calls from Quindarius Zachary.
Oh, no, I was just using that as an example of winnowing. I'm not asking about jail calls from Mr. Zachary. I'm asking about whatever you think you might use with Mr. Zachary. If there are 3 statements for instance, do you intend to use the entirety of all three statements? And if not, could you pinpoint for the defense what portions of those statements you intend to use so that if they have an objection to something you're not going to use, they don't even need to look at that because you don't intend to use it. So you can say, here's the portions we think we want to use, and then they can say, only look at those. Here are the objections we have.
Yes, I can do that. I have not broken it apart by
Okay.
segment scientific as I wasn't yet.
At him. I don't know when he's going to come in, but all right. So as a part of all of the work y'all are going to be doing before the 5th, that's going to be part of what you need to do.
They're all
And
like,
not just for him, just so that.
No, yeah, for everybody, for your next 30 witnesses, and then for your next 30 after that.
And so if, not trying to tell the court how to use the court's time, but if during.
I'm open to suggestions since what I've come up with so far isn't working.
What I can do, what we can do as a prosecution team, over the next however amount of time the court wishes to allow us is to identify with respect to each of the witnesses that are co-conspirators. I believe, I know that there are several. We can, and that it will be coming up in the next batch of 30 witnesses. So we can identify, just to the court and the defense, those people.
this
And
microphone.
begin looking at the portions of their statements, their respective statements, that we would anticipate needing to use as opposed to using the whole.
Okay.
And so we should be able, over whatever amount of time the court gives us from here forward today, to go through and come back today with a chunk of statements for each of those people.
Okay.
If not all of them.
Okay.
Some of them.
I like what I'm hearing there, that by the end of today, she have done that for all of them. Yes, I like that. Yes,
I said it, so
you did say it.
You know, there we go. But I overshot.
You might have overshot. All right, well, hey, if you can even do it for one, that'll give us something to work on. And I thought you said you could do that before the end of today.
Yes, they did,
Okay,
LaDonna.
So, anyone, are we ready on anything right now?
It's not anything.
It's not anything we can go forward with, but Judge Glanville had given me, on behalf of Mr. Nichols, a continuing objection to the admission of any of these statements, in that they have absolutely nothing to do with Mr. Nichols. So I have a continuing objection to the admission of these statements.
All right.
I have a continuing objection, which has been preserved by Judge Glanville, with regard to both the alleged co-conspirators exceptions and any of the contained so-called statements that were made by Mr. Copeland or the other alleged witnesses that the state has called. Last year, we had motions pending with regard to 801D2E issues, co-conspirator statements issues. The court indicated that, well, it required the state to provide to the defense all of the 801D2E statements that the state contended it would seek to admit during the course of the trial.
Okay.
That notice was filed on or about, by the state, on or about, excuse me, November 3rd of last year, obviously. Couldn't be this year yet, although it feels like it. that state's supplement to state's motion to introduce co-conspirator statements and notice of intent to introduce the same, they only noticed three statements. So anything else that they do now after a year, after 19 months, after a specific motion, after specific requests by every single defendant so that we could hash this out. A year ago, they gave us three. So I'm going to object to any other alleged co-conspirator statements that the state seeks to admit under 801 D2E.
Okay, understood.
So I want to get that on the record. And finally, this is prejudicial misjoinder. There's such a spillover effect as to Mr. Nichols. I had an ongoing motion to sever.
Right.
That I want to reallege and reaffirm.
And Mr. Nichols is charged with count one, the gang count.
Yes, that's correct.
Okay. Do you want to, I think I invited you previously to, but if not, invite you now to provide me a proposed 105 limiting instruction, and I'll take that under consideration.
Sure.
And I'll do that for, I know that all 6 of the defendants here are charged in count one, the RICO count. And then other than that, there seem to be sort of 8 or so independent, or not independent, but different acts or sets of acts that some people are charged with 1 or 2, some people are, charged with another set. And yeah, I mean, the people that are not charged with Mr. Thomas's murder might want some sort of instruction that says, other than the gang count, other than the RICO count, this doesn't go to this defendant. So I'm happy to consider some instruction if y'all want to provide me something to consider.
I will provide you with that. Whether you ultimately do that or not,
I don't know. I'll hear from both sides. But
yeah. It's what we've been arguing about the whole time and what I've preserved going forward.
Sure.
All right. So we'll get you that as soon as possible.
Okay. Now, as to the first point you raised, that only 3 statements were identified in the November notice filing by the state as co-conspirator statements that the state had identified as intending to admit. What does the state have more than that now? And if so, tell me why those should come in despite not being included in the November notice.
So, Your Honor, the November notice of 2022.
2022?
We provided 2 801 D2E notices.
Okay, so is one of them November 3rd of 2023 as?
Yes.
Okay.
Yes.
And then you're saying there's another one?
Yes, that's November, that was filed on November 30th of 2022.
Okay. And give me a second, Laura.
Well, one thing I've been waiting to say is if they knew that there was travel and they might not be able to call
Judge.
Woody,
In
they should have been prepared
2022
earlier.
notice, we stated that the state will establish the ongoing conspiracy of the YSL criminal street gang at trial, and any statements made between co-conspirators in the YSL criminal street gang conspiracy that were made in furtherance of the conspiracy are admissible, and we request the court grant the state's motion to permit these admissible statements at trial. What we've seen come up, for instance, during jail recordings, there are persons who are not indicted under this indictment as a co-conspirator. that make statements to either a witness or a defendant currently on trial, or in the presence of a defendant currently on trial, that the defense has alleged the statements are therefore inadmissible, despite the fact that they come within the context of a jail recording that arguably is admissible, that the statements of a particular party are not admissible. Instances like that, we argue, are instances that involve co-conspirator statements.
Okay, so not arguing broadly, conceptually, but arguing as to specific statements. What notice does the defense have of specific statements that are not included in the November 3rd, 2023 notice?
Tell us.
Because it's one thing to say broadly, hey, if there are co-conspirator statements, we intend to use them. It's another to say, and here are the ones we intend to use. And if the court had ordered, you need to tell the defense which of these you intend to use, then it's time to get down to specifics.
Yes, Your Honor. So in this particular notice, we did provide
Sorry, when you say in this particular notice, which notice?
the November 6, 2023 notice.
Okay. November 6th. November 3rd?
Yeah, I was like, wait.
It's just, he said it wrong.
It's filed.
November, okay. You provided notice of 3 different statements.
Right, 3
Right?
specific ones.
Okay.
Yes.
Right?
Yes.
All right, so my question is, are there other statements besides those 3 that you believe are admissible in the trial of this case as to any witness?
There are, just one moment.
All right.
And so that we are clear, because there's a difference of opinion. So does the court mean out of all of the jail recordings, out of all of the wiretap recordings, out of any recording that we had, which of those contain arguably co-conspirator statements?
Yes.
There are many. There are many that are included in the.
All right, I have yet to find the notice that y'all are talking about.
The November 6th one? We can
Yeah,
send it to
because
the
y'all,
court.
there are a lot of filings
We can
in
send it
this
to the court.
case. But Ms. Persefield has saved it for me somewhere, but there are already a lot of things in our file also.
We'll
so.
send it to the court and to counsel for defense.
Laura, what's it called? Where do I find it?
Yeah, what's going on with this mic?
Is emailing it to me because I need lots of assistance. Thank you, Laura.
Yeah, that's weird. What's going on with the... Is that the court clerk? The one in the gray white sweater on the far side? Like, is she mic'd up? Because that's Laura, right?
And so was there an order at some point or a direction from the judge to tell the defense
It was not me.
statements you believed to be co-conspirator statements that led to this supplement?
Yes.
Yes, okay.
I'm looking for.
Okay, I mean, if there was, that's all I need to know. So yes, so, okay, now tell me what other statements you believe to be co-conspirator statements and why they should come in now when you were ordered many, many months ago to tell the defense what they were.
They are included as part of the jail calls and the wiretap.
Okay, so they have them.
Yes.
They just haven't been identified as, hey, we think this is a co-conspirator statement, we intend to use it.
Yes.
Okay, well, sure. Well, I mean, I shouldn't say sure. Sure, you can try to, whether you're successful or not, I don't know.
I understood. So when they say they've been provided, they have not been identified in any way, shape, or form. There are thousands
Yeah.
of jail calls involving dozens of people.
Yeah.
There are about 3,000.
I think you've said enough. I understand. Them provided in discovery, not identified as here are what we believe to be co-conspirator statements. Thank you. That was kind of what I thought when she said you have them in discovery. All right. So I would imagine that the discovery in this case is beyond voluminous. And at some point in a trial in this day and age, you know, how it's supposed to not be trial by ambush anymore. It's supposed to not be trial by ambush. And I'm not saying you're trying to ambush, but at least as of now, really well before now, you should have identified. I think this is a co-conspirator statement. And honestly, you should have identified out of the God knows how many rooms full of boxes of discovery, here's what we're actually going to use. So to the extent you haven't done that, I've already told you you're going to be doing that by telling us very specifically as to each witness, here's the evidence I intend to use. But that's still weeks down the road. So if you know, well, let me put it this way. Whatever co-conspirator statement you know of right now, let's stand up and let's share it with the rest of the people here so that they can then,
They're on the spot.
tonight,
Tell them now.
look at it and say, here's why it's not. Okay? And for anything that you don't know of right now, you need to go home tonight and huddle together and figure out what else there might be. And I will consider whether I'm going to let that in or not. And then if I do, potentially, we'll have to hear as to each of the alleged co-conspirators why it is that you either have or can establish through admissible evidence that they are in fact a co-conspirator, or not in fact. That'll be for the jury to determine, but there's a preponderance from which I can determine. Okay? All right, so who do you know
She's giving
of
law
right
class. She's teaching them.
Yeah, cool. Give me 1 second, I'm reviewing.
Okay. She said, give me 1 second. But yeah, I mean, I know it's a big courtroom and there are a lot of us, so we all need to try to remember to speak into the mics. So maybe the state can, and you're pretty loud, Miss Love, but maybe pull that mic down so it's a little closer to all of y'all.
And so that the court knows what I'm doing, I overheated. And so I had to.
By which you mean your laptop overheat.
I do mean my laptop. And I was.
Because I've told y'all not to overheat anymore.
So that's what's
okay
happening.
Your Honor,
Yes, sir.
while she's waiting for that to
Sure.
come up, could I just briefly address a side issue?
Sure.
When we met for the status conference, I
Yes.
believe Mr. Harvey asked you if you would support us when other
Yes,
judges try to
I
drag
recall
us in.
that. And you know what? Immediately thereafter, that very night, a federal judge reached out to me and said, oh, I'd like Mr. Harvey for trial. And I said, no, you can't have him. So
Thank you so much, Your
Yeah,
Honor. But one thing that wasn't clear, or maybe I misunderstood it. You talked about when we say take a 1 week break, that if someone wants to call you in for motions, perhaps, they can do that. So you were referencing that week last week where we were out and why we weren't working to prepare for this.
Right.
I was being called into court all over the state of Georgia.
Sure, I'd imagine.
And maybe that was my fault because I wasn't clear whether you would support us if I told those judges, no, I'm in trial. Because we did have a lot of preparation to do for this week. But unfortunately, I was hauled over all over the state.
Right, and we didn't really talk about that.
Yeah, are you going to cover us for that as well so that we can work on this trial during those breaks?
Because, I mean, we may just have to decide that on a break by break kind of thing. Because I, for the last 19 months, have been one of those judges wanting several of you in court for cases pending before me on my other docket. I don't want to blanket say anytime we're not here working on the case, I'm still going to protect y'all, as it were. And frankly, I'm sure that all of y'all would like some time to be able to go represent your other clients in court as well.
Absolutely, Your Honor.
So, you know, why don't we take that up kind of as we need to?
Okay.
And if we are not in court, like, I mean, I hope that we will get into a rhythm if this case proceeds to continuation of trial, where we can have enough done that we can say go Monday through Thursday hard and take Fridays off, or take Friday mornings for motions and Friday afternoons off or something, but like a schedule so that y'all know if you are not prepping for the main witness in the case the next morning, that you can go to court and do some of your other representation.
That would be wonderful, Your Honor.
Yeah.
At least speaking for,
but
for myself.
I mean, let's raise it with me when you need to, but I can't give you a blanket answer right now.
Thank you.
All right.
Now, part of that is because they don't want days where they're not available to count against them. Okay, that's definitely the judge's mic with all the paper. Oh my gosh. So thank you again, Julio Suave. I am not a lawyer. I am not a paralegal. I just like having a chat, being able to talk about issues like this. I do try to read and learn things that I'm not familiar with and pass it on when I can. I appreciate your super chat. It took a long time to get it up on screen.
How long are you going to need? 2 minutes, 10 minutes, 1 minute? Okay.
And then I saw earlier, Bad Sinoika said about the transcript, they knew they were on the record, so they had to make it appear for this exact reason, that their concern was for the witness. They were manipulating the record, and the judge knew that. I agree. And I think, I don't know how Whitaker wouldn't see it.
Your Honor, we're going to allow Mr. Atkins to stand up and give to the court the cause that we have identified within the wiretap that contain co-conspirator statements.
Okay.
One of the wiretaps.
Of course they're making Atkins do it. They're giving him permission.
One of the wiretaps.
And Your Honor, this wiretap is it's a 6,000 page PDF where you can open up audio links. It has the date, the time.
Okay.
90% of them have what they call reference numbers, where while they're watching the wiretap, they'll give it its own 4-digit identifier.
Okay.
Every now and then the reference number will just say 0. I don't know why. So I think what makes the most sense for purposes of getting, I wanted for the defense to know where this specific audio is. I'm going to give, for most of these, I have the reference number, the date, the time, and sometimes I also have the PDF page on that document. So that's how I'm going to reference it for all parties to speak off the same sheet of music.
Okay. Give me a ballpark before you do that of how many there are.
Yes, Your Honor. Let me count these up.
I'm ballpark. 5, 20, 100.
More, they will be closer to 50 to 100.
Okay, so instead of standing there and reading them all, do you have them in writing?
I do. With what I can do is take, a lot of these have notes like next to them of things that stood out. And so what I can do is create a document
didn't
that has the
prepare
date,
something for
time,
the court.
reference number.
I would
and
think that would be
PDF
easier
page.
for everybody than making sure they write it all down correctly. Tell me this, what witness is this a wiretap of?
So, Your Honor, there's 2 wiretaps. The specific one I was going to start with
Okay.
is Demekion Garlington, who is a
Okay.
severed co-defendant.
Right, okay.
And I believe almost the entirety of these wiretaps will come in through Detective Viverito, Atlanta Police Department gang detective, who I think is probably ballpark 50 plus witnesses down the road.
Okay.
For this particular portion.
Okay, all right. So there are going to be a series of alleged co-conspirator statements that are in the wiretap of Garlington. I think, I would imagine that the state could speak to me right now about what it is that you will use to establish that Garlington is a co-conspirator. You, Mr. Atkins, will put together the list of all of the details, and you will email that to all of the defense attorneys and the court today.
Yes, Your Honor.
And we can maybe do the litigation of that, maybe that week in August. So I will need at least the portion of the statements that is at issue as well.
Yes, Your Honor.
Okay, so that is one set of co-conspirator statements. You mentioned another wiretap of someone else.
Correct. Of Mr. Sumlin,
And
who is
is-
also, he has pled guilty, but he was one of
Okay.
the 28 indicted defendants in this.
So you've done your proffer for that one. That one will be easy if he pled guilty.
Yes, Your Honor. Yes, Your
All
Honor.
right, Sumlin. And there are, you can do the same for him.
Correct.
Okay,
And
perfect.
he has less, it's hard for me to ballpark the number.
That's fine. I just was like, if it's 2, you can read them out, but if it's some huge chain, then it's easier to just give them in writing.
Yes, Your Honor.
Okay, all right. So that is 2 further potential co-conspirators who have statements we will need to litigate. Whom else?
Your Honor, we have an additional co-conspirator statement from Mr. Copeland, a jail call.
Okay.
That's a part of the 5,
Jail calls?
about a
Okay.
portion of the 5 jail calls.
All right, hang on. Is that a surprise to anybody? Do I need to do a back and forth about whether it's fair for that to come in? Okay, that was part of the notice, so that one's good.
I don't think it's a part of notice, but
They don't think that was part of the notice, but they're willing for y'all to say that's good.
but there was just a portion of that call that the defense objected to, but we can talk about that.
Okay, and, all right, well, y'all have already been litigating that, so I'm gonna call that one good in terms of notice. Whom else? All right, question. So I'm looking at this November 2023 notice, and at this stage, when it was filed, they're talking about witness A. Y'all all know who is referred to in each of those at this point? Okay.
Yes.
Okay.
We
we filed a supplement that wasn't filed. We gave to them.
Okay.
Witness A.
All right. All right. Can you provide to this judge whatever that supplement was so that I know?
Yes.
Thank you. Do y'all, deputies, do you know whether lunch is here yet for the, okay, why don't we break for lunch? Be back at, how long, practically speaking, do y'all actually need to get everybody fed and restroom breaks and back? Hour and 15? Okay, let's break until 1:15.
This is a quick question.
Yep.
I can't, I'm having a hard time finding a statute on recusal that says you're not allowed to say the truth of what happened to the judge. I can't find that.
Okay,
I'll look for that. I'll look for that.
during lunch.
Our reference where it said that you can't use.
Okay.
the matter of the review.
That'll be great.
Thank you.
Thank you. All right, we're in recess. Let's say till
Alrighty.
1:20 since we've already eaten up like 5 minutes.
Okay, so it's going to be a hour 25 break.
And Your Honor, are we looking for, I apologize for.
No, give us the mic. What was she saying?
All of them, when the court had asked me earlier, whether in all of the jail calls, all of the wiretaps, all of the recordings.
Yes, at this stage of the game, we need to give notice to the defense of every potential co-conspirator statement. And if in the afternoon you can do essentially what Mr. Atkins just did, it's going to be this set of statements, you know, and we'll give you the details of where to find it later. That's fine. But yeah, it's going to be this witness, that witness, and the other witness in these statements as to each of them. Yes, because A, they need to know at this point, and B, we need to know what we need to litigate at this point. Okay. So yes, thank you. All right, in recess.
Wait, is that someone arguing, talking, or just chatter? Okay, it sounds like chatter. It's like you can't tell when they're actually going to cool it out and not have someone speak and they're actually going to be on break. Like they keep getting cut off and coming back. So I'm going to keep the sound on because who knows, we'll turn it down a little so where there's not the dead space. But why do you think Love waited till the last minute right before we're about to go out on break to blurt out like, oh wait, that thing. And the judge has to say again, we want a list of all of the co-conspirator statements you plan to introduce. And then earlier, before that, we're going to give Atkins permission to tell you the statements that we want to introduce from some of the wiretaps. Then he gets up there. Whitaker, do you have a list? Well, yes, but it's my notes. It's not a list. That's your document that you've gone and notated to use in your own case, but not anything that indicates you were ever prepared to disclose, turn over, put into discovery, something that was digestible and not buried in terabytes and terabytes of data, let alone a 6,000-page PDF for the defense to go through and know what wiretaps they should be looking at and preparing for so they can be prepared to argue admissibility if they're being played in court, to be ready to ask their questions when appropriate. It doesn't make sense. And then they drop the ultimate bomb that this is for one witness that we plan to call 50 witnesses away. So the one example we're able to sort of give you, pretend that we have a list for, is something that we aren't trying to bring into court right now. which means anything we do in the short term could still be an ambush to the defense, but we tried to at least give you one example of something down the road. That's my summary of what just happened in the last like 35, 40 minutes there. Like, it's the same thing. I don't think that the judge isn't seeing what's happening. I don't know if she's going to lay down the gavel, and not the gavel, but lay down the hammer and say, look, this can't just go on like this. This isn't the way to do things. And because of that, you're not going to be able to bring this thing in. You lost your chance. Maybe we'll get to that point. That would be nice. But I don't know. So they're on break until 1:20. It looks like she shaved 5 minutes off of, or maybe she was going to do an hour and a half, hour 25. I don't know. But she's trying to cut some time there. Catch up on a few comments, and I'm going to take a short break myself too. I'll just leave the screen on like 15 minutes. So we can all come back. What do you got? This is huge too. So Praying Grammy Pammy says, what about interlocutory appeal? I thought they said they could come back. Is it premature? I think they're waiting for the outstanding motions to be denied. And that's what I'm saying. If we get to that today, I don't know if we will. Look to see if the defense asks for that right away. And then guys, keep it together in the chat. I'm seeing a little bit of back and forth. Make sure you keep it together. Don't break the YouTube terms and conditions on me. The house of cards is crumbling. Yeah, destined to be. She's not going to have the information. If we do get information, it's because she's going to make Atkins do it. Which is fine to divvy up tasks among your team. But when she announces that she finally has something, she's probably going to make it seem like she didn't have it because Atkins wasn't ready for it and it's his fault or something. She's never going to present it as if she was supposed to be ready and failed to be ready. Yeah, not understanding what the court's asking to do. This isn't rocket science. I think like 3 times today we got some education from Judge Whitaker about, hey, look, we're not supposed to be doing motions in limine in that way. Motions in limine are supposed to be kind of guesses, hypotheticals about what may come in, so you can sort it out in advance and not waste the jury's time, not kind of mess up and not be able to put the toothpaste back in the tube while the jury's seated and something that could have been prevented from coming in accidentally comes in. That's how motions in limine are supposed to work. That's how they're supposed to be used. State doesn't understand that. Judge Whitaker had to lay that out. Like, it's just a lot. It's a lot. I think it is great for the defense, especially when there's 6 defense attorneys that can, kind of tackle each of these, their specialties. One can look at the wiretaps. One can deal with this new transcript that came out. All of that. And then, yeah, I totally think Hilton's going to pin it on Atkins. Let's do... I don't need much time. I didn't eat yesterday during the stream, and it was fine. And then as soon as I was done, I was like, I was really hungry. I should have eaten something earlier. So I'm going to take a 15-minute break. I'll leave this on. You guys can hang out in the chat. I'll be back. See you then. We'll talk some more. I'm back, you guys. Hope everybody had a chance to enjoy their comfort or convenience break. We can call it whatever we want. We have some time to kill. So I was going to check if there were new motions, see if anyone, I don't think that anyone filed anything randomly right now, but sometimes it gets posted in like mid-afternoon like this. So we'll see if there's anything new to talk about. While I was gone, Rick Reese, and I feel bad you sent this while I was gone, but thank you so much, a $49.99 super chat. That's so nice. You say you're a godsend. Thank you. I appreciate that so much. I hope you're still in the chat. If I don't see you, I'm going to say thank you again if I see you pop back in after lunch. And then Will Bowman had also become a member. And then Big Tit, don't make me say that. I got to read your name on stream. So Big Tit says, so Glanville breaks were for the state to prep. You know, that's a good point. They could have been. He might have also really needed comfort breaks, maybe because of the dog. Maybe the dog would need to go outside. I don't know. But it's a good point that these breaks could be exactly for that. So thank you so much again, Rick Reese. Let's see if there's any new documents. If not, what else might you guys want to look at? Oh, I'm sorry. I'm sorry. Just coming in here roaring like, oh, I'm back, everybody. My bad. My bad. So see, I see Classy Beats in the chat. Did you I saw you were streaming earlier. Did you wrap it up? If you want to jump up here for a bit, let me know. I'll drop a link. You can tell me what you think about the morning half. Like screaming at you guys. Sorry. Yeah, and I don't know. Yeah. I know what that's like. I know what that's like. Usually not with the streams. But, like, right now, one of my clients, I knew it was going to happen. Take Tuesday off because I want to do this during the day and I want to do it live. Had all my work done anyway. It shouldn't be a big deal. The terms I give any clients are, look, I'm a flexible schedule. And that's how it should be when you're 1099, right? You're not supposed to control my work schedule. So tell them all of that. When I tell you I've gotten more calls, inquiries, emails through the day yesterday from one of my clients than ever before. And then today the same thing's happening. So I'm running out of gas because of that. Not because of these streams, but I'm losing my cool with that over there. They do a lot of Zooms and those Zooms get exhausting. But if you do want to jump up, let me know. Drop you a link. And guys, Classy Beats, because you guys know, I like to cover motions. I don't really cover regular trial days. I'm usually in the chat somewhere else watching that. Let me find Classy Beats. But Classy Beats has more YSL content. You guys should check it out. So that's the link there. I do a lot of, I call it hybrid marketing because what I help companies do, small startup companies, is one, get started, launch. I work with a lot of course creators and people in the data space. So in the real estate space, it's usually companies that do a multitude of services. So they do the education for the agents. They do the marketing. They do data procurement. So I go in and I work with companies while they're smaller and they need someone to sit in a role that wears a lot of hats. I can help people build their CRMs. I can set up marketing drips. I can help build their content strategy from the ground up and really get them to a point where they're getting organic growth. They're building a community and they can kind of like launch on their own, be a free bird and kind of just grow and snowball from there. So one of the clients I'm working with right now, they do have a lot of stuff going on because their product, it's Easy Real Estate Offer is the name of the company. Their product is something that solves a lot of the problems presented by the NAR lawsuit, the lawsuit that they're dealing with the DOJ. So there's a ton going on there. I put in like 40 hours a week for them. So it's basically a full-time job. And like, I just told them I just wanted 2 days. These are my 2 days where I'm not available during the daytime. And they're like, oh, cool. Hold on, wait a minute. But you guys know how that goes. That's exactly how it goes. As soon as there's actually a joke in real estate for realtors. If you want to get someone to tell you they want help selling their house, that's a listing. You want that because that's how you earn your money. If you want to get listings, if you want to get more work, more clients, the trick is to go on a vacation. Because the second you go on a vacation, your phone's blowing up, you're stuck at your laptop, you're out on like a floaty by the pool doing work. Like, it's just how it goes. Just how, you know, you get more business right when you try to take time off. But it's not a big deal. It's just, I feel bad when I'm like, look, you're not my priority today. I've got a chat I'm leaving alone for 15 minutes and I want to talk to them about YSL and Judge Whitaker versus Judge Glanville. Oh, cool. So Nancelot says, I used to set up small businesses for people. The licensing, setup, marketing, the market and such. I hate the licensing part. Kudos to you. I know it's pretty simple, right? You know, how do you want to be licensed? How do you want to be structured? File it appropriately. But that stuff is so boring to me. So you do a great thing, because that's not my cup of tea at all. And look, you guys are so supportive. Appreciate you guys. And no mistrial yet. I shouldn't even say yet. It's not off the table, but you know, might not be on the table. For anyone that might have joined midday, I'm going to drop this link one more time. This is a new motion. Not a motion, a supplement by Doug Weinstein. And at the bottom, it has the transcript from the June 17th ex parte meeting that we only found out about yesterday. So there's the document for you. We read it earlier in the stream. I've been checking for, you know, any updates on X, if something's going on in the court that isn't on camera. I don't really see anything. And I guess, I don't know if you guys want to talk about another case. We've got like 50 minutes, 5-0. Did you guys pay attention to the Ashley Benefield case that just got the verdict yesterday, the misdemeanor manslaughter verdict? Because that was a little bit interesting. I'll wait to see if anyone's tuning in, but I have some thoughts about deliberations. And then I want to see if I missed something in the chat here. So that girl Mia is, when did Kayla do that? I'm so behind. Because are you guys mentioning, are you thinking about Kayla saying it was Deputy Brown that went to Steele about the ex parte meeting? I don't know if I see the initial conversation. Okay, there we go. Yep. So it was a deputy. And I had actually, I'm glad you said that, because I had pinned this comment earlier because they were arguing I didn't want to talk over it. So this is from 11:53, like 40 minutes ago. SK George had said, Kat, I was thinking about what you said as to the deputies watching out. I think in other streams we've kind of speculated a little bit, like who could have told, who was there. And then look at the deputies in the courtroom kind of like looking on as this is going on. So SK George is recalling some of that and saying, yeah, I remember that. But remember when Steele complained that Lil Woody was always surrounded by police in and around the courthouse? And Kayla talked a little bit more on her live stream yesterday about kind of what goes on in the hallways. And you can check that out. She still has the streams up. And I didn't really like digest all of it. But it is a good point to consider, you know, these people that are in the courtroom every day. There's people that might see something and want to say something for good intentions, or maybe out of spite for somebody else on the other side of it. I don't know. So we have this deputy that apparently went and told Brian Steele about the June 10th meeting. It wasn't Melnick, it wasn't Bumpus. So Glanville was wrong about who he thinks that these influencers, these agitators. Where are we? Let's go to this transcript. Glanville was confused. He thought Kayla Bumpus was out here being sneaky. That's why he already thought when Brian Steele made the inquiry, it must have been Kayla Bumpus. Because they had this whole conversation on June 7th where Hilton and Love are saying something about Kayla Bumpus and Melnick doesn't smell right. Doesn't pass the smell test. That's how they characterize this. Doesn't pass the smell test. So Glanville this whole time, and the prosecutors, had such a speculative disdain for Melnick and Bumpus that they assumed the whole time they were the leak. And Brian Steele wasn't going to say it wasn't. He wasn't going to say who it was, though. He wasn't going to tell on anybody. Melnick didn't come out and raise his hand and say it was him. Kayla didn't say it was him or not. Like, Kayla said it wasn't her. Melnick didn't come out and say it was or wasn't him. What if they were letting them go on and on and on to theorize that it was Kayla Bumpus the whole time it was their own deputy? It was a sheriff's deputy. But that means what? You let them sink in further and further that Bumpus was planning to do something. And Bumpus was going and telling Steele about it. Because Bumpus was in the hallway hugging somebody. What else do you think that if Love, Hilton, and Glanville were speaking during this time period, they were probably, you know, when you play telephone, one little ember of a rumor or of a gut feeling that you're so confident is true. Everything else you see, you add extra layers to it that aren't really there. So I wonder if over the next 2 weeks, Glanville and the prosecutors had this whole vision in their head that Melnick and Bumpus were doing something crazy out here. Whole time it was just their deputy that said it. It was just Deputy Brown. Like, it's just wild. It's so wild to think about. Julie, good to see you. Perfect timing, because we're talking about finding out who told Steele about the June 10th ex parte. So, I think here, when I heard that too. So, Mixed Chick Samantha says, I don't know if I believe it because Kayla said on her YouTube that I wasn't the first to say something, but I did tell them everything they needed to know. So, I do have thoughts on what everything they needed to know would mean. I don't know what she knew or what she thought the defense may have needed to know, and we don't know yet. We might hear today if Melnick's able to get up on the stand, or at least if Steele's able to proffer what he wants to ask Melnick about, because Melnick's willing to testify. Steele subpoenaed him. He's available in the courtroom. We might find out exactly what this could pertain to. Because presumably Kayla and Melnick probably know almost the same things at this point. But I wasn't the first to say something. That I do think is true. That's probably referring to Deputy Brown. Because I do think Kayla has mentioned before that she wasn't even in the room. She hadn't even had a chance to, like, physically come up and be present to get Steele to know in time. Something along those lines. So I do believe that she wasn't the first one to say it. And I can't really guess what the missing pieces that maybe she filled Steele in were, but I do think we're going to get to see that at least through a proffer. So I'm really excited to see that. And then, let's see. I always thought a deputy could be possible. I mean, you guys heard me speculate that, maybe Christina Weaver, she felt like what they were doing to Woody was wrong. Maybe she wanted to say something. I don't know. That and one of the investigators. There were also 2 investigators in the room. And Steele had mentioned that an investigator had come by the night before, the day he made the inquiry, to drop off a thumb drive. So I was like, well, maybe an investigator could have had good rapport with Steele. They've probably known each other for many years. If he's worked there for many years, Steele's worked there many years. Maybe the investigator was one of the investigators in the ex parte meeting and kind of said, hey, look, this happened. It's kind of not gravy, and I feel like I should tell you about it. But I think finding out that it was deputy, to me, it doesn't matter what deputy it was. Maybe there's a reason the deputy wanted to snitch on the state or on the judge. I don't know. I can't read into that. But bottom line is, I do think it's believable that a deputy was the one that told Steele. I think it's hilarious that this whole time, Glanville and probably the prosecution were adamant in believing that it was Kayla Bumpus that was the mole, just for it to not be her. But, and I don't know if he can be called as a witness or will be. I don't know. It's possible it's easier to call him as a witness if he doesn't really... If he's a deputy that is specifically Glanville's deputy, it wouldn't be such a conflict anymore to call it with now that Glanville's not the judge, so maybe that could come into play. But yeah, I don't know. Positive masculinity, that's what's up. New member, appreciate you. And then Live It In My Truth says, everyone, while we were on break, let's all hit that like button and show support. Thank you so much. Yeah, hit that like button, you guys. And that's okay, you guys. A lot of people thought Kayla was the snitch. And I would say there's a few people that might use the term snitch, but there's also, you know, mole, snitch, whatever. It's just like an easy word to refer to somebody that tells somebody something. But in general, the sentiment was like, oh, I'm glad somebody let them know. Otherwise, we might not ever know. So the sentiment, the connotation was almost always positive when I saw whoever anyone was speculating told. Like, I don't know, I think it was this person, but I'm glad they did. And then let's see. So I'm going to pull up, someone said Kayla has a new video. I'm going to make sure I drop her channel. I don't mind if you guys want to go and head over there and watch it now. I don't, because we're on break anyway. I'm not going to stream snipe and play her thing. I don't see a new video from her right now. Oh, it's alive. Okay, so she's in the courtroom right now. So I will drop that link if you guys want to check that out. I don't mind. She's in the courtroom. I know she said she applied. She wanted to, you know, through Rule 22, get access to stream the actual case, be the camera in the courtroom. And she didn't get it approved yesterday. She's still working on it. Maybe she has an update on that. But right now it looks like she's going to be in the hallway if you guys want to check that out before court resumes. I have no problem with that at all. But yeah, so every right to say something. Yeah, okay. Oh my God, thank you, Spot the Live. Whistleblower. Whistleblower. That's definitely the better way to put it. My brain was like, I know there's something else besides mole and snitch. There you go. Look at you guys. Yeah, snitch are doing the right thing. That's exactly it. And then Road Dog says, Kat, Steele asked Brown what took so long and said they were in a meeting, but Kayla told them the substance. Okay, got it. So basically Steele got the confirmation. I really don't think Steele didn't already know who was in that room together, but it's different when you ask somebody and you get confirmation that they're all still in that room together, that it's those people. You know, a lot of this transcript, you heard my criticism of this transcript is they're just speculating. They're taking creative licensing to create and paint an entire picture of what they swear everybody else is doing against them. That's so wrong. Outside agitators, all this influence. Glanville's been tracking it since the beginning of the case. And Steele, rather than looking like he's doing this exact thing, probably already had it in his head, an idea of what was going on, but hey, Deputy Brown, what's going on in there? Oh, yeah, that's what's happening? Yeah, I thought so. But you get it confirmed by somebody else, so you're not the one coming up with the idea or the implication. So that makes sense. That makes good sense. And it's okay if you thought Kayla was the one that did it. A lot of people did. And I think most people meant well with who they were guessing. I don't think most people were like pulling a Glanville and wanting someone to be held in contempt for it. And then Nancelot, I think she would be streaming the same way, sort of like Infamous Sylvia and Law and Crime do. It would be the camera streams. I don't think she could be in the courtroom giving commentary at the same time. But I'm sure she could be in the chat while she's doing it to say like, oh, somebody just made a weird face. I don't know if she could do that or not, but maybe. Yeah, that's true. You just ask, you say something, and I mean, really, it's not on the deputy to keep a secret about something like that. So if I physically with my eyes see people in a room together and then I'm asked, where are those people? Oh, they're in that room together. That's not like a haha whisper, I'm spilling all the secrets that I'm not supposed to share. Yeah, and then it should have been disclosed anyway. Oh wait, I missed the, sorry Classy Beats, I missed you say you're good to join, or I'll drop a link if you want to jump up, Classy Beats. I also understand you said you burnt out a little bit, so no worries either way. That link is for Classy Beats. You can come on up, tell me what you think about morning session. So thank you for the super chat, Mixed Chick. You're like keeping me organized. You didn't have to super chat for that, but thank you so much. Oh, I know. And they didn't really mention her until the end, and then the second they mentioned her, like Weinstein said, they started acting like yentas. Oh my goodness. Oh my gosh, I hope Weinstein does like an interview tonight with somebody. Has anybody heard about any? Oh my gosh. The next Weinstein interview I'm watching, for sure. And I'll share it. If I see Weinstein's gonna do an interview or something, I'll make a community post. I wish today was Monday, because he had a Twitter Spaces. He does the Spaces on Monday. And it would be so interesting. I'm sure he wouldn't be able to speak too much on it, but his partner, they call him Siri, but I think his name is Shada Jimenez. So, but they call him Siri during the call. So when I say his partner, I mean this guy Siri, but I get the names mixed up. It'd be so interesting if their Spaces was tonight after we have this new transcript, this new ex parte. Like, just crazy. Yeah. And then Julie says, Glanville got so pissed and wanted to find out who told because he didn't know what ex parte the defense knew about. That's a good point. Which one? Which one? Because remember, he was willing to hang out Saturday, Sunday, any of the days. And then, yeah, so there's a possibility that the court might not approve her. She said she made it seem like it was just not decided, it wasn't processed or whatever, and that she might know today, but maybe she gave an update on the current video. I'm on here and we'll catch up and try to figure that out once the court day ends today. So I don't know. Yeah, the ethics and the judge's duty to make ethical decisions. I mean, we still gotta wait and see. Again, guys, for me, it's going to come down to the certificate for immediate review. If she's going to deny the outstanding motions for mistrial, will she grant a review? And that girl, Mia, there was a new June 17th ex parte meeting that was only disclosed to the defense yesterday. That's what's on the screen here. The transcript itself is about 12 pages, and Doug Weinstein included it in a supplement to his motion for a mistrial. And the transcript from that Friday is basically Love and Hilton trying to explain that they still can't get Copeland, Lil Woody, to agree to testify. And they don't want to put him in jail. That's absolutely not what they want to do. But they need some solution that they want to work on over the weekend. Judge Glanville says it's our homework. We might need to meet Saturday morning or Saturday night and try to know what to expect on Monday. And the issue that Hilton and Love seem to fix on, and Judge Glanville ends up agreeing, is something doesn't smell right about Attorney Melnick. And then Kayla's also brought in attached to that. Something doesn't sound right about her coming into the picture either. She hugged Diamante Kendrick and Jeffrey Williams in the hallway, which I think is not actually 100% correct. I don't know. Does anyone know if she hugged both of them, or is it just Diamante Kendrick? I think it might have just been Kendrick. So in any case, it's like they're hyperbolizing and adding all these details. They get basic things wrong about the emails. We've seen some incorrect characterization of those emails from the June 10th ex parte transcripts. They do all the same BS again, just on a different day. Same excuses. They want Woody to testify. They don't really have a justification for calling this meeting except that he's not testifying the way we want him to. And we want to make sure he's not going to get up there and not testify. So we did read that in the middle of the stream. When did they take that first break, you guys? Like 10 o'clock? About 10 o'clock? So that would have been about 2 hours and 45 minutes ago. Back in the stream, we read through the whole thing. And I'll share the link again one more time if you guys want to read it as a PDF. Yeah, she did. Kayla defended Love and Hilton. That's a good point. Thanks for the super chat, Jose. So Jose says the official transcripts arrive. That could be when it's a mistrial, right? Like when it's set in stone. I mean, I would think, but we gave a lot of grace. This judge gave a lot of grace to the June 10th transcripts. I mean, the June 7th transcripts kind of underscore that there wasn't really a valid basis for the June 10th either. None of them, they start this meeting, this ex parte meeting on June 7th, saying that there's no worry, no threat to Copeland's life, that he wasn't scared, which is kind of like, well, then what does he need? You're not having this ex parte to protect him. You're not having this ex parte, you're not giving him immunity to protect him. The issue isn't that he's afraid to testify. So these transcripts make all of it look worse, if you ask me, but we've seen a lot of grace given to June 10th. So are we going to give grace to this too, just because? I don't know. I don't know. Oh, is it surfboard? No. So this is, it's just a palm tree. Just my little palm tree. It used to be when I had 2 monitors, I had a monitor burnout and I cannot pick a second one. I don't know if you guys do like channel surfing where you try to pick a show forever and just can't pick one. I do that when I have to buy like a new piece of tech gear. I'm like, I don't know what I want, and I'll research it forever and then never make a decision. So I've never replaced my second monitor, and that's the one that I used to be more cornered. So it used to actually be part of the scene, but now it's just kind of sticking out there on the side. And then let me see, Julie said we have an email. Let me pull that up, Julie. Okay, so I'm going to go to page 18. Oh, wait. What do you mean page 18? Maybe you mean 19, because it kind of looks like 18 down here. Let me see. And that's what I think too. Like, if you were on the fence about the June 10th ex parte meeting, the context of the June 7th transcript absolutely does not help. The context of the emails we know from Melnick absolutely do not help. If Steele is able to proffer today, I'm sure we're going to get more details of things that do not help the argument from the state and the judge that the meeting was entirely proper. So, yeah, laughing at the idea that Melnick said we ain't going to kill him. Love. And then Florida girl, I live in Florida now. I'm originally from New York. That's why I think people hear the accent sometimes. And then Julie, I don't know, maybe page 8. Maybe you meant page 8 instead of page 18. I see Classy Beat popped in. I don't see, it just looks like a white screen. There you go. You just give me a thumbs up when you're ready. We'll bring you in. Are you good to come up, Classy? Hello.
Hey, there she is. I can see you.
How are you?
I'm good. How are you? Thanks for bringing me up. I'm sorry for the delay. For some reason, Chrome didn't want me to join, so I had to switch browsers. I don't know.
That's okay.
Streamlabing sometimes.
Streamlab does its thing sometimes. So Classy Beats, I just dropped your link in the chat, but give an elevator pitch about what you talk about on your channel so people know. Because it's more than just YSL, right?
Yeah, we've been covering a lot of things. Most recently, especially over the past few months, we've been covering a lot that goes on in the music industry, whether that's what's going on with R. Kelly and P. Diddy and Drake versus Kendrick. Most recently, I covered that entire beef that was going on. So we got a lot of stuff that we cover over there. Also have a lot of artists in the community as well. So I host the a music review show for them every Monday,
Oh, that's
Wednesday, and
cool.
Friday night. Yeah, it's a lot of
So
fun.
live? Okay.
Yeah, we do it. Yeah, we do it live. We give away some prizes. Get to hear some dope music from some of the independent
cool.
artists in the community. So yeah, I
Because you come up
appreciate
in
it.
my feed, but I think YouTube
Yeah.
still tailors your content. It's feeding me your YSL content. I don't think it's fed me other stuff that you do. I think the YouTube algorithm is too good at
Yeah.
what it's trying to do. So I didn't know that
Well,
you're doing all that other stuff too. That's cool.
yeah, the past 2 weeks has been mainly YSL content. I've dropped a
It's too
couple of
much.
yeah, Trump and Kamala stuff here and there, but it's mainly been YSL a lot lately. So
I'll say that's endless content too. I think anything politics is going to be endless content because they're always trying to have something stick in the headlines. It just keeps the news cycle going. So
yeah, I'm
how
not
do you-
mad
how
at
do you
it
adjust
as a
having
content creator.
two nonstop things happening in two different categories? I would be burnt out.
Yeah, it's a lot, and I mean, this is the first time I've done this live type of review when it comes to the YSL trial. So it's definitely been a learning curve, but you've done a great job covering it along with a lot of other folks in the community as well.
Thanks. It's been a good time. And again,
Yeah.
as a reminder, I'm not for something like the Courtney Clenny case, especially when we get a length of time estimate on how long they think that trial will take. If it's not like 6 weeks or something, a murder trial doesn't necessarily need to be 6 weeks long. We'll see. But that I might cover every day. But stuff like this, I like covering the motions. I like the documents.
Oh yeah.
I don't know how some people have committed to streaming this all day, like from day one, from the pre-trial
I know,
days.
I
It's
couldn't do
so much. I'm the listener. I love being in the chat for it though.
Well, you did good. I saw you were live for about 8 hours plus yesterday, and I said, man, I don't know if I could make it 8 hours, but
I knew that Whitaker would do a full day. I expected it. So
Yeah.
I wouldn't do that. I wouldn't commit to doing that for every day of a trial for more than a month. Like that's a lot.
yeah, well, I said I'll leave that to the professionals like a TLA or AV, somebody infamous Sylvia, someone like that. We'll make our little video clips here and there and keep it moving.
Yeah, we'll just hang out. We'll
Yeah,
totally just hang
exactly.
out.
Yeah,
But
which
I love
was
the documents. What do you like with cases that aren't televised? Because you had mentioned R. Kelly, and I know one of his was televised, one wasn't. I mean,
Mhm.
do you think that's annoying to cover when suddenly something has no sunshine on it? It's just kind of behind the gate. You got to rely on reports from a news
Yeah.
outlet, and kind of you're the messenger of the messenger.
Yeah, exactly. That's really what you have to do is you have to find some credible, up-to-date news sources. A lot of it is breaking news, or see if you can find certain documents. I know you have Thugger Daily on X, but X has been a huge place for sourcing news when it comes to documents and things like that. So yeah, it gets a little bit more intensive when you're looking for research on that side, but it's so easy to find if you're following the right people, just some solid hard facts. So it's
Yeah, or just-
2044. It's not that bad.
This is what I always tell people. If you want to, raise awareness about a cause, use X, because people go there for time sensitive news coverage, what's happening
Yeah.
right now. And make sure you're using keywords that people will search for. So if you have a really big story you want people to know more about, make sure you're using a word that they can remember to look back up the next time. So a lot of Ashley Benefield, her name was Benefield could be spelled multiple different ways. Some people think it's Benfield, Benefeld. So people were calling it the Black Swan, the ballerina trial. You put those keywords in your tweets, it'll get picked up and people can actually find your news coverage. So always when you have good information to share, put words in there so more people can find it. People like us.
Yeah, exactly. And I mean, it's such a, you really have to stumble across it at some points, because unless it's just one piece of content that you're seeing on X, you can find that piece and then maybe go through the threads and find someone else that's linking to another story.
'Cause
But
the
you kind of have
subsequent
to,
stuff, don't put the same
Yeah.
words in it.
yeah, or you'll go to a thread and there'll be someone posting promotional
Did you
links
see
or
this?
anything like that. Yeah, exactly. So I don't know, it gets weird, but it's still a lot of fun. I enjoy it. I definitely enjoy the process.
Me too. I mean, I do still prefer to be in the chat for a lot of things. I know I
Me
can't
too.
always commit to do things like gavel to gavel, I would never be able to make a commitment for most cases. Some cases are short. They're like 4 days long. That's fine. But like being in the chat, being able to learn, being able to see what other people are saying. That's why I love YouTube. Like I love it for the chat. I started doing YouTube because with the Jonathan Majors case, that just wasn't getting coverage. There were no cameras in that courtroom. So I had looked up some news reports where I was like, wait, there's like evidence that he had injuries, and this is like back in April, right after it happened. And I'm like, nobody was talking about this. So I just started like making little YouTube videos. I don't even think I put my face on it. It was just like me talking over a PowerPoint, like a screen share. And so I didn't expect to have a YouTube channel. I always just liked being in the chat somewhere else, but there was no chat for that. So I was like, okay, I guess I gotta be the one. And then that's how it ended up. Here I am today, which there's other people talking about YSL, but I just like to summarize the motions and get in and get out.
Well, you've done a great job of covering it and grown so fast. And I think you do a good job of not only going through and reading each motion and giving background, but also showing the history of, you know, some of the things you've covered in other cases and what led up to the point we're at in this trial. So it's been interesting for me just from a personal growth standpoint, just all that I've been able to learn, not only from reading through each one of these motions, but from watching you, from watching Infamous Sylvia, from watching TLA and AV. And you pick up so much, especially as we're covering
I'm going to bring you up
every single day.
I do this panel on pronunciation. I'm going to bring you up to be one of my lay people. You'll be on my side. And the attorney.
I'm the worst one. I'm the worst one because I can barely read. Oh man, I can barely read the regular words. I'm gonna struggle on this one, but it'll be. That was a great idea.
It's gotta happen.
It'll be fun.
Because we'll learn.
Shout out
to
the chat too. Yeah,
I love the chat.
We're in here learning.
Okay, wait. Julie was saying something about the transcript, but it's page 12. Okay, let's see. Page 12. Let me get this double share screen thingy.
Yeah, that transcript was crazy. I tried calling Kayla earlier. I had a feeling she'd be busy. I wanted to call her and see if she wanted to give some insight into what she thought about this transcript, but
I know
a lot of shots were taken.
Guys, look for a Kayla stream later today. I mean, she might be talking about it while she's doing her hallway stream. I feel like you'll probably get more casual conversation if she streams about it later tonight. But it seems like she'll be transparent in her thoughts and share what she can share about what she thinks about it. So definitely recommend that. And Julie was referring to this section here where Miss Bumpus is going to stand in his stead. Miss Bumpus what is the word I'm looking for? The sheriff had to speak to her because she was in the courtroom trying to hug Jeffrey Williams. No, she hugged Diamante Kendrick. And then let me double check, because is this the correct part? Julie, this is the part you wanted us to look at?
Yeah, I have to go back and look and see what she said. She said...
I mean, I know Kayla was live. You guys can relay in the chat. I'm going to post the link to her live because I'm not going to stream snipe somebody. And, you know, since I'm doing this, I'm going to watch that after court's over for the day. But...
yeah, so they're saying that who is it? The sheriff was the one who initially leaked everything?
Yeah, Deputy Brown.
Oh, man. That's
But that could
wild.
have been... This could have been a different deputy, right? We don't know if that was Brown. But I think Kayla may have been talking about this yesterday. I might go rewatch her stream from last night. It was about 15 minutes in her late night stream. And I think she mentioned someone coming up to her in the hallway to say something. And I do think she may have known about this transcript, even if she didn't get to see the full thing. Someone probably, if an attorney got handed this, tried to skim through a few pages, maybe saw Kayla in the hallway, maybe discussed it with someone and said, look, you got mentioned here. But didn't get to read all of it, didn't really tell Kayla yet the other parts, and Kayla gets to find the rest of it out today. This part isn't that much shade at Kayla. This is just saying she's going to stand in, but she hugged somebody. So it's a little bit of shade.
Yeah, it's Julie, are you talking about page 12 of the transcript or page 12 of the motion? Because page 12 of the transcript says, Miss Hilton says there's a lot going on. I'm not sure if that's what Julie was talking about.
The presence Let's see.
Yes, yes.
We can read it again anyway, and we'll find out if this is the right part. But there's a lot going on. There is a presence. Yes, yes, that's all I'll say. And then the judge, I mean, I remember all his ums are cut out of this. But it really read like, I mean, but I see it from just being in the courtroom and tracking.
He was a little nervous.
Really slow and read. Like, there's probably a lot of like, should I say this?
Glanville was definitely, you can hear he was holding back some, like, I don't know. But we still think you're on their team, Glanville. You're not going to hide that easily.
100%. I totally think he is. Especially the part about, you know, I know people can communicate with judges on off hours, but he made it seem like, contact me as soon as you find out the thing that we can use to make this happen. Like, he was like eager for them to give him something on a Saturday night. Oh, we got it. We figured out how to do this.
And then you go through later in the transcript and he's like, yeah, I mean, we'll try and figure it out and see what happens. But until then, let's just take a break. And just for Glanville to be so upfront about his willingness to help out the prosecution, it just seems like it's a strike against them in itself. And odd.
Yeah, and this is going back to the Melnick body language, right? That's what Julie is getting at here, is the body language. So
yeah, which I went and I tried to look up the video where he shrugged and turned around. I think the cameraman just missed it. I don't know if you were able to find it. But
she sent another stamp from infamous Sylvia's stream. So let me see what she says. At 444 at 4:44:47. There's a like nationwide attorney that made their phone number 444-4444, and that's like a commercial that just blares that phone number out.
Oh, that's awesome.
Yeah, over on this stream, let me load it before I switch the screen over. And it should be short, you guys, so we'll obviously be able to play this shorter clip before they come back from lunch.
Yeah, they're saying, Amy said, shout out to Amy. She's saying Kayla is reading the transcript and she's hot about it. I knew she would not. She would not be happy about this.
Guys, I'll drop that link again in a second. I don't mind if you guys want to watch that now. Pop back in when we resume court. I'm gonna be replay crew for Kayla's current reading.
Yeah, for sure. Same here. Because, it'll be interesting to hear what she has to say on that one.
I think I'm close to the timestamp. So let me switch over. We'll share this one.
Okay.
Let me make us little. I think is this the little one? You know, StreamYard. Their little icons for what the screen layouts look like kind of don't match what they end up being on the screen sometimes. So.
Yeah, I know. You got to almost make your own custom layout.
And know which one is which.
Yeah, exactly.
Okay, so I see him watching the screen. We're going to start a little bit earlier, 20 seconds earlier than Julie's timestamp. And he is staring down at that screen. And this I remember seeing, but I can't see much.
I remember seeing this too, because there's Melnick at the back, at the top right of the screen, talking to Steele.
And then she just looked. Hilton just looked. I mean, Love just looked.
All right, ladies and gentlemen, please be seated.
Yeah, I missed it.
So I remember seeing that, but I still don't see
the shrug.
Well, I don't see how they could insinuate that they think his shrug was saying something in particular. Like, for them to make this argument, he shrugged as if to say, is very much creative licensing. So put him on the damn stand. Let him come in. Let Melnick take the stand. Ask him.
Well,
ask him why he was shrugging.
Not to mention that Melnick already told her in an email that if you're insinuating in any way that I'm trying to not practiced in my client's best interest, he says, then F you. So, I mean, I don't see where she would even have a case to say that he was somehow working with the defense.
Right. You didn't even, I would absolutely not have agreed to this order with the language it was used. Like, because he didn't have a copy, but once he got it, he sent another email that was like, I absolutely would not have been okay with this. So if he wasn't looking out for his client, why would he take issue with a crappy immunity order? It doesn't make sense.
It doesn't make sense at all. And it's a shame that Lil Woody's in this position too, but it seems like the prosecution just had a leg up and was getting a lot of help from
Yep,
the
Judge
court
Glanville.
itself too. Mm-hmm.
Yeah.
Yeah, for sure.
Oh my
Wow.
gosh. So I had seen someone say that court's about to start. Probably Kayla said it.
Oh yeah, they
Oh,
might
so
be back in there.
Kayla's stream might have froze. Maybe she was trying to move around. And then Sylvia, that's true. So Sylvia was saying that like some apparent conversation, that stuff being said between Melnick and Steele didn't happen. And I mean, obviously, as far as the judge trying to figure out the truth, find out the facts, the best thing to do would be to ask Melnick.
And the
Melnick.
subpoena, he's been subpoenaed, he's ready to go. So I think he's gonna put all this to rest pretty easy. But yeah, thanks, Kat. I know we're probably going back live soon, so I'll definitely be watching. But I appreciate you bringing me up.
I'm gonna drop your channel again. See you in the chat.
Okay. Yeah, thank you. Keep doing what you do. You're doing a great job.
Thanks so much. Show Classy Beats some love in the chat, you guys.
All right, peace, chat.
Wait, did Jason get reprimanded today? What happened? In my chat? In my chat? Hold on, let me know. Let me find out. Oh, wait, Julie. Are you behind on the stream? Let me type that. There we go. Let me make sure. So we might not, Julie's saying that might not have been the exact moment. I went by the, 442. There's an earlier portion of it. All right. Let's get that back. Pull that video back up. Oh, they're starting with the court, I think, maybe. Nope, they're not. So Julie gave a second timestamp for 442. So this would have been before the clip we just watched. Let's see if we notice anything. Am I the only one that gets like the YouTube circle of death when I try to scrub a video, like move the video forward? All right, so they're going to come back. This is the timestamp Julie's saying to look at first. So, and keep our eyes on Atkins.
All right, Sergeant Brown, all our jurors present?
Yes, sir. Deputy Ham, you rotate.
Okay, all right. Deputy Ham, can you check on our jurors, please? Mr. Steele, what can I do for you? Okay, all right.
Good to see Miss Weaver.
I don't know if the state's planning on introducing today, but I just wanted to give you a heads up.
You're right, we're gonna pass them out, and I think we can deal with them after.
Okay, all right. She said you'll deal with it. She'll deal with them as they come, as they're introduced, so.
Everybody ready?
All right. Summon our jurors, please.
Okay, so where's Atkins? Yeah, it does look like he's staring right at the laptop screen watching. He's either meditating or watching. So, Julie, I think you're right, because he kind of always stands this way. So he probably just sits there and watches the defense and the camera all the time, waiting to see anything that might possibly look bad. And then shout out, hey, Seti.
Wait on one yard.
All right, sir.
Don't pan away from him. Okay, so there's Melnick in the cut. There he's whispering. And she's shaking her head laughing. And looks.
All right, ladies and gentlemen, please be seated. All right, thank you, Deputy Ham.
Oh my god, he's so lurchy. Guys, you guys were funny yesterday. I had asked in the chat what you guys think that Christian Atkins listens to as his playlist when he's leaving court. And that they were arguing for so long, they had so many arguments, I didn't get a chance and I forgot to come back to it. You guys had the funniest suggestions of what was on that man's playlist to drive home to. I think someone said the sound of cats screeching, not me, like literally the cat animal screeching. Anything except love, like just so much going on. Let me see what you guys are saying. You guys are all noticing it too. He's staring at that screen. And it is crazy looking at it in retrospect in relation to this new transcript from yesterday. Like, they're clearly looking for any sign that somebody's in cahoots doing something suspicious or shady or whatever. Oh, and I see someone saying, hearing that Seti was feeling better. Feel better. I hate being sick. That sucks. Especially as a YouTube channel. Like, I know you do the YouTube content. If you're losing your voice, my voice always is gone the first 5 minutes I start talking, so I'm used to that. But when you lose your voice, it's hard to stream. I feel like everybody already knows who Seti Nash is. But for those that don't, Seti Nash also is on YouTube, does a ton of content. Let me pull up your channel. So there is the link to Seti Nash's channel too, so you can keep getting your YSL fix. I think we have Classy Beats, we have Seti Nash. I don't know if anyone else has dropped in today, but yesterday, you know, Nick Starro, Tabiz TV. There's like an endless amount of content to continue to binge watch on this case. And then thank you so much. I see Paula Joyce Erwin Davis has just gifted a membership. Say thank you if you got it. Shout out to Paula in the chat. And then Garrett said, you think Whitaker, like Whitaker, will defend Glanville. Love, not so much. Yeah, and I do not get the vibe that Whitaker is pleased with Miss Love. She doesn't seem to be going that hard at Miss Hilton. But Miss Hilton's also not prepared. And she was pretty stern with Atkins about that's not really a list. You having something on your computer with your own notes is not what I mean when I'm asking if you have a list that you can produce of the statements that you plan to introduce from these wiretaps. She is not playing. She is ready to push back on people as appropriate. And then, let's see. And then Amy had become a member too. Thank you so much. And then we've got 3 minutes. I think their clock is 2 minutes off, by the way, because every time they act like it's at the hour, my time is 2 minutes ahead, so maybe we've got 5 minutes. 3 or 5. You guys want to do predictions for mistrial or not mistrial? Because we're going to start with Aaron. Aaron says it's going to be a mistrial. Who agrees? And guys, you know I love the Cuff Boys reference. As soon as we had to talk about Whitaker getting caught up, go watch the 15-minute recaps by Cuff Boys. Well, let's drop some Cuff Boys too. That, and I just learned over the weekend, I knew that I'm Not a Lawyer But did like shorter recaps, but she's been doing them almost daily too. So Cuff Boys and I'm Not a Lawyer But are also really good if you want short content to get caught up. There we go. So conditionally accepted says mistrial by Monday. CJ says no mistrial, but it should be. Hilton's trying to go on vacation. Call the mistrial. Let her go. I thought that was pretty interesting today that they weren't prepared to suggest a different witness in case they can't handle some issues about Woody, or they might not be able to call Woody. We had it underscored yesterday that because of Hilton's travel schedule, even though they're saying it might be okay for someone else to continue questioning of Kenneth Copeland while she's gone, there might be a different solution to that. But if not, another solution would be to call a different witness instead of calling Kenneth Copeland back right away. So if that's in your brain and the judge tells you to do your homework and be prepared, one of the things you should come in today to be prepared with is evidentiary issues on the next witness you plan to call, whether you have to call them next or after Kenneth Copeland. And they just didn't do that at all. They didn't even try. Mistrial, but she won't do with prejudice, Tam Tam says. That's a good one. That's a good one. Because it's possible. I mean, that Bruce Harvey, his motion is really, really good. But it would be if the others aren't granted, all that other stuff that Bruce Harvey adopted, if that stuff's not granted and only his is granted, it wouldn't be with prejudice. They could retry. And Classy Beat says, I think I agree, but Judge Whitaker is going through the whole process. Susan says, yeah, there's no way that the judge can handle this. And that's crazy. I mean, everyone's just saying mistrial, mistrial, mistrial. Mistrial. Good to see you, Andre. Thomas Scott says mistrial. Tony says maybe mistrial with the new ex parte. Good thing you're pretty says, it's so funny that they had to figure out which illegal ex parte the defense meant. And then Susan Tisdale says mistrial. Do you think Judge Urinal's watching? Guys, I've seen it in a few channels. He shows up in this chat sometimes, but Judge Granville, the YouTube account, is so funny when they show up in the chat. So we at least have a parody Judge Granville watching YouTube. Let's see. And Cuff Boys was one of the first, I think I saw videos that weren't like watching a stream live, watching the court live. It was the first that I saw as like the recap style of video content. And then YouTube got stuff into my feed. Okay, so Amy says she's going to go over everything with a fine-tooth comb and then mistrial. Cap Law Entertainment says it should be a mistrial, but I think it will go on further until the judge is caught up and realize it can't go on. Praying Grammy Pammy says mistrial and in everyone's best interest, Love should withdraw. Yeah, it's going to get real when we come back. And then Living in My Truth. There we go. We have someone saying no mistrial. We have Mahadi saying no mistrial due to Fani. And then Tim K saying mistrial with double jeopardy. So no retrial. It's pretty split. Because I think most of us are saying we want mistrial, but we don't know if we'll get it. There's people that we should get it. Maybe we will get it. And then no mistrial because we're not going to get it. And then let's see. Oh, thank you so much, Sapphire Ridge. You remember. Now you got to pick your Mario Kart racer. Dee Dee says that she's trying to decide if it's going to be with or without prejudice. That's a serious decision to make too, guys. I mean, it seems so obvious for us to chatter about on the outside, but you know, she's got to make sure her decision is backed up by the record. I mean, not just for it to be backed up by the record, but that she should feel confident in the decision she's making. right? We could criticize whether we think she's using good judgment, but really she's got to apply her judgment. She's got to come to a certain determination for herself first. And then she probably wants to take extra care in a case like this. You should be careful in every case, but especially in something like this where you're coming into it late, to make sure you've crossed all your T's, you've dotted all your I's, you've got it all closed together. You can put the bow on it and say, look, this warrants a mistrial with prejudice. Here's why. Or this warrants a mistrial for manifest necessity. But there is no, I didn't make a finding of prosecutorial misconduct. I didn't find that this such thing rose to that level. And so here's the bow on the mistrial, but I'm not giving you the bow on the double jeopardy attaching. There could be a retrial. We'll have to see. We'll have to see. Definitely want to make sure if you are the judge making that decision, you are able to figure out exactly why you're doing so and how to get that argument down in paper. And then Will Bowman says, for the sake of the taxpayers, let's pray they don't have to retry. So Will Bowman, I don't think I saw one and it stars. I do see that you became a member. If I go up, I do see that from you. So I've had this same issue happen with YouTube where I've tried to send something to somebody and it'll say thank you for your payment or whatever. But then I'll see in my transactions I don't actually get anything for it. So I don't know if there's a way for me to see, but hopefully you didn't get charged for no reason. If you did, I'll try to look and be in touch with you about it. But I've had that happen to me and it just meant that it didn't actually go through. Don't send it again. Don't send it again just because I'm saying when I did it, it didn't go through. I appreciate you sending your super chat either way. But just so you know that sometimes YouTube has a tech glitch like that. And here we go. We see some heads moving on the screen. Jay Koppel says, YFN Glanville should write a 600-page essay on ex parte and judiciary conduct. Or like writing on the chalkboard how reciprocal discovery does or does not work when it comes to the defense turning over things. Yeah, gifted memberships. Thank you so much, Classy. Shout out to Classy Beats in the chat. You guys say thank you. I love gifts. It's an awesome feature. If you just got a gift, you can now use the Mario Kart emojis. And then Garrett says, please no mistrial. We want to see Steel Cross Little Woody. It's true, right? It'd be so interesting to see. It would be better than TV. But yeah, definitely please no mistrial yet. So thank you so much for the super chat, and thank you so much again for the gifts, Classy Beats. We're selfish. We want this to keep going just a little bit more. Let Woody finish testifying. Let him have cross-examination. Just jump to cross-examination and then call the mistrial. Yeah, and that's right. Look at that. We're actually back late. So that's a first late for Miss Whitaker. It might not be her fault, but you know, we're being sticklers just because we're keeping score for no reason. Yeah, right? She's slipping. Jim says Glanville gifted the judge his watch. Yeah, and that is true. These poor dudes are sitting in, and I don't get it. So, like, they had money. They're currently building a new jail. Is that what I understand? So they're building an entirely new jail. And since it's not ready, like, obviously they're just not repairing the one that's currently falling apart because they're just going to wait until the new one's ready. But in the meantime, sucks for everybody stuck in there, right? That's my understanding of what's going on over there. Like, just crazy. Pastor Whitaker. And what's interesting is, maybe Kayla knew, like, this is about the time we're going to start, so I'm just voluntarily going to go into the court. But if she got the sign that, everyone's entering the courtroom, that the judge is about to take the bench, and then we're still not back, I wonder what happened. Yeah, guys, so don't forget, if you're just tuning in now, if you're coming back, we took a break even though the stream was still running for lunch. Kayla, we had mentioned that Kayla had gone live. She's back in the courtroom now, but she did go live and call out some of the things in this transcript, this new June 7th transcript. So I'll drop that link one more time. I'll be in replay crew on that later. But there's the video now. You guys are saying maybe there's another ex parte. Both of you look. Oh my gosh. And then Will Bowman. So I'm getting this one. Thank you again. If mistrial doesn't happen here, and maybe Woody's testimony that causes it. Right? Guys, can you imagine if we deny all these motions for mistrial? And then Lil Woody gets back up on the stand and he goes, I plead the fifth. Again, all over. All over. We get through all of these motions. We're going to start. And then the same thing happens all over again. It all comes crashing down in, the first 2 or 3 questions that he gets back up there. Like, then what do? You give we're trying to figure out this curative instruction to give the jury on how to disregard the things that we're going to rewind with Lil Woody's testimony, why the judge isn't here anymore. And as soon as we give him that instruction and bring them back up on the stand, the same thing happens again. And I think there's a good possibility that that's what happens. It's definitely not impossible. I wouldn't even say it's unlikely. I think it's probably pretty likely that that could happen. So, okay, I'm going to rely on your insights for this, chat. So, I know Lil Woody's done a lot of content. I know he was like driving a Hellcat through Atlanta. I think it was Atlanta. And he did some interviews. He did the balloon popping challenge. But here, J Capo T is saying, I hope Woody's all right because he's gone silent since the trial started again. So, maybe went on a weekend vacation or something. But also, that's interesting. So I don't know. I didn't think about that. I haven't seen anything about Lil Woody pop up on my YouTube feed. But yeah. Yeah, and he's saying he doesn't want to testify anymore. I mean, it's going to be the same thing. Yeah, we're late. Late due to another ex parte. Heck yeah, I think that probably came from Classy Beats. So F-Bombs is saying thank you for the sub. Right, who is representing Lil Woody right now? Because I think, did Whitaker kind of mention that when they were talking about, the proffer and potentially calling Melnick as a witness? Did she mention Woody having to concede, like, okay, that's not, you can talk about that. That way there's no attorney-client privilege barring Melnick from talking about certain things? Because if I feel like she touched on that. Maybe it was just a general question. But if she was saying it and nobody said, like, oh, he's not representing him anymore, then the presumption is kind of that he is. And sorry, Julie, I didn't know it kept going. I thought we got back to the 4:47 timestamp. Okay, so Woody was just live yesterday. He said he's not coming back. Oh my gosh. Yeah, what would Woody need the immunity for? The transcripts clearly state statute of limitations have run their course. So why are they giving him immunity if they know he didn't do something else? Yeah, might have missed it, but he may be unrepresented. And surely if we get testimony, we'll see. We will see. Okay, and he's still posting on IG. Cool beans. So he's still out there on social. But in any case, it's hilarious. I didn't mean that he deleted his stuff. I just meant was he still actively posting anything? And then if it's a mistrial, two things would happen. It depends on how and why the mistrial is granted. So if it's granted with prejudice, it can't be retried. If it's granted for manifest necessity, something like, we've gone on so long, the jurors drop out, that we don't have enough jurors to continue this case. Manifest necessity. It's a must that we must get a new jury. And that means we can retry the case. There's no reason to bar retrial because there wasn't misconduct. There isn't some reason that would prejudice the defense to have to retry this. So retrial would be allowed. So really, it depends on how the mistrial is declared, if there is one. Okay, there we go.
All right, good afternoon. Hope everybody had a good lunch. So what were we able to sort out with regard to other potential co-conspirator statements? Identifying those.
We have a list of potential ones.
Okay.
Sort of a broader universe. And I'd like to narrow them down before handing them over. Some of them we have reviewed and they have statements about drugs that we may not want to introduce. So there's a large volume of, for instance, calls that have certain commentary in them.
Okay. So you can identify the statements and you're saying that it may be less than the full statement and you can further narrow that, but you at least at this point have the person and their statements.
Yes.
Okay.
Up to a point, yes.
Okay, up to what? You can go ahead and continue to explain.
So, and that's the way it is with a number of the jail calls and the calls from the wiretaps that we have reviewed so far.
Okay.
There are some that are left unreviewed, but the ones that we reviewed.
Okay, and for the ones that are left unreviewed, can you identify, here's the person and here's their universe of statements? We just can't tell you what portions yet? Do you understand what I'm asking?
I think I do, and I don't think we can. When you said, if you could just clarify.
Okay, so why don't you do what you can right now, and then I'll ask you the rest of it. So as to what you have prepared, let's go ahead and share that.
Okay, so this is much in the way that Mr. Atkins was a list of.
It's right. Not what you need.
Okay. Similar, it contains
you don't have to count the number. You can just go ahead and give them the notice.
Okay.
Is it something that you have like a written list?
So yes, it's an internal list.
But it has work product.
Notes.
It's not what she wants.
That are identified.
Okay.
So what I can do is provide to them just the calls that are identified.
Okay, so do you want to do that in writing?
Yes.
Okay, so do you want, could you at least in court identify the witnesses?
This is crazy.
So when you say the witnesses, you mean who we're going to introduce through?
No, that's not what I mean. I mean, who is the alleged co-conspirator whose statement you think you're going to use? And if you have the witness you're going to use, I get it in through
Detective, whatever,
That's
the
great
fifth
too,
gang
but-
expert.
We're looking for co-conspirator statements, so we need to know the ID of the co-conspirator.
Viverito, Detective Viverito is who they want to bring some of this wiretap stuff in
Mainly
with.
the ones from the Garlington wiretap are the ones that are identified in the majority. That's the ones that we have the majority of. The remaining jail calls that we've identified, they are jail calls of Diamante Kendricks, Martinez Arnold, Shannon Jackson, all of whom are actual defendants who either are currently in trial or who have pled, and Marvius Nichols.
I'm sorry, I didn't, number one, I didn't hear that.
Sorry, I just couldn't
Okay.
hear it. And number,
My original objection just was.
Is your mic on?
my original objection was too little, too late. In other words,
I understand.
Okay,
I'm just
so-
trying to sort out what there even potentially is at this point, and then, which is harder than it should be. And then I will hear why it hasn't been shared before and why it should now be permitted regardless.
Look at the prosecutor's face at the second table.
So can you say those four people again louder so Mr. Harvey can hear?
Yes, Your Honor. The jail calls, the jail calls of the persons that I have in my hand that we're reviewing are jail calls of people who are currently on trial or who were on trial and entered a plea.
Okay.
So I don't think that counts for what Mr. Harvey is talking about in terms of co-conspirator statements. In other words, for instance, I have Mr. Kendricks, Mr. Stillwell, Mr. Nichols, jail calls that we had under review by the team who was working on that. And that we've identified calls from that we intended to use.
if I may respond to that, if it's Mr. Nichols' phone calls, the kid has been in jail for a couple of years, number one. Number two, those are his statements. I'm entitled to those under the discovery statute. And if they're just looking at them now, 2 years later, you should, without any question at all, exclude those. I mean, this is,
okay.
Come on, 2 years later.
It is my understanding that everything that my understanding based on your representation to me earlier today in court, that everything that you intend to use as a co-conspirator statement has been provided to the defense in discovery. Is that correct?
Correct.
Okay. And so what we're doing
In
now
terabytes of data.
is y'all asked that it be identified which are going to be co-conspirator statements. So it's not that you don't have it, it's that it is yet to be identified as a potential co-conspirator statement. So with regard to your objection about not having it, you have it, it sounds like. Now, if it's a statement of one of the defendants on trial right now, but it is going to be used against another one of the defendants on trial right now, it is, right?
Yes.
Then it is a co-conspirator statement. So, Mr. Nichols, Mr. Kendrick, Mr. Stillwell, you also said Mr. Arnold and Mr. Jackson. And did you say that both of those people have pled?
Mr. Arnold has pled.
Okay.
And I said Jackson, but Jackson is Stillwell, so that was
okay.
a statement.
All right, so the only person you've identified other than the three that are on trial right now is Mr. Arnold, who pled.
Right, and there's also Nichols, Kendrick, Stillwell. And I have a jail call from Quindarius Zachary.
Okay.
We've identified.
That you've identified only now, not previously. So don't tell me that the three that were already identified, they don't have an issue with in terms of it. Late notice, yes. So was Zachary one of the people that had been identified in that November 2023 notice? Because the notice I have says person A, person B, so I don't know who they are.
Right, so not the jail call, the statements that he has made, but not the jail call. So the name, I believe Zachary is either A, B, or C. I have to look at our notes.
Doesn't matter who. Yes, he was identified as one of the people whose co-conspirator statements you intended to introduce, but the jail call wasn't identified within there?
That is my.
Okay. Is the jail call subsequent to the time that you provided the notice?
No, the jail call date is.
Remember, this is the witness they want to impeach.
2015.
Okay, so is there a reason you didn't include the jail call in the notice that you provided?
When we were preparing the notice, our understanding of the need to extract jail calls that contain this information or wiretap calls that contain this information and identify them was separate from our obligations regarding generally what co-conspirators say.
Okay. Can somebody provide me either the order, oral or written, or the directive that the court gave to the state so that I can figure out whether that was a reasonable interpretation?
And we're going to get that for you. And at the time that we were under the obligation to present the co-conspirator statements, we were still, and the court was aware, we were still listening to, because there was an ongoing commentary about the jail calls and the number of them and identifying them. So we were still listening to.
Okay, so at some point, presumably you completed your listening? I mean, I know they're still ongoing, so I'm not talking about a jail call somebody did last night, but
even all of the ones.
Do you understand? I'm sorry to interrupt you, but let me back up and ask a different question instead. Did you understand that you had a continuing obligation to notify of co-conspirator statements, even if it didn't include jail calls and wiretaps?
Yes.
Okay. And with regard to whether there was some other understanding about jail calls and wiretaps, I'll sort that out later. Let's, at this point, are there other people who you think are co-conspirators, who you think you have co-conspirator statements for that you are potentially going to want to admit in this trial? And let me direct your attention to, because this might help you a little bit. You, a couple of days ago, provided at the court's request to the court, and I assume to opposing counsel, a kind of modified list of witnesses still to go. All right. And you have at least a broad outline of evidence you expect with those witnesses. And some of these people you have actually identified specifically as co-conspirators. So, I mean, can we go through that and at least with regard to those people, see whether, yes, in fact, there is potentially such a piece of evidence? All right. So if everybody wants to follow along and pull out your state's witness list, The first one that I notice is number 3, Antonio Sledge, who you say is a co-conspirator, and then on your evidence, you have listed a defendant interview and a jail call. Could that potentially be?
Yes.
Okay.
Yes.
So we can add Sledge to the list. Then Zachary, you mentioned, so he's already on our list. Now, some of these, I just don't know, but there are a lot of them that have interview or something like that over to the side. I mean, somebody like number 7, Kenya Morton. I don't think she's a co-conspirator, but okay.
Guys, the captions say
then
coconut
Arnold,
spirit.
who's number 27 you mentioned. How about number 35, Wooney Lee, who you have labeled as a co-conspirator?
He is.
Okay, and are there potentially co-conspirator statements from him?
So unless, what we have of Winnie Lee consists of social media evidence. So arguably, if that could be considered co-conspirator statement.
Say better to say, yes, I think so, and it not be than the other way around at this point? I think it was 35. 33. It says 35. Oh, no, it says 35 on mine because I got what, today maybe? Or yesterday afternoon, an amended witness list that adds a few people.
And Your Honor, for the
we add
record, it
people?
added 2 custodian records for Sprint and T-Mobile.
Okay, so anyway, Wooney Lee, either number 33 or 35. How about, and you mentioned Sumlin earlier this morning, and Sumlin y'all already had notice of from November of 2023. So Sumlin's, okay.
That was a deep breath. That's
And
almost
that
like
may
one of
be
my
it in
fives.
terms of, in my review over lunch, what I noticed to be pretty obvious ones. Are there other ones?
As we're reviewing
I feel like we got 3 co-conspirators named out of that they plan to use, they want to admit hearsay statements through. And Sledge, Quandravius, Zachary, and Wooney Lee. Out of all of that. And she's spoon-feeding this to the state. Judge Whitaker is spoon-feeding this to them. And that is true. Glanville had to do the same thing, but he'd let them try to ramble for a while. Yeah, they need to watch their own YouTube videos, timestamps of themselves. And I know lunch you probably want to eat too, but if I was them, I would have been fixing all this during lunch. Atkins got yelled at for trying to say something with work product comments on the sidebar, things that we're using internally, was a list that they were ready to present. Well, are you ready to present that? No, because we have our notes on it. Well, then it's not what I want. The first thing Love comes and tries to say is, we have a list, but it has our internal work product notes on it.
And Your Honor, I think I took it for granted, but all of the 6 co-defendants currently on trial, their statements, their social media, and the jail calls that they have, that we have of them,
Okay.
would be
All right.
considered co-conspirators.
All right, and I'm think that with regard to the 6 co-defendants on trial, it is, I mean, pretty obvious considering that there's a RICO count as well, that the state considers those people to be co-conspirators of each other. It still might be helpful to identify the statements, but with regard to deficiency of notices to those people, I'm going to say that's okay, that's kind of within the context of there being a RICO count against them all. That notifies the defense that at least you think they're all co-conspirators. So if you can identify the statements as well. So that leaves, I guess, so does that mean that there are no others other than the ones we've run through just now?
I want to say that that is accurate. I want to be accurate before I say that that is accurate.
So while she's making sure she's being accurate now, somebody else can tell me, so on the notice that is from November of 2023, the 2 people who are they? Zachary and Sumlin, the people that are identified as like person A and person B? Everybody seems to know except me at this point. I mean, y'all know at this point. So how about somebody on the defense side tell me?
Was that
And you
Sylvia's
don't even have to
voice
say
in the
who's
hot
who,
mic?
just. Oh, okay. Mr. Weinstein, you're looking at me like I know, but.
I'm looking at you like, this seems like a job for Matt Schardt.
Apparently it is, because here he comes.
I'm looking at, am I correct that you're asking about this notice of the 3?
Yeah, there's a like, I don't know what it says, witness A and witness B, or person A and person B. And then y'all said, or she said, there was a supplement that actually identified who those people were. So.
So, Your Honor, witness A was Mr. Copeland, and in that notice, we talk about the statements that Mr. Garlington made to Mr. Copeland. Witness B was Quindarius Zachary.
Okay. All right.
And he's talking about statements that were made by Defendant Stillwell and Defendant Kendrick.
Okay.
And
yes,
I agree with 1 and 2. 3, I'm not sure has played out in actual testimony.
Okay. Do y'all know who 3 is?
So, Ron, I think it says Donovan Thomas Sr. to his brother, but that wasn't co-conspirator.
There's only an A and a B that are like not identified people, right? Okay. Okay.
But 3 is not a co-conspirator statement, correct? Okay, so there's only 2 co-conspirator statements, alleged co-conspirator statements.
Okay. All right, so with regard then to
Damone Blaylock, Your Honor, there are statements that are made, well, there's social media that we have identified. Damone Blaylock is a defendant in this case who's been severed.
Severed, okay.
He social media from the incident listed on the indictment that he was already tried for with one of the other defendants currently on trial.
Okay. And Lee is also a severed co-defendant, right?
Lee, yes.
Okay. How about Sledge?
Sledge is a co-defendant that already pled guilty.
Okay. All right. Yes.
You might want to know Mr. Lee, Willie Lee, he resolved this case.
Okay. But I mean, he was at one point part of this indictment,
He was
the big indictment. Okay. All right. So then, really for everybody that was a part of this indictment, everybody was charged under the RICO count, right?
Yes.
Okay. So it will come as no surprise that the state thinks they are co-conspirators because the state literally alleged that in the indictment. So at this point, there is an objection that they don't have notification of what the statements are. And we are several months in. How quickly can you get to them the detail about what you think co-conspirator statements you intend to introduce? Go ahead.
Your Honor, not certain what amount of time the court's willing to allow us to identify anything not already identified or in the indictment. I don't know if a week exceeds what the court is willing to give. It's what we would ask to identify within the discovery already provided.
Right.
Identify specific statements that are there. We would ask for a week to identify that.
All right. Understanding, Mr. Harvey, your objection to delayed notice, I am going to overrule that objection right now to the admission of the evidence. We, of course, still need to know what the actual evidence is. And a part of the basis for me overruling that is that it appears that the whole trial has kind of been operating on a rolling basis with regard to the evidence. And there have been orders even that, hey, you know, every other Friday, let's talk about the evidence that's coming in for the next 2 weeks. And so if that's been the understanding, then so be it. But I want that to stop right now, which is why we are going through in what I consider to be painstaking detail, because this really should not be what the court is spending its time doing. This is what y'all ought to be doing on your own. But I want us to get on a track where the litigants know what is potentially coming in against them, less than here's the universe. And I want us to be efficient, but I don't want y'all, anybody, either side, having to try the case sort of, you know, blind, or practically blind. So now that I hope we all are getting a better understanding of how it ought to work moving forward, I am going to give y'all, because I've given y'all a lot of other tasks as well, 1 week until next Thursday to get all of that in detail, including anything in wiretaps, including anything in jail calls to the defense. Okay. You look like you want to say something, Mr. Steele. Okay.
I want to say thank you.
All right, you're welcome. Okay. So, what else can we get done today?
Your Honor, just to address a matter that the court asked me about before lunch. The court had asked, when I represented that my understanding, if I'm not mistaken, was that the matter of disqualification of a judge was not competent evidence to be used in the trial. I think I said something akin to that.
Yeah, and you said you had some kind of law that you could provide to us.
What I referred to was Georgia Uniform Superior Court Rule 25.6 and my understanding of it.
Okay.
If it's different than the courts, then that's not unusual. But the last two lines of the rules say that if a motion to recuse is sustained, the selection of another judge to hear the case shall follow the same procedure as established in Rule 25.4. Any determination of disqualification shall not be competent evidence in any other case or proceedings. So the way that I understood that, and of course that rule is cited in other cases, for instance, not for the proposition that the disqualification is not competent evidence. It's just cited in a block cite in Evans versus Williams, 341 Georgia App 226. But that's my understanding. If my understanding is not in line with what the court's understanding is, we would have other arguments against the idea that somehow the recusal of the former trial judge is competent evidence and in some way relevant to whether or not the defendants did or did not do what they are alleged to have done.
Well, it's not relevant evidence as to whether the defendants did or did not do what they're alleged to have done. It cannot in any way be evidence of that.
I mean, I was as to relevance, that was why I was saying.
All right, so relevance will be a separate issue from whether it is, and I can already anticipate the argument because I would make this argument. What you just read says any other case or proceedings. What does that mean for the case that it happens in? So I think we probably need a little bit more research.
And that is what I sought to do over the lunch hour, but I did not find any Georgia case law that elaborated on that. I didn't find any case law that elaborated on that. And so that was, all right. That was where I stood.
Okay. Well,
you don't
thanks
have
for
much to
letting us
stand
know what
on.
it is you were referencing, and I'm not sure if it actually answers our question or not. And it might not need to, because the relevance issue may be what answers that question, because we cannot, well, and it may be that, I don't know, I will entertain whatever y'all want to submit on that.
Motions.
Either competency-wise or relevance-wise, although I think I pretty fully understand the defense argument on it, but okay, thank you. So I know we're not quite ready on the Copeland evidence. I think we have sent out some of the transcripts we've got already, so we're not ready on Zachary yet. Are we ready on any part of Zachary? How about the part y'all had notice of?
Yeah. So,
the statement.
No,
Yeah.
I'm a little confused.
It's not even showing that I have a message, but okay.
Confused.
So that's a problem. Yes.
So regarding Zachary, when we're talking about the co-conspirator statements,
Notice.
We've been talking about Mr. Quindarius Zachary in different kind of contexts here. We've spoke of him having approximately 9 hours of statements.
Right.
And we're also speaking about him in context, as I understand it, with the co-conspirator statement. One statement allegedly stated by Mr. Stillwell to Mr. Zachary, that we caught nut down bad. And then another statement allegedly made by Mr. Kendrick to Mr. Zachary saying we caught nut down bad. Is that correct? Those are the entire co-conspirator statements to Zachary that we're talking about right now.
That we can't talk about today. They're 2 sentences long.
Yes.
Zachary's interviews, the entirety of those interviews and everything that he alleged that a co-conspirator told him in those interviews are statements of co-conspirators we intend to use in this trial. So he has said, and we identified that because I thought it was pretty specific as it related to the Donovan Thomas murder, what it is that 2 defendants currently on trial are alleged to have said.
Okay.
But within those interviews, he talks about other co-conspirators and acts, for instance, the shootings, the buying of the shootings of one of the incidents that are alleged as an overt act in this indictment. He talks about his role providing guns to members of YSL.
Okay, so the answer is no, it's not just those 2.
Right, it's the whole state.
No, it's not just those 2.
Right.
It's
And so,
My understanding is the state is saying, and I don't know if this is true or not, but the state is saying at this point, to the extent that they know, that Mr. Zachary's taking a stand. So I mean, that's what I understand him saying. And so him saying that he provided guns to people is not a co-conspirator statement if he's taking a stand. I'm saying what the state is saying is a co-conspirator statement involving Mr. Zachary. The only thing we've has been identified to us is those 2 statements, which are clearly, in my opinion, spilling the beans. I mean, we're in the same predicament as the other. That's going to be our stance, but I don't know. I can't answer the other statements that have not been identified specifically.
The statements that the statements that Quindarius Zachary gave to the police, I'm certain everyone is aware within those statements contains statements made by other people within YSL. When he's talking about the acts that were committed, he is talking about conversations at times that he has with other members of YSL. He may, for instance, at one point talk about what Antonio Sledge told him to do or something of that nature. Antonio Sledge's statements to him would constitute a co-conspirator statement. So to the extent that we have given to them the interviews of Quindarius Zachary and have noticed them that he is our witness, our position is that the interviews and what is within them, it is a discrete set of information that they have noticed that we are using that.
all right, so I think I hear you saying that with regard to anybody named with at least 1 count against them in this indictment, which is everybody in the indictment, that anything that they say to anybody is a co-conspirator statement, potentially, because they're co-conspirators with the other co-indictees. And anything that they relay was said to them by another either indicted person or person who has admitted in judicio to being a member of this gang is also a co-conspirator statement, and that the defense is basically on notice of that anyway?
If it is contained within an interview that we have given to them,
Okay.
yes. If it is a statement that is made to someone alleged to be YSL, yes. If it is a statement.
Not just alleged to be YSL. I mean, if you're saying they've got automatic notice of this, they need to, like, it needs to be more than somebody's alleged to be YSL for them to, if you're saying, hey, my notice already based on this indictment and me giving these statements over is sufficient notice.
The only reason I said alleged is that the people here have not, we're on trial. So.
Right, but they're co-indictees.
Yes.
So I was talking about people other than the co-indictees.
Yes, I see what you're saying. Yes, any statement, yes. To answer the court's question earlier, then yes. To the extent that we have given them that interview, yes.
All right, and so are you seeking to say, and maybe this is where Mr. Schardt is asking for some clarification, that for all of those people, which is essentially everybody we talked about, that the most detail you're going to give them is you have their statements?
No.
Or are you going to break it down further within the next week?
This has been the
We will
question
break
all
it down
day.
further, but there are only, I think, the people who've pled, and Quindarius Zachary and Kenneth Copeland, who are not indicted, that fall up under that umbrella.
Does that answer at all your question?
Can I explain how it really doesn't, and it's kind of to move from the theoretical, the theoretical to the reality.
Yep.
The reality is these statements, for instance, Mr. Zachary gives a proffer. There's like 4 district attorneys and probably 4 investigators in the room with Mr. Zachary and his attorney. The district attorney, it's you really the investigators are just peppering him. Well, tell us about the Lil Wayne bus shooting, or tell us about the shooting on, someone's house.
Mm-hmm.
And to the extent that, now I get it if Mr. Zachary's saying he was there for a certain event, but there's discussion of a lot of it. The shooting of the convenience store on Cleveland, I'm just making this up, Cleveland Avenue. And I'm just going to use my client's name because he knows I don't mean anything by this. Well, yeah, I think Shannon did that. I think Shannon did that, and that's my understanding, And there's no real, these aren't lawyers asking the question, and there's no indication of what he's basing it on, who told him, who he's saying told him,
Right. So
and
you
everything
need
else.
to know in more detail. Is the state planning to use, I think Shannon did that.
Right.
Is that what you want to know, so that we can then drill down on, is there any basis for that coming in?
Right, I need to know what the statement is, if the state knows. Now, obviously, if the statement says, Mr. Huey told me this, then I understand that he's saying the source is Mr. Huey, but there's just so much information that's just like being thrown out with no declarant, no identified declarant.
Sure, okay. So, first things first is you identify within the next week what parts of each statement you intend to use, because it may be that you are not going to use, I think Shannon did it. And so if that's the case, we won't worry about it any further. So identify them. And if you can also, before the end of the week, before a week's time is out, identify the source. If it's not readily apparent, do that as well, but at least get them each statement. And so we'll go from there. Okay.
This is a mess.
So
just answer one question today, please.
What else do we need to think about? Because I mean, and I hope we can actually go through more evidence, but all of what we're doing right now is productive, even though we're not hashing out the details. We're at least winnowing, narrowing, which is good. So I don't have an agenda anymore. My agenda got hijacked. else can we do that's productive today? Anybody have any ideas? Mr. Steele? Okay.
Yeah, tell us, Steele. Oh.
Your Honor, I could get you brief very fast, but I argued this before the recused judge and it was denied. Former judge would not give me a certificate. I took it to the Court of Appeals of Georgia under the collateral order doctrine. I lost, and then the Supreme Court of Georgia denied cert.
Okay.
But it's
This might be about Ms.
so
Bennett.
there's a ruling on it.
Okay.
So if you don't want to rehash it,
I don't even know what you're going to ask about.
the indictment is fatally defective.
Okay.
So I could take a quick
I
count,
lied.
if you don't mind, right now, and it should apply to,
Okay.
definitely applies to Mr.
All
Williams.
right. I don't know. I mean, if it is something right offhand, if it. Go ahead.
Okay, well,
Go ahead.
it's a general demur. I was going to do it again at appropriate time, but since you asked.
Since you don't have anything else to do right now. Okay.
So in count 56,
You know what? Let me grab my copy of the indictment. Okay, count 56.
I'll get you the page.
Gonna be a minute.
It's page,
Okay, got it. Page 90.
okay, so that charges Mr. Williams, I'm just using this as an example.
Oh,
It
okay.
repeats charges Mr. Williams with participation in criminal street gang activity. And it gives a date range. And it says the essential elements need to be there while occupying a position of organizer, supervisor, or other position of management or leader of a criminal street gang. YSL did engage in directly or indirectly or conspire to engage in any one of the following acts of criminal street gang activity. And that lists murder, aggravated assault with a deadly weapon, armed robbery, hijacking, and motor vehicle. Sorry, I apologize, Ms. Winfrey.
Street gang is.
Okay. Participation in criminal street gang activity for that said accused in the county of Fulton and state of Georgia on and between the 12th day of May 2018 and the 8th day of May 2022 while occupying a position of organizer, supervisor, or other position of management or leadership of the criminal street gang YSL, did engage in directly or indirectly or conspire to engage in any one of the following acts of criminal street gang activity of YSL, to wit, murder, aggravated assault with a deadly weapon, armed robbery, hijacking a motor vehicle, sale of marijuana, possession of marijuana with intent to distribute, theft by receiving a firearm and possession of a weapon by a convicted felon contrary to the law, the state, good order, peace, dignity thereof. They're going to repeat, but Your Honor, my belief is that the grand jury, by and through the Fulton County District Attorney's Office, did not allege a material element. There are
Okay.
4 material elements in violation of criminal street gang activity. And there's going to be a jury instruction that the court, one day is going to give to the jurors. There is a jury instruction on this crime. And I'm trying to get you the pattern jury charge that gives the essential elements. And that would be pattern jury instruction 2.02.25. And there's also case law that one of the essential elements is that the crime was committed to further the interests of the gang. That is omitted in count numbers 56 and 57 for Mr. Williams. There are other people here charged, Your Honor, that has the same issue.
Okay.
But they're different count numbers. And the way I understand the law is that the fact that the statute does not give the mens rea, every crime has to have the mens rea attached to it, and that when the legislature or Congress does not include the mens rea, the courts say that the omission from a criminal statute of any mention of criminal intent should not be read to dispense with that essential element. This rule of construction reflects the basic foundational principle that wrongdoing must be conscious to be criminal. And here, and that was, I'm sorry, under MORISSETT versus United States. It's 342 US 246 at 252, 1952. It's also explained in Elonis, ELONIS versus United States, 575 US 723 at 734. It's a 2015 case in Division 2.
I'm sorry, 575 US.
723.
Okay.
That's 734. It's a 2015 case.
Okay.
It's in Division 2B. And that specifically says that the fact that the statute does not specify any required essential element, including mental state, does not mean that one does not exist. And here what happened is there was a challenge years ago under Rodriguez from this courthouse, the Georgia Supreme Court, said in order to save, or that it is a constitutional statute because it's not a denial of freedom of association, because you don't have the right to commit a crime in furtherance of the gang.
Mm-hmm.
That became an essential element. That changed our jury pattern instruction.
Yeah.
And our grand jury did not, in our case, did not allege that.
Okay.
So I know that there's a lot of argument about, well, this is a gang case, and then 418 kicks in, 24-4-418 kicks in. But I believe that the charges for the gang is not appropriate. I wrote.
And did you say, I'm sorry, did you say that, what did you say the Court of Appeals did?
They didn't take it up.
They didn't take it up, okay.
I didn't get under Dukes, D-U-K-E-S. I don't have, Judge Glanville denied a certificate.
Oh, okay.
They never.
I thought you sought, but you did not secure a certificate. So then you took that up under the collateral order rule and.
Did not, they said it's not a collateral order. I
Okay,
needed a
all right. So they gave you an opinion on the merits of, is this a collateral order thing you can take up? Okay,
And then they dismissed the appeal. So there's no
right,
rule of the case.
okay.
So that is, a couple of counts for Mr. Williams. He has 6. Then the conspiracy, which we're talking about. Okay, I'm sorry.
So you said that with regard to counts 56 and 57, it is not alleged.
I promise that.
Okay.
In those
And
counts.
are there other counts that are alleged against your
Here we go. She's going to grant
client,
it, I
Mr.
think.
Williams, where that is an issue?
Yes, there's an essential element in count 1.
Okay.
Which is the RICO count. And I compared it, I just did it because, it's such a well-known case, to the Donald Trump indictment out of the same grand jury.
Yep, they were missing the mens rea. The
Nowhere
indictment
in
wasn't
count
complete
1
there either.
Will you see that any of these individuals have been charged with joining the conspiracy knowingly and willfully. It is not in there. And that's RICO conspiracy count starts, I think, at page 12, but hold on.
All right, and so you're saying nowhere in, I'll read it, it's pages 1 through 68 of the indictment, but no, I'm sorry, 12 through 68. You're saying nowhere in that 50-something pages does it allege any of this was to further the interest of the gang?
No. I'm saying that it's a different.
No, that's not what you're saying, or no, it's not in there?
I'm doing a different issue in that, in
Okay.
count one.
Okay.
The conspiracy.
All right.
The grand jurors charged that Mr. Williams and the others who were here, also the others who are not here, unlawfully conspired to acquire and maintain indirectly and indirectly an interest in and control of U.S. currency and other personal property through a pattern of racketeering activity in violation of OCGA 16-14-4A, as well as 4B, as well as B. But what happened there is, I went through it hard. There is no allegation by the grand jury that Mr. Williams or anybody knowingly and willfully joined the conspiracy. And under Cotman, which is C-O-T-M-A-N, versus State, which is 342 Georgia Appeal, 569, it's in Division 2.
Okay.
The 2017 case, that is a teacher from the APS trial. It was also a RICO conspiracy case. The Court of Appeals of Georgia held that in order to commit a conspiracy under the RICO statute in Georgia requires proof of the material element that the accused knowingly and willfully joined the RICO conspiracy. That is also in MacArthur, which is MC-ARTHUR versus Beach, which is B-E-E-C-H. Haven, which is H-A-V-E-N Baptist, B-A-P-T-I-S-T Church of Athens. Your Honor, it's 368 Georgia Appeal, 525, it's in Division 3. 890 Southeast 2D, 427, that's a 2023 case. Cotman specifically wrote that under Georgia law, a person may be found guilty of the crime of RICO conspiracy if that person knowingly and willfully joined the conspiracy, which itself contained a common plan or purpose to commit two or more predicate acts. There's also Wiley, which is W-Y-L-I-E versus Denton, D-E-N-T-O-N.
Another
which
case
is
law, more case
323
law, more
Georgia
case
Appeal,
law.
161, it's in Division 1. It's a 2013 case where our second highest court wrote the material requirements needed for a conspiracy under the Georgia RICO statute is for the person to knowingly and willfully join said conspiracy. There's another case called Z, like in the Honorable Lawrence Zimmerman -space, S-P-A-C-E, Inc. versus Dan Tanners, D-A-N-T-A-N-N-A'-S, CNN Center, LLC, and that's at 349. Georgia Appeal 248. It's a 2019 case. And what I used also was, I just looked at Donald Trump's indictment. I was interested in it. He is not only the former president, but the other alleged co-conspirators. They are charged several times with knowingly and intentionally joining this conspiracy. And it's not here for Mr. Williams. And mens rea is a material element of the crime and must be alleged in the indictment. That's in Eubanks, E-U-B-A-N-K-S versus State, which is 317 Georgia, 563. It's in Division 4. It's a 2023 case. So, you know, as you're going through this, if you're going to reconsider it, I will bring it up later, obviously, because I believe at a directed verdict motion, that would be relevant as well. But, you know, I don't know what it's like ever to be a judge. And I certainly don't know what it's like to come into a case like you're coming in. So if this helps, this is ripe under State versus Heath, H-E-A-T-H.
Once the jury is sworn, a general demurrer can be made orally or in writing. I actually put this in writing.
Okay.
But I waited till the jury was sworn, and I did that,
Okay.
I mean, intentionally, because jeopardy attached, so.
Sure. Yeah, and if it is already in writing, I'd love to have that. And I assume this got argued at one point before if the
Yes.
prior judge made a ruling. So if there's a written response from the state, point me to where I can find that as well. If there's not, point me to where, like what date it's argued.
I have the order, and I filed that in a motion that I gave to this honorable court.
Okay.
I'll get the motion, I attached it, but I didn't give you my brief. So if the court's permission, and of course, the state has it already, but I'll resend it.
Is it filed in the case somewhere or?
Went to the Court of Appeals.
Oh, okay, that brief. Yeah, sure. I'll take it all.
Okay.
And then I'll assume the state filed some sort of a response, maybe not this team right here, but, and it may have been that more about that was about collateral order or not, but I'll take it and read it for whatever it's worth.
The state argued, and then they wrote the proposed order, which was signed by Judge Glanville. So,
Okay.
and it's a long order,
Yeah.
12 pages.
I'll take all of that.
Okay. So I thought that would be, if you grant it, it would be helpful because it would knock out all this work.
Yeah, it would. That is true.
Okay, thank you, Your Honor.
Thank you.
I'll get you that brief.
All right, appreciate it.
Your Honor, I'd also point the court's attention to the transcript dated December 11th, 2023. It was filed on that date.
Okay.
Of at least one of the hearings where we addressed Defendant Williams' general demurrer claims.
Okay. Is it a transcript from December 11th or was it filed on December 11th?
It was filed on December 11th. It was held on November 20th, 2023.
Okay, thank you.
And it was specifically as to Defendant Williams' plea and bar / motion.
Great, thank you, appreciate that. All right, Mr. Harvey, you look like you also were maybe gonna stand up and come up with something we could do. Oh, and you know what? Hang on, sorry. If I don't do things when I think about them, sometimes they escape my mind. So I understand that for Mr. Williams, that is count 1, count 56, and count 57 you're alleging are fatally defective. And you mentioned that may be true about other defendants as well. Are there other defendants who either have already made or intend to sometime before this goes to a jury make a similar argument with regard to counts that you have against you?
I think under the rule, we're all joined in.
Oh, right, yes, the Harvey rule, thank you. Okay, but if you are all joining in, can you tell me, is this essentially true about every one of the gang counts that they're missing? Okay, all right, then I can sort out for myself which ones go to which person. All right, now, Mr. Harvey.
Doug reminding him about the mic.
And this is more of an afterthought. At least I'm still having thoughts, whether they're before or after. I want to make an oral motion at this time to prohibit the state or anybody else from talking to witnesses while they're on the witness stand. Judge Glanville would give an instruction which was incorrect to witnesses. Don't talk to anybody but the parties in this case while they were on the witness stand. The only one that is, the only people that are accepted from the no talking rule once a witness is on the witness stand is a criminal defendant and the defense lawyer, because that's a Sixth Amendment impediment. The case, as I remember it, is Perry versus Leak, Perry versus EEKE. It is a United States Supreme Court case which indicates that other than the defendant, witnesses or parties are generally prohibited from talking to witnesses once on the witness stand. So I would like an instruction. I could write this out. I can ask for an instruction.
That'd be great. No, you don't have to write out the motion. I mean, it's fine. I'll entertain it orally. And I mean, that's generally my understanding as well, but it's been a minute since I've practiced. It's been a minute since anybody raised that issue. Is there some kind of an exception for I mean, I know if you're on the stand and then we take a lunch break or a restroom break or something, that's one thing. Is there anything about overnight that is different?
Only for the defendant.
Okay.
And the defendant's counsel. That was the whole basis of Perry versus Leak.
Right.
The state said in Perry versus Leak, hey, you can't talk to your client while he's on the witness stand. And the Supreme Court said that yes, because there were Sixth Amendment implications, that a defendant and a defense lawyer could, but generally other witnesses could not.
Okay.
So you're
hazy
close.
memory.
Yeah.
All right. Does the state have a response?
Your Honor, I believe that the rule that Mr. Harvey is referring to essentially is the rule of sequestration, and as it relates to other witnesses and about talking about the witness on the stand's testimony. The reason I was looking feverishly is that Ms. Hilton and I had actually discussed this, and I had sent her a case, not from within Georgia, but it literally spoke directly to it. So I was at least looking for that. Because I don't think that under the rule of sequestration that attorneys, I think that Judge Glanville had it right, attorneys are not prohibited from speaking to witnesses, but I want to make sure that we get the law.
Let's make sure we get it right. So.
Oh boy.
Submit whatever you want to submit on that as well.
She's not, yeah. Oh boy. Holy moly. Whitaker is not convinced that they have anything of substance.
We're going to take a recess right now if there's not anything we can do immediately. And we will be back at 3 on a Rule 22 matter. Y'all got that notice, right? That there was a new Rule 22 filed.
That's Kayla Bumpus.
All right.
When we come back, we're going to hear Kayla Bumpus's Rule 22 motion, her application. I bet the state's probably going to try to fight it. And it'll be really interesting considering the June 7th transcript that we got to read today. So, first, the big part of that, you guys, was Whitaker has asked the same question pretty much all day. Can we start talking about some evidentiary issues? Can we start talking about, these hearsay statements? Guys, the reason I keep seeing in the chat, hearsay isn't that hearsay, isn't that hearsay? Hearsay can't just come in without a reason, but there are exceptions to hearsay. And what Love has been trying to do for seemingly this whole case is say, because this person is a co-conspirator, doing something, anything, anywhere, sometime ever, they blinked in the direction that someone from YSL may have been standing, their statements should come in under an exception to the hearsay rule. So all of this back and forth about, can we outline who you're saying is a co-conspirator? And because you're saying they're a co-conspirator, also what statements you're trying to get in through that person. So one of the example, and what witness are you going to use to bring in their statements? Because some of these co-conspirators aren't going to take the stand themselves. It's coming in through someone else that heard the statement, oh, this person told me that. So person A says something to person B. Person B says it to a detective or a police officer, and they want to bring it in through, what's his name? Detective V. Detective Verita something. They gave a detective's name. I don't know where I wrote it. Viverito, Detective Viverito, who's 50 witnesses away at this point. And then also a different witness, Mr. Zachary, who they've already said they plan to impeach. The state plans to impeach this witness when they call them. So they've been arguing back and forth about some of these statements that could potentially come in through some of these witnesses. And the judge is like, well, do you have any other, let's talk about other people, other witnesses, other statements that you might be trying to bring in. And we got a total of 3 people listed. And it took us, I have it marked in this stream as 5 hours in and 4 minutes. And that question was asked several times in the morning. They had 2 breaks so far today, lunch and a long break, an hour-long break earlier this morning. And we still only get Antonio Sledge. Zachary was one of them, and Wooney Lee, I couldn't get the pronunciation exactly right. Then, also the 6 on trial, which would make it 9. Ooh, so impressive. But at the same time, they're co-indictees, not just co-conspirators on the outside as witnesses coming in with statements to bring in. So it's really 3. All this questioning to get 3 names out of the state. Well, what do you plan to bring in under them? Oh, well, we have, social media posts and all of this. Oh, and did you identify those things for the defense? And then the answer is no. They have identified 2 sentences total, according to Schardt, for what they plan to bring in through Quandravius Zachary. 2 sentences. We are at day 103 of this trial. So it's crazy. It's crazy. I want to work backwards a little bit. I think we left off here with Will Bowman saying if mistrial doesn't happen here, it may be Woody's testimony. It may be Woody's testimony that causes it. Yeah, if he gets back up there, he doesn't want to testify. Garrett asks, great point, and I love seeing the parallel. If this was in New Mexico, Thug would be home, ask Alec B. And I don't know if New Mexico would be the answer as much as a judge that didn't want to play around with her time. Judge Summers in the Alec Baldwin trial from the very start, from the pretrial motion hearings, was telling the prosecutor and the defense attorney, because they were both quibblers, both of them, both sides. She said, I'm not playing this game. I'll cut you off. If you run out of your time, that's it. I'm moving on. They can present their case in chief. And defense, when it's your turn to present your case in chief, if you keep going on and you try to bring in new witnesses, I'm not going to let you do it. I'm going to stop you. It's not going to happen. You're going to have your 3 days and that's it. So it could be, the judge, not necessarily New Mexico, the jurisdiction that would make the difference, but rather the judge. And Steven Satchel said, the summary so far, the bottleneck in this case is the state not using all the people in the DA's office to finish this homework. It seems like Love wants to dump assignments on somebody after she gets in trouble for doing them wrong or not doing them at all. But every other time she tries to hog the decision making, it has to go through her. And it's funny that you're presenting bottleneck and you've got the rainbow light refraction. Thank you so much for the super chat. Shannon became a member. Thank you so much. Mahadi says, yeah, who else in the chat gets this feeling? Mahadi says, I'm not an attorney, but Lord, the way the judge is holding the hands of the state makes me feel like I could do this. Because she's walking them through. She was really baby stepping them, spoon feeding them. And I saw people saying, of course, the judge is helping the state. I don't know if it's helpful in a positive way for the state. She might be helping them, but only to show that they have a mess that they have created themselves. They are not prepared. They don't have what they're supposed to have. And then following a mess of this whole day, we get to these arguments from Brian Steele about how the indictment is inherently flawed. Think about that. The judge is learning all the pieces that haven't been done properly. The state seems like they're trying to ambush the defense by not disclosing, not identifying what they plan to bring in through a witness. They just spring it on them. Judge Glanville allowed it. Judge Whitaker's realizing all of this. And then she gets presented with this all the way back from the beginning, the very indictment, the initial indictment, multiple counts have flaws with them. It's not just a mistake. They forgot to include all of the underlying elements of a specific count. One is bad, but the rest is fine. No, there were several counts, and it applies for several defendants. That's not good. That's not good. And I do think she's going to take that argument from Brian Steele seriously. And whether she agrees with it or not right now, I think she will grant the certificate of immediate review so he can take it to the appeals court. And the appeals court said, look, we can't hear this without a certificate of immediate review. But if he comes back with one, now they can finally hear it. And he mentioned the Trump RICO case because that's another Fulton County case that had fatal flaws in the indictment. And I forget the exact numbers. I think it was like 28 total. Some of the counts were shared among multiple defendants. They had the same counts, whatever. But I think it was like 6 for Trump. And we're not going to do a deep dive on that or anything, but what I'm saying is it just happened recently with an indictment written by the same DA's office, where they weren't putting in the elements of the crime. And one of the problems with that is if you don't put in the indictment the elements of the crimes charged on someone, then they don't know what to defend themselves against. How can they prepare a proper defense if you're not telling them the full scope of what they're being charged with and what you'll be trying to prove to convict them as guilty beyond a reasonable doubt? So that's where why a fatal flaw in the indictment is problematic, and why when Love says, hey, I just want to mention, I want to defer back to what we were just talking about. We have 2 different days where we heard arguments about this in court. If you go look at those transcripts, you'll see that we corrected this orally. It doesn't work like that. Love is trying to say, well, we talked about the elements and we corrected it orally. That's not how it works. The indictment is flawed. It should have been correct in the indictment. So that'll be interesting to watch. And I do think it comes back to what Stephen had said. If certain people want to be in control of it, shoddy work is the output, because you don't have group participation where things could be improved, corrected, proofread. So thank you so much, Mahadi, for that. I think a lot of people in the chat might feel the same way, that they could do this too. Ray says, I understand why the judge is trying to keep this trial on life support. It's out of respect for the jury's time, past, present, and future. At some point, she has to realize continuation is untenable. It could be. I really think she's realizing a lot of it as we go. You can see her shift from yesterday morning when the big motions hearing started. We came back from lunch, and it was just like it shifted. And I know people think she's being nice to the state. I know there are some judges that come out and really tear someone a new one right in open court. But that's a personality thing. Not all judges are like that. But that doesn't mean they're not peeping what's going on and going to issue a scathing written order when the time comes, after they've taken things under advisement and they're going to look at it before they make their decision. So we'll just have to see. So thank you so much, Ray. And then Miss Abby says, maybe it's Miss AB. Miss Abby or AB? They seem very unprepared. Put a 1 in the chat if you agree that they seem unprepared and unprofessional. How is she having to teach them how to do their work? What have they done all of this time? Jeez. I don't know. Like I said, we went through 5 hours today. We talked about a few different issues, but the bulk of the time was about what evidence can we look at? What statements can we look at? We get 3 names of people, and we have a bunch of general stuff. Do you have a list of things that you've identified? No. That's what we've gotten out of this whole day. This is day 103 of the trial. So thank you so much. And you'd sent another super chat. Thank you so much. I think that she is punishing the DA's office. It could be. By making them do their job. And these people, it's literally like the state, the government prosecuting, in any case, prosecuting the defendant, whoever the defendant or defendants are. It's the state, it's the government against the defendants, the people. but sometimes they'll be written as the people verse. Or in some states, like in New York does this. It's not really referred to as the state of New York verse. It'll say the people verse. And the reason for that is the prosecution is supposed to fight for justice for the public. They're supposed to act for the public. They are paid by the public. So you have something like this. This judge could be making them finally do their job. They represent the people and they haven't been doing their job. But they've been getting paid by the people. They've been getting paid by the people to do a really shoddy job trying to prosecute someone that may or may not be guilty, but this process isn't going to give us confidence in the outcome. And it's just crazy. I appreciate your super chat. It gave me a nice chance to rant. It's good to see you in a live. But yeah. So yeah, you guys are saying I see a bunch of ones. Unprepared. Kristen Vasquez says all the way 1111111. And it's crazy, you know, we all try to be fair sometimes, see the other side, try to play devil's advocate, see maybe we're missing something. But I don't think there's any way to sit here and try to say, well, maybe there's a reason they seem unprepared. There's just no excuse for it. I don't think there's an excuse. Look at you guys. Yeah, nobody agrees that they are prepared. Just crazy. And then factual lie, good point. I landed here on accident, but good point. I bet Steele has been having chats with Ashley Merchant. Now, we don't want to discredit. Steele's also good. He has a great appeals record. But that Trump line, talking about that RICO, the fatal flaws in that indictment against Trump and his co-defendants in that RICO case, because it wasn't just Trump that had counts, you know, dismissed because the indictment was inherently flawed. But, you know, I'm sure that's something that Ashley Merchant is very familiar with. They could be talking. And I do think Steele made this initial motion for this a long, long time ago. Like, it might have been 2022. I didn't hear the date, but I think it was 2022 already. And then he was trying to argue for it. And then in 2023 is when Love referred to the transcripts where Glanville finally addressed it in court and denied it. So it may have been before all of that stuff started with the Trump RICO. But it's just crazy. Like, can you imagine if all of this 2 years later and half of this is knocked out because the Supreme Court ends up looking at and agreeing that the counts are flawed from all the way back in the indictment? All of this time passes. And then thank you so much. That's so nice of you. Kimmy Sue, you became a member. Make sure you use your Mario Kart emojis. And then I can relate and living in truth. You guys just both sending a pure $1.99. No comment or anything. That's so nice of you guys. Appreciate you guys. We've been going for 6 hours today. I see Casper in the chat. You guys show Casper some love. And yeah, so correction in here, guys. So Brian Steele and his wife, Colette, are both attorneys. And then Ashley Merchant and her husband, John, are both attorneys also. So they are two attorney couples, but they're not coupled together. So, oh my goodness. Oh, I see people saying, hey, Nick. I don't see Nick. I see, hey, Nick. Nick, let me know if you want to come up. I don't see an initial comment from you, but if you want to come up, I'll drop a link. Oh, okay, you're stream sniping. You're still on your... Hi. Okay, everybody say hi to Nick's chat. Okay, and someone... Thanks, Aaron. So it was 6 counts for Trump. Sometimes I'm bad with the recall, but every once in a while I get it right. Yeah, we got some love for Nick over here. We're waving over to Nick's chat because his stream is streaming this stream. And we're also going to be monitoring if we come back on time at 3 p.m. Oh, look at you guys. We're like 2 worlds colliding. Oh, so Max Schardt's wife is a lawyer as well. I never really heard her name come up. Gotta find out more about her, see what she practices in, get her some spotlight. You've got a bunch. Jar! Hey, Jar! Okay, wait, so are you raiding now or stream sniping? Are you saying hi to yourself over here? There we go. Oh, and then not Sando, which makes me think of Steve Sadow. So not Sando. I'm dialing it back at work, Hilton in love mode. What is it called? Quiet quitting, where you just like kind of do your job, but you're not really doing it. You're just letting someone else do it for you. I think it's called quiet quitting. Thank you so much for your super chat. Recused Judge Glanville became a member at exactly 3 p.m. right on time. Oh my gosh. Okay, and you guys are saying that Max mentioned that his wife is also an attorney on the interview with Megan, probably Kunith. So I missed part of that interview. I did try to watch it, so I probably missed whatever part that was in. And then they met at Duke. There you go. Talk about power couples, right? There's like that joke, the meme of like what people think power couples are. I think power couple is Colette writing that filing for the supersedious bond to the appeals court when her husband was held in contempt. She was like, oh no, like here we go. That is power couple right there. And then yeah, it's 3 p.m. for me. It's 3:01 p.m. for me. It says 3 p.m. on the Law and Crime stream. 3 on the dot. So where are we? Okay, so it is a raid from Nick. So the Nick is actually in here. So is he like actually streaming stream snipe to the end? And then Nick needs to get to bed. Well, you're welcome to keep watching, but you might hear some voice, some love voice, and I don't know if that'll really help you go to sleep. Thank you for the raid. Shout out to all the Nick Starro raiders coming into the chat. I think so too. I keep wanting to call you your old username, but she loves fantasy. She's exhausted from this case already. It's only been, I mean, I'm sure she was looking at some stuff I'm sure she has other cases. But she had the first hearing where she's like laying out, all right, we're gonna, status hearing, right? Oh, we're back. We're back. Hey, everybody coming over from Nick. We are back live.
All right, where's Miss Bumpus? That's
Yeah, it is Kayla.
Rule 22. Good afternoon. All right, so you filed a Rule 22 at what, 11:10 or so?
Yesterday.
That's fine. The night before last. So, and you had said that you wanted to start recording for yesterday. And honestly, I didn't even know you had filed it until we were finished with the court yesterday afternoon at 4 something, because it came in so late. And normally the Rule 22s go to our public information office, but I know about it now. And so I have provided notice to all of the parties, and I will listen now to or ask if there is objection from any of the parties or witnesses or victims to the Rule 22 filed by Ms. Bumpus. All right. So I am not real. So what are you looking to do?
Your Honor, I just want to be able to record what's going on in the courtroom.
All right. And you had already, I guess, yesterday live streamed from somebody else's
Yes.
live stream. What is that person's name?
Miss Sylvia?
Miss Sylvia?
Yeah, she's sitting in the courtroom.
Okay. All right, so there are an inordinate number of separate Rule 22s in this case anyway. I'm not really sure why everybody is not using the pooled media that is already, I mean, it's like 8 or 10 media organizations are using one pool, and then there's Miss Sylvia who has a separate one, and then lots of people who have the ability to take still photography and audio, and it's just a lot. It's like 8 or 9 different things. But I am not sure that yet another person doing essentially the same thing adds to the public's access to this proceeding. There is 24/7 coverage of this, a pooled camera, and Miss Sylvia's separate video recording that you can access anyway, apparently. So, I mean, if you want to be heard as to how that either increases the public's access or helps with the dignity of the court or the administration of justice or the truth-finding function of this proceeding, I'm willing to listen to what you have to say.
Your Honor, I'll be brief. I just would like to say that at any point, these other people who are part of this pool, they have logos and they can pull what I am streaming on my personal YouTube and do copyright issues. They have their own logo on there. And also, I don't always want everything that they are streaming. I don't need the full court hearing all the time. There are specific parts that I need to reference and inform the public of what's going on. And that's my point of being here. And I'm just trying to do everything right so that I can, pass the smell test.
Okay, so with regard to, I mean, obviously you can let the public know anything you want to, and you can video blog, vlog, all you want to, any kind of opinion that you want to about the case. And you can obviously also sit here and watch all of the proceedings. Are you saying that you can't use somebody else's, like the news media coverage?
It has their logo on it. At any time they can say it's copywritten and take it from me.
Okay.
From my page.
Have you asked anybody other than, is Miss Sylvia okay with you using her? Because honestly,
say no, Sylvia, say no.
It's a little bit disruptive to have essentially phones in court. I mean, it ought to be that unless you are somebody who has a Rule 22 already in effect, or you are an attorney in the case, you shouldn't have your phone out or on or anything. And it's kind of chaotic in this entire part of the courtroom. And I find it to be distracting. I find there to be security concerns with having to constantly figure out, okay, who is authorized to have their phone out, who is not. And so what I would like is, until there's some point when you find out that you're not able to use somebody else's, what they've already taped. I mean, I'm kind of saying, why don't you and Miss Sylvia be the second pool? Okay, would that work?
We'll try it out.
Okay, so let's do that. Y'all are now the second pool.
You will revisit it if I have an issue.
Sure.
Thank you, Judge.
All right. Thanks. All right. Anything else we can do today?
That was so worth it for the day.
Enough work that y'all can just go home and do your work, and y'all gave me plenty of work to do also. All right. So we are adjourned for the day. How about we see each other at 9 in the morning?
We're doing
Which
9
doesn't
instead of
mean when we get the
8:45.
jury back, if we get the jury back, I won't go back to 8:45. But let's see each other at 9 in the morning, and let's be ready to actually work on some actual evidence, okay? All right.
I just want to be clear. What is your expectation of what the evidence will be tomorrow? If you got it.
Are we going to be able to, so y'all are getting some of the transcripts of Mr. Copeland's testimony so far. What all have we already shared? No? We don't have any of his testimony? I thought we had at least the 11th. When are we getting that? By the end of the day? That was a really good question, Mr. Schardt. I thought we were going to be doing Mr. Copeland's evidence tomorrow, but maybe not.
Did we ever get an answer, Judge, as to whether or not we have the transcript from the 10th? I know that Ms. Weaver indicated, excuse my seat, Ms. Weaver indicated that she was working on the one for the 11th. She might have it by the end of today is what I heard earlier. But you asked whether we actually had the 10th, and I didn't hear the answer to that.
I got you, Felicia, when they're done. All right, there. Look at the defense attorneys cooperating, working together. I'm sure the state loves looking back at that. In the meantime, thank you so much, Ronnie, for the super sticker. That's super awesome. Thank you so much. I can do this because I'm not covering any captions right now.
The answer to that is no, we do not yet have the 10th. We had portions of the 10th, but they were the other portions of the 10th. So hopefully by tonight, the court reporter will have both the 10th and the 11th. Y'all should have, now this isn't his testimony, this is y'all going through evidence, but y'all should have a rough of the 18th, the 21st, and the 24th already, and then the rest of it will be forthcoming. So I don't know if we can work on Mr. Copeland tomorrow or not. I don't know what can we work on tomorrow?
She's like, please, something.
No point getting together as much as y'all are all delightful. No point getting together if we can't get work done.
Both emails to get the 18th, the 20th, what you said?
The 18th, the 21st, and the 24th.
Testimony or pitch?
No, so, yes, that. So he testified on the 10th, the 11th, and the 12th, and well, wow, okay. He testified the 10th through the 17th. And then y'all took up matters about the evidence surrounding him the 18th through the 26th. All right. I think tomorrow might be more productively spent with everybody working on the things they need to work on. Tomorrow is Thursday, so let's get back together on Friday at 8:45. Okay. See everybody then.
Is this actually going to be it? Because you know how they've been doing. We pan away and then someone starts talking. We might be good. All right, we're blacked out. They said not today. We're just shutting it out completely. Now, real quick, you guys had said, what was the smell test comment about? What was the smell test about? And Kayla, I think it looks like she's going to go live tonight. And she said, save energy for me today. Because yesterday I was like, look, I have no energy to jump on, but another time. So today she's like, save energy today. And I'm not going to say what she said next. But it looks like she's going to go live today to explain the comment herself. But she is referencing this newly released transcript from June 7th. Because towards the end of it, the prosecutors and Judge Glanville, they've been throwing shade at Melnick through the whole transcript. But they really throw some shade at Kayla at the end. They think she's up to no good. She hugged Diamante Kendrick in the hallway. She's up to no good. So Miss Bumpus is going to be here. This is Friday. They're talking about Monday. Miss Bumpus, hugging Mr. Kendrick and Mr. Williams, is going to be here representing the interest. Okay, it went to another thing. Sorry, my screen started, the YouTube started playing another video. So, Bumpus is going to be here representing the interest of Kenneth Copeland, who is supposed to testify against Kendrick and Williams. That is where we are. That doesn't pass a smell test. And then Judge Glanville says, all right, okay. And Miss Love says, thank you. So we read the full transcript at, I think, about 10:45 this morning, so it should be about 2 hours and 45 minutes into the screen. If you want to go back and replay that, you'll see the paper on the screen when we're reading it. But here's the link if you want the paper copy. I just dropped it in the chat. But that's what Kayla was referencing when she got up in there and gave that look over at the state table, really, at Hilton and Love. And previously, she's tried to speak well. She's tried to speak positively of the two. So I think this made her go scorched earth. I don't blame her. I don't blame her. So, and then Miss Avey says, I want to make my coins off the trial, Judge. And then Jose Guzman says, Kat, hire a lawyer and file a Rule 22. And that's, so Nick Starro pointed it out in the chat, but you heard Judge Whitaker say, you know, what about Press Pool 2? You guys can become Media Pool 2. You and Miss Sylvia. So, as opposed to really the big guns, the local news, and then outlets like, in this case, Law and Crime, I don't think Court TV has streamed the YSL stuff, but I'm sure they have press access. I'm sure they applied. I don't think they're in there streaming live today. But, you know, the media pool is kind of locals, local news outlets, and any bigwigs that get approved. And sometimes they have a press attorney that represents them. But other people have to kind of look for their own way to get public access to do the same thing. So it seems like Judge Whitaker has now officially given a press pool title to Sylvia and Kayla combined. So interesting there. Really, really. Kayla's going to add, hey, Flush of the Gods. Kayla's about to add YouTube to the witness list. I think it was a smart move too. And let's see. Kayla better be selling a pass the smell test shirt tomorrow. I wouldn't want to wear a shirt that said that though, to be honest. But it's still hilarious. Like, hilarious, hilarious, hilarious. You want to watch it again? You want to pull up that clip? Just watch that one little eye. The dart. Let me go back to the timestamp. Staring daggers at the table. And dang, they really had a recess just to come back and not do too much. So let's see. I think we're close here. We just get back from the break. Let's watch her eyes.
All right, where's All right, so there are an inordinate number of separate Rule 22s in this case anyway. I'm not really sure why everybody is not using the pooled media that is already, I mean, it's like 8 or 10 media organizations are using one pool, and then there's Miss Sylvia who has a separate one, and then lots of people who have the ability to take still photography and audio, and it's just a lot. It's like 8 or 9 different things. But I am not sure that yet another person doing essentially the same thing adds to the public's access to this proceeding. There is 24/7 coverage of this, a pooled camera, and Miss Sylvia's separate video recording that you can access anyway, apparently. So, I mean, if you want to be heard as to how that either increases the public's access or helps with the dignity of the court or the administration of justice or the truth-finding function of this proceeding, I'm willing to listen to what you have to say.
Your Honor, I'll be brief. I just would like to say that at any point, these other people who are part of this pool, they have logos and they can pull what I am streaming on my personal YouTube and do copyright issues. They have their own logo on there. And also, I don't always want everything that they are streaming. I don't need the full court hearing all the time. There are specific parts that I need to reference and inform the public of what's going on. And that's my point of being here. And I'm just trying to do everything right so that I can, pass the smell test.
Okay, so with regard to, I mean, obviously you can let the public know anything you want to, and you can video blog, vlog, all you want to, any kind of opinion that you want to about the case. And you can obviously also sit here and watch all of the proceedings. Are you saying that you can't use somebody else's?
So we don't need to rehash the whole argument there, but that was the look in reference to the newly disclosed Friday, June 7th ex parte. That was a quote from that transcript, daggered right over at the state's table, who are looking at each other and talking when she first got up at the podium. But as soon as she says that, so, but there you go. So there's that, you guys. I think we're all caught up with everything we're going to get today. Thank you, Ghost, again for dropping Infamous Sylvia's link in the chat. I had just dropped that in Kayla's, and you guys are chatting so fast that I think it's gone. I'll drop it one more time. So this is Kayla. And then, I don't know, maybe she said what time she's going to go live. I think she's been going live around 7 p.m. Eastern, so it's, 3.5 hours from now. She uses the same time tonight, so not too far away. But yeah. Anything else on? I didn't see any documents filed, you guys. I didn't see any documents, but it is possible that something could come in because it's only 3 o'clock, but I could do a standalone video or hop on live later tonight. I do have some stuff to get done, and we've got nothing else to catch up on in the meantime. And then Jar, thank you so much. $9.99 super chat to say thank you, Kat. Appreciate you, Jar. Any closing thoughts, you guys? Remember, 9 a.m. tomorrow, the judge said, we're starting back up. Since we're doing motions, I will try to cover that. Actually, give me 1 second. I'm going to mute my... So Kayla just called, but I think she realizes I'm still on stream and hung up. So let me hop out of here. Any closing thoughts, you guys? Oh, 9 a.m. Friday. Perfect. Thank God. I have so much stuff to catch up on. But I'll see you Friday because we're still talking about motions. So I want to keep covering that stuff. Thank you, guys. Friday. Look at you guys. Oh, I think the Rule 22 motion was, well, two reasons. One, if you want access to something, like maybe she wants to be in there just to take photographs or look at it, see what's going on, pan the camera a certain way. You could do that because Law and Crime is only panning it the way they want to pan it. You could pan it differently. Infamous Sylvia pans her camera a little bit differently than Law and Crime does. So that's one reason. But two, I also think it's an opportunity for, first of all, she got to take a dig today, but nobody counter-argued that they want to call her as a witness in anything today. They could have raised that as an issue. They could have opposed her Rule 22 application if they thought they wanted to call her as a witness. So we found out today that it was Deputy Brown that disclosed the ex parte meeting to Brian Steele, at least initially. And the state, if they wanted to object because they plan to call Kayla as the witness for any reason, which I wouldn't imagine they'd want to do because Kayla, if they looked at her YouTube content, Woody's on good terms with her. So why would they want to do that? But they had the opportunity to raise an objection and say, look, we plan to call her as a witness. How could she also have a Rule 22 application? And they didn't really do that. So I think it was a smart move in that regard. But yeah, thank you guys for the Friday. Friday. And then well worth it for the dig, the stare over at the state's table. No, there are still outstanding mistrial motions. There's actually a supplement filed today by Doug Weinstein. I'll share that one more time, you guys. It is interesting reading, and I know, you could hear me read the transcript, but looking at it with your own eyes, you could see different stuff. So that Google Drive link in the chat is the new supplement filed by Doug Weinstein this morning, with the transcript as an exhibit at the end for the June 7th meeting. So check that out, do some reading, see if you notice anything differently. Wait, Deputy Brown is also, no, I don't think so. Come on. He's live update tweets. That would be a plot twist. I don't think so at all. But yeah, you guys all have a good one until, I guess, Friday morning as far as live coverage of future motion streams. Any documents, probably would do a video, but maybe go live if they're more than a couple pages long. So maybe see you soon. Maybe see you Friday. Thanks so much, everybody, for all your support. Take care. Have a good one.